I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial daddy.
I want to give a big shout out to the 13 Jury Podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
Every time we run into Phil Barber, you should reach for it. And then I just looked at the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, what's up?
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Hello, jurors. Hello, good morning. Or afternoon, depending on where you're at. Hello. I miss that music. I know, me too. When I hear it, I'm like, yay. It's been 4 or 5 days without it. I needed it. Yay. Hi. Hello. I am so glad to see y'all. Bring the jury, y'all. I'm so glad to see y'all. I missed y'all this week. I have slept so much. But you know, I feel like the best way to heal and feel good is to sleep as much as possible. So, I have been, and it's good. And today, I finished treatment 25. So only 15 to go. I got 3 more weeks, y'all. 3 more weeks. And we are good to go. So I was just messaging the mods. I feel pretty good today, which is good. By the end of the week, it's doing better. Chrissy G, attorney for 6 whole months. 6 whole months. Happy anniversary to you. Happy anniversary to you. I am glad to see y'all. I did go by my post office box a couple times this week when I was leaving treatment. And I'm going to do, a separate little video thing. I'll just do a little short to show some of that stuff, because y'all are very generous and I appreciate it so much. But I wanted to, I forgot to take pictures, and it's over there on the couch where I opened it, so I don't have pictures to show you. But I got some very thoughtful, and Lucy got some very, very thoughtful gifts, and I really appreciate it. So I'm going to do a separate little short video or something so I can show y'all that. But I do have this right here, though. I will show you this. This is part of it. This is part of what's to come. Lucy got a panda costume, and I have not had a chance to put it on her yet, but it's coming. This is going to be our Friday night. Me and Lucy this is going to be our Friday night. I'm going to dress her in her panda costume, and oh my God, so cute. And she got a handmade quilt. So I'm going to do a little short video and show y'all. It was very sweet. And also, Kathy Davidson, if you're in here, this is the best chapstick I've ever had in my life. My lips stay chapped, I try not to get dehydrated, but man, they stay chapped, and that stuff is so good. All right, so I cannot wait for the panda thing. That's why I have to do a whole separate video, because I want to show the stuff that was sent, but also I know everybody's going to want to see Lucy in the panda costume. So it's my 2 favorite things, Lucy and pandas. So too cute. She has her little handmade quilt that has her name on it. I have it sitting on my desk right now, so she's laying on her little quilt on my desk. So too cute. So very, very sweet, very thoughtful. Y'all are so good. Y'all spoil me. I appreciate it so much more than you could even know. Karina says, what type of chapstick? My lips are always chapped. Look, mine are always chapped too. And Kathy Davidson sent me this. It's EOS Dry Lip Repair. This stuff is so good. So good. So rescue treatment. This is not for you. Lucy's up sniffing it like, is that for me? Is that for me? She thinks everything's for her. But yeah, that stuff is so good. So good. Sandra Oliver, thank you for the super chat. Brandi, you look marvelous. Thank you. I feel good today. I love the days when I feel good. So, today will be the first day all week I have not taken a nap yet. The day is young. I might still take one, but by the time we finish here, probably I'm going to put Lucy in her panda costume, and then we'll probably go to bed early tonight. But I feel good today. I feel good. There was no court on Tuesday. So because of snow, so all we've got is Wednesday, Thursday, and today. So the plan is, everybody's been loving the weekend court catch up, speed trialing, and that's been working really good for me since it's, weekdays have been getting progressively harder. So what we'll do is, I'm going to do, Wednesday's court today, and then we'll do Thursday tomorrow, and then we'll do today's court on Sunday. So that way we can get all 3 days done and be caught up over the weekend. Also, I heard they said that the prosecution is planning on ending their case like maybe Tuesday. And then the defense said that they're going to take about 4 or 5 days, I think. So we could potentially be in verdict watch by maybe not next week, but the week after, early the week after. So that's awesome. Pilolo's mom, Friday Express, Best Queen Mods family. Thank you so much. Thank you for the super chat. Thank you. I appreciate it. Regina Crawford, I miss you too, Regina Crawford. Thank you for the super chat. I miss y'all. I'm very glad to be here. And Tina, thank you so much for the super chat. Brandi, you look great today. I've missed everyone. I've missed y'all too. I really do. I miss y'all. I miss y'all when we're not here, when we don't get to hang out every day. I do enjoy the weekend thing. It's been fun, but I do miss y'all during the week when I'm awake. Hello 80s. Hello. Good to see you. Okay, I've got our trial pulled up. Now, I do know, I have not watched it, but I do know that Wednesday's court was, there was more arguing by the defense. Shocker, right? We're all surprised. I do know that there was more arguing than there was actual testimony. So we'll listen to the arguments. We'll go through it. If it gets to be to the point where it's affecting our blood pressure and our anger issues, then, we might skip through some of the arguing. Apparently it gets pretty repetitive. But Wednesday was apparently a big defense argument day. So we will see how it goes getting through this. So it'll be interesting. It'll be interesting. Mermaid Mary B, happy first birthday to my youngest pup, Garth. Aw, happy birthday, Garth. Thank you for the super chat. Mermaid Mary B, I appreciate it. Thank you. And Garth, happy first birthday. Happy first birthday. Oops, it's moving. And thank you for the super chat. Thank you. I appreciate it. I'm glad to see y'all here. Hey, Shireen, hello. Welcome to those of y'all still coming in, joining us. Hello. All right, y'all ready to get this show on the road? Let's get it going. I think I have it set for 1.25.
To make this easier for the court, it would not be our intention.
No, it's 1.5. Okay, let's do a poll real quick because this is going to be the arguing. Oh, gosh, the arguing. Defense argument speed. All right, do you want to do 1.25 or 1.5? We'll do a poll real quick.
With any witness that's coming in to talk about anything that was said by the children or anything about their health or what their therapists were saying or not saying, that was an area that, even if it might become relevant, we have no intention of delving into. So that's the easy part of dealing with Mr. Meehan's or Attorney Paoletti's concern.
Okay, so Meehan, I did look into this a little bit. So what they're arguing about, just because this starts kind of like as they're already going, because they started earlier that day. So as they're starting, the prosecution wants the guardian ad litem that was hired for the divorce between Jennifer and Fotis to basically come in and say he's lying, about how things were going so well for him, in the case and all that stuff that we had heard. They're wanting him to come in and say, no, that's not what was really happening. So there's all these arguments about this now. So we're gonna, and what the guardian ad litem is going to be allowed to say and not allowed to say and all that.
Or conversations that the children had with Mr. Meehan, again, not relevant. But without being able to get into either what happened in this report, the fact that Mr. Dulos in Mr. Meehan's office read the report with his lawyer, Mike Rose, they talked about it. There's already in the material, the forensic download, the Celebrite report, a fair amount of conversation between Mr. Dulos and his lawyer about how great things are going and what we're going to do now, et cetera, et cetera. So that hasn't been presented to the jury, but it's in as part of the report that was provided by the state. So then we get into, well, what's happening in the month before the disappearance of Jennifer Dulos? I don't know how the state could say, well, we won't talk about what happened, we'll just put in some observations of the reaction, where I'm precluded by virtue of the court's prior ruling of getting into what was happening during the course of this hearing. It's my understanding that Dr. Herman wanted to be paid, and neither the lawyer for Mrs. Dulos or Mr. Dulos were willing to pay him until he finished his testimony. So that's a financial dispute that has absolutely, again, nothing to do with my client, and I would argue really has nothing to do with Mr. Dulos either if he were on trial. The fact that there was some apparent conversation between Dr. Herman and the lawyers is neither here nor there. But if we're going to get into any of these court orders, I would have to then get into the background of it, because it had nothing to do with Michelle. She was absolutely not only innocent, but had no involvement or no issue with either her or her daughter as to why the court required that Mr. Dulos have, absent Miss Troconis and her 12-year-old daughter at the time, from interaction with the Dulos children during visitation. Again, I don't know how to get into that, how we can address that without getting into the underlying custody. And it certainly doesn't go to my client's state of mind under any circumstances. And I would submit that in the absence of Mr. Dulos, you couldn't get into his state of mind as to how he reacted to that. It was complied with. In other words, there was no sneaking behind, surreptitious visits with the children. That order went into effect at some point. And it is something that the state certainly has to prove my client's state of mind, her intent. And if we can't even get into it and that she had nothing to do with it, and the reasons why it was entered into, again, puts us in a decided disadvantage. I can't cross-examine based on simply the fact that there's this order, and we can't get into where it came from and why and how it was elicited, et cetera, et cetera. That raises the second question about the actual report itself. Now, it's our intention to not put in the 88-page report, but it would be our intention, and there's an order by Judge Lowy from, I think, 2020 or 2021, I have it someplace, that gave me the report. It was just the state's had it since 2019. The police obtained it. The state had it, and it was order disclosed to me, but with an order attached that it was not to be otherwise provided unless in the absence of a court order. So it's in my possession, it's in Attorney Felson's possession, but nobody else's possession. But we intended to put in at least the conclusions as part in a cover sheet from Dr. Herman to show that this is what the orders were going forward. And the fact that there was dispute about that in a sealed proceeding, which we're apparently not allowed to get into pursuant to this court's order. The state wants to suggest that, well, it wasn't going the way that Mr. Dulos wanted it to go. But again, how do you do that without getting into what's actually happened in the sealed proceeding? I mean, how?
Okay, so the sealed proceeding is the custody report has been sealed. So, which actually I heard about the drama from yesterday where this is not really a spoiler alert, but I think it's something to one of the perks of speed trialing this is we kind of know what happened. This sealed report and sealed proceeding for the custody, apparently Michelle had it pulled up on the laptop in like big font yesterday during court so that people in the gallery and the photographer and all these people behind her could see it, and that's not allowed because it's sealed. So they're having all of these arguments over that sealed document for the custody report in the case between Jennifer and Fotis.
How can somebody testify that they went into this proceeding and there was something that happened that we don't know about or we can't talk about, but at the end of it, Mr. Dulos seemed sad or he seemed despondent, he seemed angry, whatever it is that's going to be testified to, the way I hear, and that's why we would need a hearing on it. But my concern is it paints an incomplete picture. But more importantly, it's particularly unfair to my client because she knew nothing about any of that. She wasn't at that hearing. The only people apparently that were at that hearing were Mr. Dulos, Mrs. Dulos, and their lawyers, and Mr. Meehan, and maybe the judge, clerk, and a court reporter. Well, I know there was a court reporter because I couldn't get that transcript.
Well, the court is not persuaded that the history of the dissolution proceeding is relevant. There's already been testimony that there was a dissolution proceeding pending. There's already been testimony that Michelle Troconis was not allowed to be in the presence of the 5 minor children. The court sees the scope of the offer by the state to focus on Fotis Dulos' response to the report. There's already been testimony that there was supervised visitation. The jury is not unaware of the necessity, based on the testimony of the social worker, of the reasons for supervised visitation. The testimony was that he was not allowed to be in the house. He was not allowed to be out of her sight. So there's already the strong inference that there is a concern. So the necessity of testimony concerning whether Michelle Troconis could be in the presence of the children, in this court's view, is not relevant. What's relevant, according to the state's offer, is whether, first of all, Attorney Meehan had any conversations or was in the presence with of Fotis Dulos, and Fotis Dulos' response to the report, or his response, if there is any, to the fact that there was supervised visitation.
If I may just address a few things, Your Honor. With respect to one of the other aspects the state wanted to just reiterate is the phone call that Attorney Meehan had with Michelle Troconis in March of 2021 and Fotis Dulos as well. He spoke to both of them, and it was very apparent on that conversation, he will testify to this, that Fotis indicated that Michelle Troconis was going to leave him because of he was scared she was going to leave him because of the strain of this divorce proceeding and custody hearing. What I just wanted to just clarify with respect to the Dr. Herman report and the fact that he indicated he didn't get paid by Mr. Dulos for his testimony, he never returned. So Judge Heller, he never returned to be cross-examined. He never came back to court. Judge Heller ruled that that entire custody report was sealed and that his testimony was sealed because he refused to return when he didn't get paid. So the idea to put any kind of emphasis on the state's view or the defense view on that day and that custody report, it is completely useless because Judge Heller ruled it so. And that's where the state feels that that is why it shouldn't come in the state's view. It shouldn't come in cross-examination. The report wasn't subject to any kind of scrutiny or cross-examination because Dr. Herman refused to come back. It has already been a judicial determination on that report, and in the state's view, it's completely irrelevant. The time and length of this process, of the arduous, restrictions on Mr. Troconis, on Fotis Dulos, and the fact that it culminated in March in a phone call to the GAL from the defendant and Fotis Dulos, expressing what can only be described as their desperation for this to end, then the idea that it didn't end is very important. So that's why the state is very clear with respect to the hearing on the family side for the sealed order as well as the actual report. It is not something that should come in by either party.
Your Honor, I'm a little bit surprised because it sounds to me that Ms. Manning is in possession somehow of the contents of what happened in those sealed proceedings, because all I know is there was an email sent to Mr. Rose, to Attorney Rose, saying, I want to be paid before I return. This notion that he refused to come back or what Judge Heller did in that sealed hearing is news to me, and I don't know how she knows that, but I certainly don't know that. So I also find that I'm at its further disadvantage because it looks like the state has those documents that the court has precluded me from having. I'm wondering if the state will admit that they have access to the contents of what happened at those hearings, because I sure as heck don't.
Excuse me, Your Honor.
First, before we even proceed,
can I just address
that the discussions of the dissolution hearings in this court's view, any evidence of the dissolution hearings are not relevant. Any discussion of what happened at any dissolution proceeding, not relevant. What the court finds relevant for the state's case is the following, and the jury can draw any logical inference that it wishes. When did supervised visitation go into effect? And what was Fotis Dulos' response to supervised visitation? What was his response to the report?
Happy anniversary, Jamie.
Should be that narrow.
He said, I sure as hell
Otherwise,
don't.
we get into collateral matters concerning what happened in a dissolution proceeding, which then may lead to, well, what orders were entered? concerning custody, visitation, alimony, child support. Not relevant. So what the court will do is grant or it's already granted the amended motion for order, but also grant the third-party witness protective order with the following conditions. Any fact which may negatively impact the minor children in the matter of Jennifer Dulos versus Fotis Dulos will be prohibited. Any fact involving the minor children in the matter of Jennifer Dulos versus Fotis Dulos, which is subject to state or federal laws of confidentiality, prohibited. Any fact involving the minor children in the matter of Jennifer Dulos versus Fotis Dulos, which is subject to state or federal statutory privilege, prohibited. Any fact involving the minor children in the matter of Jennifer Dulos versus Fotis Dulos, which is subject to a court sealing order, prohibited. We also have to take up, outside of the presence of the jury, the motion to suppress the defendant's cell phone. Now, this motion has been the subject of a previous motion to suppress. So in order for the record again to be clear, this court granted the defendant's motion to suppress the warrantless seizure of her cell phone.
Okay, so remember we talked about this before. Her phone, they seized it without a warrant. So they've done multiple pretrial hearings and motions about this specific information, and it was granted that because it was done without a warrant that it wasn't going to come in. So I didn't even know that they were going to talk about this again today, so we'll see what they say. Oh, Jen Devka, happy anniversary.
The state was able to obtain a warrant for that cell phone. So before we even proceed with argument, Attorney McGinnis, what the court is going to do is this. Of course, the court has made factual findings concerning suppression motions from property seized at 4 Jefferson Crossing in Farmington, Connecticut. The court is not going to entertain a hearing, an evidentiary hearing, where those facts, again, have to be elicited. So the court would just put on the record the facts that have already been found. And the court is just going to refer to its memorandum of decision first on October 2nd, 2023.
I'm terribly sorry to interrupt. I just want to be very clear about what this motion encompasses. The state is not seeking to introduce evidence of the defendant's cellular phone or its contents. What this motion has to do with is called detail records, Your Honor, from AT&T, the defendant's provider. In other words, we're not asking that the court revisit its motion on the warrantless seizure of the cell phone. This is an entirely separate motion with respect to AT&T providing records.
Oh, okay.
So I just didn't want the court to have to read.
Okay, so instead of they're not arguing because it's already been decided by the court. They're not arguing for like the Celebrite or anything that was gathered from the phone. These are records that they did get a warrant for, and they subpoenaed her phone company, and the phone company returned it back. So it's not the same as what would have been received just from her phone. This didn't come from her phone. This came from her cell phone company.
Read that into the record because I just want to be very clear that that is not something that we're seeking to elicit. If I could just, because it is the defendant's burden in my view in this motion, so I just wanted to be very clear. In 2019, on May 27th, the New Canaan Police Department executed a search warrant on AT&T for the defendant's CVR records to include outgoing, incoming calls, SMS messages, things of that nature, as well as cell site location information. In 2023, the state did a new search warrant for some of the same records, some new records related to the defendant's AT&T provider. And on December 6th, the defendant had an outstanding motion to suppress the 2019 records. And I indicated to the court that I was in agreement that that warrant wasn't supported by probable cause, and we had done a new warrant in the interim, and it would be those records we'd be seeking to introduce. So I just...
Okay, they're saying that the search warrant that was signed, the original search warrant that was signed and their stuff was gathered without probable cause, which is why it was thrown out. So...
I just want the record to be clear. We are not asking the court to revisit any findings from the warrant seizure of the phone. This is entirely separate. It deals with her CDR records.
So, Attorney McGinnis, would not the facts concerning the memorandum, rather the motion to suppress property from 4 Jefferson Crossing, also be included in that subsequent warrant? In other words, aren't the facts that the court found in its October 2nd memorandum of decision some of the same facts that are going to be included in the affidavit for the subsequent warrant?
I can't recall specifically the findings that the court made. I mean, I can provide a copy of the 2023 affidavit to the court if you would like to see a copy of that.
The court has a copy, and the court was under the impression that because some of the facts are the same, that it would not be a judicious use of time for there to be litigation about those same facts.
Well, I certainly agree with that, but I don't think that the court, quite frankly, needs to make any factual findings or have an evidentiary hearing in the first instance because this was a search that was done pursuant to a warrant. I'll be heard on that at the appropriate time, but I don't think that the court needs to have a traditional evidentiary hearing because obviously the only way for a defendant to get an evidentiary hearing when they're challenging a warrant is through a Frank's claim, which they've made, and I'll be heard on that at the appropriate time as well. But I didn't want to interrupt the court, but we are not asking the court to revisit its memorandum from warrant procedure.
Just, again, I agree with the fact of what Mr. McGinnis said. That is not about the warrant procedure of the phone. What this is, however, is about, and I believe that Mr. McGinnis has just not given the full picture to Your Honor. On May 27, 2019, there was a search warrant signed by Judge Blowy for this CDR, for the location data from AT&T from my client's family, not just her phone. There was some testimony about that, so the court would have to at least look back at that testimony from that hearing. However, the motion to suppress, which was granted by this court, and I think it's the 6th of December, 2023, was a motion dated March 16, 2020, to suppress the AT&T data. On the date of December 6th, this was a remote hearing, if I'm not mistaken, Mr. McGinnis stated to Your Honor, we agree that the May 27, 2019 warrant was issued without probable cause. And the state's position was the court did not need to then rule on it, but the court said, no, based on that, I'm going to suppress that evidence from the warrant. Now, Mr. McGinnis just says that he mentioned at that time, well, they applied for another warrant. I don't believe that was ever mentioned to Your Honor, ever. So we start with that as an issue because I know that at one point, Ms. Manning said they were going to apply for another warrant, just like they said they were going to apply and did obtain another DNA warrant for my client in 2023 because I assume they thought it was possible the court would find there wasn't probable cause to take her DNA back in 2019. But since Your Honor didn't grant that motion, I didn't argue it to the court because it was kind of moot at that point. The DNA didn't change between 2019 and 2023. But it's important to note, Your Honor, that this motion, that this warrant, although applied to, went to Judge Golger. And the thing that's more concerning is they checked the box that said that this warrant was not presented to any other judge. Or this, and I assume they're trying to claim that. So if you look at, I attached a copy of the of their warrant, and I think it's page 9. I think it says the undersigned has not presented his application in any other court or to any other judge. So their position is, well, because it was different affiance, they can misrepresent the truth and say, oh no, we're applying for this for the first time, and check the box. But if Your Honor looks at my motion, not only is this not just a facial challenge, but we would have to hear why they would falsely tell Judge Golger that it was not submitted to another judge. And if they're going to try and argue, which I would then refute and cross-examination, that, well, we were not the affiance, that was some other affiant. Even though we're all working together on one case, it wasn't me personally, so I could swear under oath that this affiant didn't submit it to another judge. And I would just point out that I would argue that if not an outright falsehood, under oath is a deliberate reckless and or reckless disregard of the truth. But finally, I do make some of the same arguments about its overbreadth, the lack of specificity, and all this stuff, which the court didn't have to rule on because the state conceded that the original warrant lacked probable cause. So here we are in the middle of a trial. I get a copy of the fact at, again, the end of December with a new document and discovery dump, literally on the eve of New Year's Eve, that now has the renewed CDR material. But the more important key aspect here, Your Honor, is that my research has shown that AT&T only keeps this data for 13 months. So that would have been erased sometime by mid-2020. So they have a burden now to show that this is an independent source that would not otherwise have been destroyed. What I think they did is since we didn't get a hearing on my motion until December of 2023, they applied a month or so earlier, maybe a month and a half or so earlier, getting those records. Didn't, to my recollection at least, did not mention, oh, we got it again, so we don't care. I don't believe they said that, Your Honor. I can go back and look at a transcript, but I don't believe that Your Honor was made aware of that fact. And therefore, they have the burden of showing that this evidence that they obtained was in fact independent of the tainted, suppressed evidence that Your Honor granted on December 6, 2023.
Tainted.
So that's just, this is not my argument yet, it's to point out the
Real quick, Lady Lever, thank you so much. Gifted 10 memberships. Thank you so much. I appreciate it.
distinction, just to make sure that Your Honor is aware of what the record now is, where we are on this issue.
Attorney McGinnis.
Well, I was going to wait for his argument, Judge, because obviously it's my position that they have a burden. But I guess I do need to clear this up. I was hoping that Attorney Schoenborn would simply accept my representation that I did, in fact, inform the court. But I did get a copy of the transcript just on the off chance that he didn't. So I'd like to read to the court what I actually said and what the court said.
Uh-oh.
And this is from the December 6th transcript. Attorney Schoenborn begins his argument on why he felt the 2019 warrant should be suppressed. And then I jump in and I say, if I could actually maybe short circuit this, Judge. The court, yes. Attorney McGinnis, just with respect to the March 16, 2020 motion, which as I understand it, deals with CDR records which were searched and seized in May of 2019. And so if that's the scope of the motion to suppress, what I can indicate to the court is that the state at this time has no intention of introducing evidence from those cell phone records from that particular seizure, because we agree with the defense that the search warrant did not set forth sufficient probable cause. However, we did do a subsequent, and you'll recall, Judge, I kept dropping footnotes in my memorandums indicating please pretend that this information doesn't exist because I didn't want it to influence the court's decision on any of the other motions, so we wouldn't have to go back and revisit it. But we did do a subsequent search warrant for those same records, which was disclosed to the defense. And those records were seized, I want to say, in October or November, but probably October, and those were disclosed to the defense. They're mostly duplicative of the records that were seized back in 2019, but it would be those records which we would be seeking to introduce with a new warrant, which we believe does set forth sufficient probable cause. The court, thank you. So as the court understands the state's stance, there's no objection to the granting of the motion to suppress on that which was seized in 2019 concerning AT&T records. Is that correct? Attorney McGinnis, yeah, I mean, we don't have an objection to that, Judge. We have no intention of introducing it, so I don't know if it's mooted out by that, but in any event, no. I mean, certainly I don't believe that that warrant established sufficient probable cause, and so I would know, however, the court wants to handle it, whether it wants to officially grant the motion, or, by virtue of our representation, we have no intention of introducing those records. Either way is fine. The court, well, it appears to make a clean record for the court just to grant the motion. Attorney McGinnis, sure. So, when Attorney
Okay, so all of that basically shows that Shoehorn was wrong when he just said that he was never, that they were never told about the new search warrant, because he just read it that they definitely were.
Shoehorn stands here and says that the state somehow kept this information from the court, which I did see in his motion. I was hoping that he would walk it back today. That is completely contradicted by the record. I did inform the court that we had done a subsequent search warrant, and it would be those records which we would be seeking to introduce. And I also just want to correct the record on one other thing before he gets into his argument, which is that we turned over these records to the defense in November. They were picked up on November 16th by Audrey Felsen, one of the defense counsel in this case. And I said it on the record on December 6th. So this idea that he didn't know until January 2nd, Judge, I don't know where he's getting that from, because he was part of this exact same hearing. And again, I'm not trying to cast aspersions, because I think the four of us would agree that there's a lot going on in this case, but I just want the court to be assured that I did not withhold this information from the court. I did alert the court, and if we can now move on to the actual substance of the motion, I'd like to be heard, because I think that, frankly, the court should deny their motion to suppress.
Well, let me just correct that. He's correct. I looked at my notes. I didn't order this transcript, so he did say that on the record. So I do want to correct that he is that I misspoke when I said he didn't bring it up to the court. But the fact that just Your Honor understands, in November, what we were given is a 5 or 8 terabyte external drive that had thousands and thousands of documents, including the same material that had previously been given. It wasn't separate. Oh, here's the new set of records that are separately being sought to be brought in. It was not until I was given a report by their expert, which included the GPS information again, and that was right after Christmas, December 29th, I believe, that I realized that they were now going to again introduce these records. So I filed my motion. I know, by the way, there's a typo in the title of my January 8th motion. It says 2024 search warrant. It should say 2023. So I just want the record to reflect that I misstated the date of the warrant.
And Judge, just to be clear, we gave this to them in November, not the end of December. And this discovery that we provided to them is not terribly large, just from my review of it. I think we basically gave it to them twice. Once we gave it to them in November, then we gave it to them again at the end of December. So, and I said it on December 6th. So I think the claim, and as the defense conceded, Attorney Manning indicated that we would be doing another search warrant before we did it. So this idea of unfair surprise thing, I think is frankly unfounded, Judge. But I'd like to just, after they argue, I'd like to be heard on the substance of the motion, because I think that the court should, in fact, deny it, and we should be permitted to introduce the records that were seized in 2023.
Thank you. The court will hear from the defense on the motion to suppress the CDR records pursuant to the warrant.
Well, they're essentially, and first of all, I don't think, I'm looking at my motion, I don't believe I used the word surprise anywhere in my motion. I'm looking at it right now, and I would note, I've obviously had these records since 2020, since I came in the case sometime in 2020. So nowhere am I claiming I didn't know what the records were, but as of the December 6th ruling, I assumed that this wasn't even going to be an issue, so that I filed this motion in January at the first day of trial after receiving the actual December 29th list of exhibits, if you will, that they intended to use, electronic exhibits, and that's what I'm basing it on, not that I didn't know what the info was. I submit, Your Honor, that my motion is kind of comprehensive when it comes to different issues. Your Honor looks at the warrant itself. It even mentions the seizure of my client's phone in there, which the court had suppressed. They included that as part of their probable cause determination, but I submit that nothing in the affidavit itself, let's assume it was the first time they did this. Let's assume it was the first time they did it. Nowhere in there does it establish that my client engaged in any phone calls, text messages, or anything for that matter that would entitle to the state to go through any of that material. Even this new 2023 warrant affidavit does not do that or examine, other than the same argument they made at the hearing where the court suppressed the phone. They would like to have this stuff because there's always information that's in there. So that argument was previously made. The state simply agreed. So I'm just going to incorporate the December 6th arguments with regard to the affidavit, so I don't have to restate that. But there are other issues here that are concerning to me. And the most important one is the fact that they checked the box saying it was not presented to another, this affidavit. The undersigned has not presented this application in any other court or to any other judge or judge trial referee. And that, in this case, it's signed by Nicholas Olivetti and Detective Jessica Janescu, who in paragraph 1 state they are part of the Western District Major Crime Squad. What's interesting about that is we now know, and we have testimony, that the Western District Major Crime Squad was involved in this investigation from at least May 25th forward. So therefore, whether or not the original warrant was signed by 2 New Canaan police officers, and now it's signed by 2 officers or detectives from the Western District Major Crime Squad, is neither here nor there, for the simple reason that it's a joint investigation, and there's the presumption that the knowledge of one, the collective knowledge doctrine would clearly apply here. It's not like they simply sent 2 detectives in and say, gee, you don't know anything about it, why don't you apply for a warrant for this phone and pretend that nothing else exists, because they obviously had that tainted information at the time that they applied for this warrant. So we start with that. They stated to Judge Golder, and I submit, Your Honor, that the whole reason that this is in these judicial forms is to alert the judge that another warrant was applied for, that another warrant was suppressed, and yet we're going to another judge. And I'll note, this is the 3rd time, I'll just say it on record, 3rd time that the state did this. The first time they did it involved after the death, and again, I have not made this an issue, but Your Honor needs to be aware, when Mr. Dulos committed suicide or attempted suicide in his house in Farmington, 2 affiants from the Farmington Police Department sought a warrant to search the house for evidence of a murder. That warrant was presented by Farmington Police with, as I understand it, in consultation with the state police to a judge in Hartford. The presiding judge at the time was, it doesn't matter, but the judge in Hartford. That judge declined to sign that warrant, refused. This was now 6 months, 7 months later, refused. So what did the law enforcement do? The state police represented it with different affiants, went down here with and went to Judge Hernandez.
Object at this point to this, and I know it's highly unusual to object during an argument to the court, but this is really getting far afield from the issues here. And frankly, it's
Your Honor, I'd like to
untrue
finish because I'm putting on evidence of misconduct. It's not the first time, and that's why I'm putting this
It's
on.
untrue, however, that Detective Kimball and Ventress.
Shoehorn is now accusing the prosecution of basically of misconduct, or by the state, I guess, because that would include the going to the different judge and all that. So he's claiming misconduct.
Nebraska were part of that initial search warrant in Hartford, and we've.
Well, what the court has to do.
Oh, they're mad.
Is first of all be alert to the arguments of counsel. When the court determines that the arguments of counsel are going far afield, then the court has to interject.
Yes, Judge.
What happened in Hartford may be of interest to the defense, but it does not hold sway with this court as to what it has to do in this case.
Well, it's the same. It's this case, Your Honor. I'm talking about the fact that 2 state police affiants went to Judge Hernandez, who rejected the warrant because those boxes weren't checked. And it was Detective Butin and someone else who then checked the box saying this has not been presented to any other judge.
Well, the argument you're making, counsel, is that this has been done before. But whether it has been done before is not pertinent to what the court has to do under this set of facts.
I agree. And I'll limit the purpose, though, was to show there's a reason why there's that page inside a warrant, that it's to alert a judge to make sure they are not signing something that has already been ruled on in the case. And so the first thing that the state would have to prove is how they avoided that, what they did to inform Judge Golger that this is the first time it's being presented. Essentially, I think that's the reason for this, this to prevent judge shopping. That's the reason for this. So we have that. And then I did some research. The state's also going to have to prove that these records existed, because if you go to...
Okay, so he's saying, he just used the term judge shopping. He's saying that it was wrong for them to submit the warrant for a judge, and the judge denied it, and it was submitted to a different judge, and the other, like as if it were new and one judge hadn't already denied it, and it was approved by the second judge that it was submitted to. So he said that they were judge shopping trying to get this warrant.
And as I said, I don't have this burden. The state has the burden of showing where they got their evidence and that it was properly obtained. And I've already refused to agree to an affidavit from a records keeper, which is not the law in Connecticut. But these records would have been destroyed, or at least most of them would have been destroyed within 13 months of their creation in 2019. And the state's got the burden not only of proof, but that these records, in fact, would have existed outside of the fact that they had obtained them by virtue of a illegal, unconstitutional search, because it does involve privacy rights, and it does involve not only the Connecticut Constitution and the Fourth Amendment, which I cite, but it also cites the the Federal Electronic Records Act, that's 18 U.S.C. Section 2510. But and finally, Your Honor, I note that I did cite there's a recent Second Circuit case which asked the court to look at, United States versus Loria. It's in 70 F 4th 106. It specifically says that if a warrant is applied for, and if a defendant makes a motion to suppress, pointing out the defects in the warrant, then the government, in that case it's a federal case, cannot go get another warrant and argue either independent source or inevitable discovery. The Second Circuit as recently as this past year said that the Fourth Amendment does not permit that, because once a defendant points out the deficiency, they cannot simply turn around and get another warrant. So the burden is not on the defense to show, because they could just, why not while we're talking, go get another warrant, and then I have to keep arguing ad nauseum, and it becomes my burden once again. So I submit to the court that the state has the burden, not only, I would have the burden if all we were dealing with was whether this warrant suggests probable cause or allows probable cause. And under both the Riley and Carpenter, the Galfin and the Mordowinitz case, Mordowinec, it does not. But be that as it may, there are all these other issues that they have the burden before any evidence comes in. It's tainted evidence, regardless of the fact that they applied for the warrant, regardless of the fact that they, in my view at least, recklessly disregarded the truth when they told Judge Golger that this has not been presented in any other court or to any other judge.
Good morning, Judge. What a romantic way to spend Valentine's Day. Judge, no surprises. I disagree with just about everything that the defense said. I want to begin with this issue of the state somehow has a burden of proof of showing that these records would have existed but for the previous illegal search. The defense is absolutely wrong on that. And you'll recall, Judge, that we went around the block on that a few times when we were talking about the reasonableness of the execution of the search warrant. And one of the things that I pointed out to the court at that time, and I'll reiterate to the court now, is that it is actually the defense that bears the burden, the initial burden of proof of showing that there is a causal connection between the illegality and the evidence which is seized. And that comes directly from Wong Sung, which is the United States Supreme Court case dealing with the fruit of the poisonous tree. Specifically, the defendant must establish the incriminating evidence, quote, would not have come to light but for the illegal seizure. So it's untrue to suggest that the state somehow has to prove that these records would have still been in existence. It's actually the defendant's burden to show that they would not have remained in existence. And I'll also direct the court to United States versus Oro, 2022, Westlaw 18155-665. Defendant bears burden of proving execution of search warrant was unreasonable and suppression not appropriate where there is no causal connection between the unreasonable conduct and the items ultimately seized. There's a couple of other cases, Your Honor, that stand for that very proposition. But Mr. Schoenhorn is simply standing in front of the court and saying because of his research, they would have been erased after 13 months. Two things on that, Judge. One is that our research shows that AT&T holds these records for 5 years. However, they don't hold all the records for 5 years. So, for example, we lost something known as NILO data, which is essentially the phone giving a handshake with the particular cell phone tower to give location data. But it's actually the defendant that bears the burden of proof with respect to that, and they failed to meet their burden today because the evidence actually is that AT&T holds these records as a matter of course for 5 years. So that's
okay. So this is part of what he's arguing now. So Schoenhorn is saying that when they got the data originally, it was from a warrant that an improper warrant or didn't have a warrant or whatever it was. So they said that data would not have been allowed. And then he said then they went and got a warrant, and Schoenhorn is saying they wouldn't have even been able to, by the time they got the warrant that was actually approved, that information that they had would have been already gone, because he said according to his research it only lasts for 13 months. And McGinnis is saying that's, his research is not the same as my research. My research says that most of it they keep for 5 years, so they would have still had this.
point number one. But we didn't have to prove that. They had to prove that they don't. So that's point number one. And I'll just pick it up there. But I want to also indicate that there are 6 other reasons why this court should deny the defendant's instant motion to suppress.
Oh, 6 reasons.
First,
Let's hear 'em.
the defendant's failure to raise this motion sooner should be considered a waiver by this court. Now, under 41.4 of the practice book, if a party doesn't raise a motion to suppress in a timely manner, absent good cause, the court should deem their failure to do so a waiver. So just to address some of the specifics in their motion, the defendant writes that she was unaware of the fact that the state had done a separate search warrant for her CSLI records until January 2nd. However, that is simply untrue. We turned over a copy of the warrant and a copy of the records in November to the defense when we were still very much having motions to suppress. Additionally, the defendant writes in the motion, we've covered this a little bit, that the state withheld this information from the court on December 6th during the hearing. That is simply untrue, and I've already read you a copy of the transcript. So obviously, the defense was on notice of the fact that we were going to be introducing these records, and despite that fact, they didn't file their motion to suppress until, I believe, January 8th, or the day that we were originally slated to start trial. So I personally think that at this point, it should be considered a waiver by the court because they haven't shown any good cause as to why they didn't raise this issue sooner. Second, the defendant has no reasonable expectation of privacy in subscriber information or her toll records, nor does she have standing to assert that somehow a violation of her family's rights, which I don't even know how we get there, that she would somehow have standing. So
can the court just not interrupt, but just clarify?
The court can interrupt.
The court, on a previous occasion, denied a motion to suppress information gained from a tower dump.
That's correct.
This was not the argument that was made for that matter, but essentially, there's no expectation of privacy in a tower dump. Is this essentially that argument?
Not exactly, Judge, because a tower dump, and you recall this when we argued it, a tower dump is a little bit distinct from somebody's individual CSLI records, their individual location records, because a tower dump obviously is simply a data download of any phone that hit that particular tower, whereas here, they're actually pulling the defendant's specific CSLI records. And under Carpenter, if it's beyond a week, a defendant does have a reasonable expectation of privacy in those records. But that is separate and distinct from the fact that a phone call was made, the fact that a text message was received, the duration of the call. Those are just traditional toll records. And under Maryland versus Smith, 442 U.S. 735, there is no reasonable expectation of privacy in such records, nor is there a reasonable expectation of privacy in subscriber information, which incidentally didn't even belong to the defendant. It belonged to her mother and was obviously conveyed to a third party, being the phone company. So I think we also need to parse out their motion because, quite frankly, I think with respect to that stuff, the court shouldn't do a really long analysis of that because obviously there's no reasonable expectation of privacy with respect to the toll records. But if we get to the issue of was there probable cause for the cell site location information for the defendant, I would argue to the court that with respect to that, the current warrant is supported by probable cause and particularity, and the defendant has failed to meet their burden of proof. Namely, obviously, the defendant bears the burden of proving that the warrant is insufficient probable cause or not sufficiently particular. And the court knows from our previous litigation and its experience that there is a strong presumption of validity with respect to search warrants. And given the reasonable inferences that can be drawn from this particular search warrant that Judge Holder signed, Judge Holder could have reasonably concluded that the defendant that Jennifer Dulos was assaulted or murdered in her home, that Fotis Dulos and or other persons were responsible for that murder or assault, that the defendant, by accompanying Mr. Dulos to Hartford with bloody clothing, was an active participant in the disposal of evidence relating to that murder and assault, that the defendant had her cellular phone with her at the time of the disposal of that evidence based on the fact that her cellular phone hit a tower in the area. That was information that we got from the tower dump, which the court has previously denied. That this crime involved pre-planning, especially given that the body had never been found, and that the crime involved activity even after the crime as evidenced by the destruction of the evidence. And therefore, the defendant's cell site location information for both the week before and the week after produce a fair probability that evidence relating to the crime would be found, including potential phone calls and text messages and locations. Including potential phone calls and text messages and locations, which might reveal where additional evidence of the crime may be found. And it's a very narrow time frame. Counsel in the motion, it's not just a typo as to the year. Counsel in the motion refers to the previous 2019 warrant when he refers to the scope. And he says that we asked for March 20th, 2019 through a date uncertain. That's untrue. The new search warrant specifies a week before and a week after. And I would just direct the court to State versus Smith, 344 Con 229. They're involved an even longer period. And even though the court ended up granting the motion to suppress for different reasons, namely that they didn't properly link that defendant to the crime, they talked about how that time frame was generally reasonable. And also the data which was sought was reasonable or likely to be reasonable under the Fourth Amendment. And so if you look at what we saw in this new search warrant, we greatly narrowed time frame. Fourth, the defendant is not entitled to a Franks hearing in this case. To begin with, there is no false statement by either of the affidavits. The box which the defendant indicates should not have been checked reads, quote, "The undersigned have not submitted this application to any other court." The plain language of that box, therefore, requires two things. One, that the affidavits are the same, and two, that that specific application has been submitted to a court before. A plain reading of both applications show that, one, the affidavits were different on the first warrant, and two, the application itself is different, both in terms of the amount of data requested and the information provided in the affidavit is.
Okay, so that they got the first warrant was
greater and provides probable cause. Moreover, which of course it was not, for the reasons that the misrepresentation was necessary or
Okay, am I back now? It looks like I'm back.
independent source doctrine. The defendant conflates
Let's see. Okay, is that better? Says YouTube is having issues. I don't know. My little thing just popped up and is giving me a YouTube error. All right, let's see if it's...
Inevitable discovery and independent source. They are not the same thing. And I'll direct the court to State versus Cobb, 251 Con at 338, which describes the difference between the two. Quote, the independent source rule applies only upon proof that, in actual fact, the officers did not obtain the challenged evidence as a result of the primary illegality. The inevitable discovery exception assumes that the evidence was in fact obtained as a consequence of the primary illegality, but is invoked by proof that, hypothetically, if the officers had not engaged in the primary illegality, they would have nevertheless, although in a different manner, have obtained the challenge evidence. Here, we have proven that the independent source doctrine applies. And I would direct the court to State versus Joyce, which I really think is persuasive for this court, Judge, 243 Con 282. And just by way of background, Your Honor, in State versus Joyce, which the court is probably familiar with, the police had conducted a warrantless seizure of the defendant's clothing and subsequently performed a warrantless analysis of that clothing for accelerants. It was an arson case. And the defendant was ultimately convicted. The defendant appealed the warrantless search of his clothing, and the Connecticut Supreme Court found that the police should have sought a warrant in the first instance and reversed his conviction as a result.
Smooth streaming. I don't know what that means. Let me see.
To obtain the evidence. In order for something to be admissible under the independent source doctrine, the warrant must be supported by probable cause derived from sources independent of the illegal entry, and two, the decision to seek the warrant may not be prompted by information gleaned from the illegal conduct. Here, if the court conducts an...
Hold on. Let me see.
Analysis of the search warrant from last year, you will see that there is no mention of the previous results of CSLI from the 2019 warrant. Therefore, it is supported by sources independent of the previous warrant. Second, the decision to pursue this warrant on its face cannot have been prompted by the previous search warrant for two reasons. First, the police had an interest in her CSLI prior to knowing what the results would be, as evidenced by the fact that they initially sought a warrant in 2019 from March 20th through May 27th. Second, the records obtained in the search warrant was not prompted by the 2019 warrant because the records obtained from the data were never previously retrieved. The 2019 warrant ended on May 27th. This warrant goes through May 31st. Third, as illustrated in Joyce, there is nothing improper about the state seeking a subsequent search warrant for the same information if a previous search is constitutionally infirm. And I would argue to the court that here we're on even stronger grounds than Joyce, because in Joyce they conducted a warrantless search, whereas here at least the police did in fact seek an initial search warrant. Sixth, the law of the case doctrine does not apply. The defendant argued in her motion that the law of the case doctrine does not apply. However, this court's suppression on December 6th was limited to the 2019 records, as I just read the transcript. The court did not weigh in on the 2023 records at that time, and the court was very careful when it ruled that it was only granting the motion to suppress with respect to the 2019 records. So I think the law of the case doctrine, quite frankly, is not well-founded at all. The defense gave no case whatsoever to support their position that the collective knowledge doctrine somehow would necessitate the affiants basically misrepresenting to the court that they had personally submitted this exact application before. And just with respect to the evidence of her phone being seized, obviously that was a natural end date for the warrant, because obviously any CSLI after that would have been irrelevant. But I think even if the court were to excise that information from the warrant and its analysis, it would still find that probable cause is sufficient here. I also just want to correct, Judge Hernandez did not reject a warrant for CSLI, to my knowledge. He initially rejected a warrant for DNA. So when defense counsel says that he rejected a warrant for CSLI, that's just not true. And the case relied on by the defense in the federal court, I had a chance to look at it this morning, Judge. Two things on that. One is that, of course, Second Circuit is persuasive authority, but not binding on this court. But number two, that case dealt specifically with inevitable discovery. It did not deal with independent source, and as I've already explained, they're two separate things. Counsel kind of rolled in independent source in the course of his argument, but I did not see that in the case. I'm not saying it's not there, but I just personally did not see that this morning when I looked at it. So I think the inevitable discovery argument, quite frankly, falls on its face because we're arguing that this is an independent source. Does the court have any?
Okay, I'm not sure what's going on with YouTube. It just kicked out almost everybody. We went from however many people we have down to 35 people. It like kicked out everybody. All of my settings show everything's good on my end. It's something with YouTube. YouTube's had so many problems lately. Okay, let's try this again.
Any questions?
No.
Thank you.
Can you give us a moment, please?
Okay.
So weird.
Thank you.
I just want to address at the outset the independent source doctrine. I'm going to give the court three cases, Connecticut cases on the issue. State versus Correa, Correa, 340 Connecticut 619. State versus Degerville, Degourville, 41 Con App 772. And State versus Rogers at 18 Con App 104. When we're talking about the independent source, first of all, as a doctrine, the court in those cases, as in the U.S. Supreme Court case in which they rely, Murray versus United States, 487 U.S. 533, all state that this is that the independent source doctrine is a form of inevitable discovery, although slightly different, but the analysis is the same. All these three cases, however, note that it is the state's burden of proving that the evidence was, quote, genuinely independent, unquote, of the previous unlawfully seized evidence. So to the extent that the independent source doctrine applies, it is the state's burden, not the defense burden, to demonstrate that but for the prior illegality, these documents would not exist. Second, I am flabbergasted, is the way I can only describe it, that the state would actually stand up and have the temerity to tell the court that because these are different affiants, even though they're all working together, that therefore they could swear that it did not get presented. So all they have to do, according to what I heard the state say, is pass it on to a different set of affiants, change the name on it, re-sign it, and go to the judge down the hallway and pretend this is the first time that it's been presented. I find that argument shocking. I find it somewhat absurd, but that's one of the positions that they're taking. And I would assume that any judge in this building, once they discovered that fact, would be, I would think, certainly perturbed, if not outraged, by such argument if it was made in front of them. Be that as it may, Judge. The fact that they resubmitted a warrant after the state came to the conclusion that their previous warrant lacked probable cause still brings us back to the fact that they have the burden of demonstrating that this was an independent source and it was genuinely independent from the illegality. That's simply not the case. Their warrant talks about things that were obtained. Otherwise, it's a do-over. They can basically apply for a warrant, have 5 warrants rejected, just go to, as long as there's more judges, just go to different judges and keep doing it until they find one who will sign without being oblivious to the fact that it had already been rejected, the same information on an almost, I'm not going to say it's the same, it is slightly different warrant affidavit to a different judge. That's, I submit, not an argument that should hold any water with this court. Second of all, going back to their original argument, first of all, phone data such as text messages, phone calls, et cetera, are not part of a cell tower cell dump that we had that hearing on with the expert. So the state saying not exactly is like really saying not at all the same, because the information that they obtained through the second warrant is the personal communications between the defendant, her family, very personal, her daughter, all the things that one has an exact expectation of privacy in. In State versus Smith,
gotta hydrate.
Excuse me. In State versus Smith with the state sites. These are cases I argued to your court back in December, so I want to just incorporate by reference. I don't want to cite all the cases I cited then. I think Brown and Smith were two of the more recent Connecticut Supreme Court cases. There was specific evidence that the defendant used his phone during the course of a crime, and therefore there was probable cause that that specific information from the CDL would be, from the CDR would be relevant to the crime. Here, the state's not even making that argument. The warrant says, well, there's also, half the warrant is about what one might find in general if one goes through the phone service and the phone company. The claim about the family goes to overbreadth. This wasn't even just her unit. It's the entire family plan, which included her mother, I think, again, I don't want to, her daughter and herself. So they got all that information. So that goes to overbreadth. They didn't even say we only want the data as to her phone, but all of those phones. So once again, Your Honor, that just goes to the fact that there would be like a warrant that says we don't just want to search the defendant's house, but in the same warrant, 3 or 4 other locations in the same warrant, just, somewhere among them, maybe we'll find something. So that's the claim I made with regard to the overbreadth of the claim and lacking of particularity. So I submit that one of the problems with this also, if they're going to put this back in, this also requires, as I can see, there are at least 2, if not 4 witnesses that we would have to call back to explain what the nature of or certain communications that my client had during those 2-week period. And I just will note that the state has already submitted substantial evidence by showing where she was in connection with Fotis Dulos. This is kind of cumulative, unnecessary. We've already put in where Dulos was, and we know my client was with him at certain times. So beyond that, I submit that it's not only should be suppressed for the reasons I gave, but from an evidentiary point of view, it's cumulative and unnecessary.
Thank you. First, the court will go over some of the case law concerning the challenge to a validly authorized warrant. If a defendant seeks to challenge the legality of a search warrant or seizure conducted under a properly issued and executed warrant, the defendant has the burden of proving the illegality. A search warrant, or rather a search executed pursuant to a valid warrant, is presumed to be valid. And the defendant challenging that validity has the burden to prove that there was no probable cause supporting the issuance of the warrant, or that the search was otherwise unreasonable. Now, the defense has indicated that it is the state that bears the burden of showing how that independent source developed, or when that independent source developed. The court cannot countenance that hypothesis because it is the defense's burden to challenge and prove that a warrant was not valid. There's no indication in the case law that the burden shifts in a validly executed, a valid search warrant, a burden shifts to the state to show how did it develop that independent source and when. Now, that independent source doctrine, to use a swimming analogy, is like a saving stroke, because it always begins with there was an illegal search by the police, there was an illegal seizure by the police, either because there was no probable cause or it was warrantless. The saving stroke is the independent source doctrine, and that stroke can only be used if whatever the fruits of the illegally seized items were are not infused into the affidavit for the new warrant. And the policy is essentially this. If the police, by way of their own misconduct, occasion an item or information to be suppressed, they have another opportunity if they can get a warrant that doesn't rely on anything derived from the suppressed item or the suppressed data, and that independent source establishes along with other facts, probable cause. And one argument is, well, why should the police have another chance? Well, Connecticut courts have determined that the police get another chance because there's a balance that has to be struck. And the balance is between deterring police misconduct on one hand and allowing a jury to hear all admissible probative evidence on the other hand. In State versus Rogers, that is 18 Connecticut Appellate 104, 1989 case, the police entered the defendant's home without a warrant and secured the premises while a search warrant was being obtained. After obtaining a warrant, the search of the house yielded cocaine and cash. The court in Rogers then articulated the independent source doctrine, which is an exception to the exclusionary rule. And the court held the rule barring, that is the exclusionary rule, the use of illegally obtained evidence does not mean that the facts thus obtained become sacred and inaccessible. If knowledge of them is gained from an independent source, they may be proved like any others. The rationale for the doctrine is that the interest of society in deterring unlawful police conduct and the public interest in having juries receive all probative evidence of a crime are properly balanced by putting the police in the same, not a worse position than they would have been in if no police error or misconduct had occurred. So it's a saving stroke. The court is persuaded by the argument that there's essentially no causal connection between what could be claimed as information gained from a warrant for which there was no probable cause found and the current warrant. The court is also persuaded that there was no false statement. There was no misrepresentation. The affiants were different. The information was augmented in that second warrant. And finally, the filing was untimely. We are in week number 5 of a trial. Typically, in most cases, and counsel are aware of this, there's no 2 or 2.5 month continuance or delay between the start of a trial and the hearings on a motion to suppress. That is what had to occur here. But the argument that, well, the police can keep going back and getting warrants where they failed previously, they would not have time under normal circumstances because the motion to suppress may even be heard right before the jury comes out for the first day of evidence. So the court is persuaded that the filing is untimely. In addition to that, the warrant set forth sufficient probable cause. So the motion to suppress is denied.
May I just put one thing on the record, Your Honor?
Yes.
This warrant was applied for on October 4th, 2023. This trial began on October 7th, 2023, when I believe it was October 7th, the jury selection. No, September, excuse me. I think we had jury selection in September. So therefore, the search warrant was applied for after the trial began. Under the practice book, a motion to suppress is only to be filed before a trial began when the issue arises before a trial. This was not the return on the search warrant, if I'm not mistaken. I don't even know what the return date was on this warrant. But be that as it may, it was certainly after the trial had commenced, and the disclosure to the defendant was in November at the earliest, and so therefore, I would just take issue with the fact that it was, quote, untimely, unquote. They had 5 years to file this motion if they thought there was something wrong with it, but to put it on the defense after the trial starts, that I'm supposed to have filed it in advance of the trial, I think is not a reasonable conclusion. Your other honors ruling, I accept, but I want to just put on the record that I think that finding is not supported by the record in this case, that it was untimely.
Thank you. The court is going to take the morning recess. The state does have witnesses for today. And how many witnesses, Attorney Manning, and who are they?
Your Honor, I have one police officer who should be brief, as well as 2 lay witnesses and Dr. Gill from the medical examiner, which I think we need to address counsel's motion on that matter.
Would Dr. Gill be the last of the witnesses?
I believe so.
So the court will take the opportunity to take a look at the case law that is likely to come up with Dr. Gill's testimony.
And Your Honor, I know the state has indicated that one of the police officers that's going to testify is simply going to say they searched 61 Sturbridge Hill and found nothing. I'm going to argue that that's irrelevant and just using time unnecessarily, and therefore, since it's like the same as everything else that's been presented that shows negative evidence that is immaterial to this case, it's certainly immaterial to my client, and therefore, I ask the court to preclude it.
Well, the court would not know what the state intends to introduce How counsel would know that, the court does not know. We will wait for the evidence before we rule if there's an objection.
Well, could I ask for an offer of proof with regard to that witness then?
What you're asking for, counsel, is this. You don't want to waste time hearing certain things, and if the state wants to call a witness and you think it's a waste of time, then the court should preclude it before the court even hears it. So that's denied. We stand on recess until 11:45. If counsel would present the court with the case law that it needs to review.
Denied. Yeah, that is kind of, I mean, the judge has a good point right there. He's like, look, just because you say like that whatever they're about to show is a waste of time, you want me to preclude it? Like, that's not how real life works. So now we are already at the morning break, and they still haven't even brought in the jury yet.
Judge, there's another matter.
But can I just say, this is what I love about speed trialing. I love being able to listen to the arguments faster than having to listen to him whine longer.
I think a witness is being called for which a motion in limine was filed in January regarding, my guess is, the state's intending to put on a video clip through some witness about an unknown person wearing and it's literally a 2-second clip as far as I can tell, of a person in a navy or black sweater or sweatshirt riding a bicycle about a half hour.
Here we go. Here's the bike clip. Now, he has made a huge deal about this already. He does not want that bike clip to be shown because obviously it is, not only does it explain to the jury how Fotis got from the Tacoma to Jennifer's house, but it also has the bike, he doesn't want them to be able to see that it has like the ram horn, thing like that. The blue hoodie that they said was in the back of the, or in that bucket in Pavel's truck and all that. Like, this is like, this little clip, even though it's so short and so small and whatever, pulls together so much evidence, and he does not want this in. And he keeps saying it's just some random person on a bike and we don't even know who it is, and it wasn't even by Jennifer's house. He does not want this coming in.
Away from the location of Jennifer Dulos' house. So I'm objecting. I have a motion in limine regarding that. There's certainly no foundation regarding it. There's no correlation between any other evidence, and the court will recall that the only testimony about any bicycle was Mr. Gumieni saying that there was a light blue jacket inside a bucket that he put in the house. That's the only evidence about any outer clothing. So this is, in my view, an attempt. Well, the motion speaks for itself, Your Honor. And if Your Honor looks at it, because it literally is about 5 seconds or 4 seconds, unless the state has a different offer than what I've previously seen. They just literally, after the break, handed me the video, so I don't know if it's the same one. If I'm assuming it is, I object and I have my motion pending.
Oh my gosh, what if it has
with respect to that witness, Your Honor, or Sergeant Pearson, who is about to
the court did not know which witness was being called.
Sergeant Pearson is first, Your Honor, as to the search of 61 Sturbridge Hill Road, and then the state intends to offer evidence of Todd Holson, who owns 386 Weed Street. That's the subject to counsel's motion. Does Your Honor wish to hear that argument now or after?
The court would rather not have the jury come in for a short testimony and then leave, so the court will entertain the argument now.
Sure. Your Honor, with respect to 386 Weed Street, what I would indicate to the court, there's been more than enough evidence over the past month of the travel route of Fotis Dulos the day of, or the morning of, I should say, 5/24/2019. Specifically, what the jury in the court has heard is the Toyota Tacoma leaving 80 Mountain Spring at 5:35 in the morning, being on the Merritt Parkway, traveling, being seen on Route 15 at the Fairfield rest area, the New Canaan rest area at 6:36 and 7:03. At 7:05, a New Canaan school bus passes Waveney Park area, and there is no Toyota Tacoma park there. The reason why I start this way, Your Honor, is because the timeline is important and it makes this video extremely relevant. At 7:31 along Weed Street in New Canaan, a person on a bike is driving past the area. This is a route, Your Honor, from Waveney Park to 69 Wells. And the time of that bike ride is actually one of the most key parts of the evidence that the state wishes to introduce, because at 7:40, a school bus goes by and the Toyota Tacoma is seen parked on Waveney Avenue. So the fact that this is the path of travel from Waveney into to 69 Wells, the fact that there is an individual on a bike through that area is relevant as well. I say the bike because, as Your Honor will recall, one of the items that was taken out of Albany Avenue garbage was a piece of tape. The alternate side of the tape had a Tour de France imprint on it. On top of that, Your Honor saw photographs of the Toyota Tacoma traveling. The state attempted to elicit testimony. Your Honor refused to allow the witness to testify as to what was in the back of the car. However, the state is going to argue that that was a bike. What I would also refer, Your Honor, to is in the defendant's own third interview, which the jury will hear in the next couple of days, the defendant discusses the fact that she saw a bicycle at 80 Mountain Spring that day, that the bicycle was in the garage. She talks about the fact that it was Fotis Dulos' bike, that it was, I think she uses the fact that there were, he had the bike, it was surprising or something to that effect. I can't find the transcript in front of me now. But the idea of the bike is actually relevant in her own words. So the idea that we have a video of an individual traveling the path of travel from Waveney Park, where the Toyota Tacoma is seen, to the victim's residence, or Jennifer Dulos' residence, at the time frame appropriate in light of the distance travel in the morning, and a bike that the defendant references seeing at 80 Mountain. Pavel Gulmini testified that the bike was missing from the garage photographs already in evidence, so it does make it admissible. It goes to its admissibility, Your Honor, the weight the jury can give it what they think it deserves.
Very briefly, I think if Your Honor would just look at the one of these videos. This is what we're talking about, Your Honor, and I'm going to show the court what just one, I could show you a couple. This is what the state, if Your Honor can just look at the screen. Is it on, Your Honor?
Yes.
That's it, right now. That's their best one, okay? There's a couple other angles, but it's all the same. This is about a half hour away from the Wells Lane house. This person is obviously, there's another, I'll just show Your Honor, one of the others here, so the court understands what this is. So we have the camera.
Riding the bike.
The person when he went by on that one.
He does not want this in.
There it is again, Your Honor. Person wearing all black clothing. And this, I'm going to ask the court to pay attention over where the telephone pole is on the left. You see there's a person in all black riding a bicycle. That's essentially what the state's offer is. I'll note Mr. Gumiani did not identify any truck other than the one picture coming back from New Canaan. He was not even asked about any of these other red trucks as being his vehicle. The fact that Mr. Dulos owned a bicycle does not even remotely suggest that that's him or that has anything to do with this case. So it would be pure speculation and lack of foundation. And there's, I guess, one more. I'll just show the court so that the court has a complete background of what these videos are. So there's, at some point, yeah, there's an individual, navy blue or black, riding along on a bicycle, and that was it. Mr. Gumiani stated that they found in the truck a light blue jacket. It was definitely not navy blue, and it wasn't dark blue or black. So the suggestion that the jury could speculate that this must be Fotis Dulos or somebody who is driving, that had been driving that truck is complete speculation. It doesn't go to weight, it goes to nothing. And to suggest that bicycle, I mean, if you saw a person riding on the back of the bicycle with them, to suggest that maybe that's how the individual was transporting the Ms. Dulos, I don't know, maybe that would be a different argument, but this is what we have, and I suggest it has nothing to do with the case. It's pure speculation. This was one of the things that the warrant sort of just threw out there and suggested, but the warrant had suggested that the person was wearing a navy blue or black sweatshirt, that's what Mr. Gumiani had claimed, but it's not in fact what he claimed. So I object from that basis.
Well,
Denied.
of course,
it's prejudicial too.
Thank you. The court has heard the arguments, and the court is able to determine at this point, well, is not able to determine how the jury will receive this, but this motion in limine really goes to weight, because there is evidence of a bicycle, even though the court precluded the witness from indicating, the police witness, what was in the back of the Tacoma. That does not mean that a juror or jurors would not conclude that what was in the back of the Tacoma was a bicycle. There's the same route, there's the time frame, there's the tape, and there's the hooded sweatshirt, the color of which is not certain. So the motion in limine is denied.
Denied.
Bring the jury out, please.
He says it is pure speculation, and it has nothing to do with the case. It literally has everything to do with the case, and that's why he doesn't want it in. Because here's the thing: his job is to create doubt, right? So if they don't see the bike video, then the jury, all they have in their mind is, okay, he he could have driven a Tacoma and parked at this park, however far away, like a couple miles away. I think, 3 miles away or something like that. And then how would he have, gotten there in that time frame to to kill her and then drive her car back? So it would make no sense to the jury if they don't know that there's video of somebody on a bike on the way there. So it's a huge puzzle piece, as Rashi would say, to the jury to fill in the pieces of how everything happened, and he does not want them to say that all you can see is a person, and it's it's pure speculation that it's him. It's not pure speculation when there's other factors that have led to that being their theory. So of course it was denied, but I mean, I guess he gave it a shot. Puzzle pieces.
Good morning, ladies and gentlemen.
Good morning.
The state will continue presenting witnesses today. The state can call its witness.
Thank you, Your Honor. State would call Sergeant Jamie Pearson back to the stand.
All right, so this is another one that we've had before. They're bringing them back for different pieces of the story as it's unfolding.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
Yep, Sergeant Jamie Pearson, Jamie Pearston.
Sergeant, you may be seated. Attorney Manning.
Thank you, Your Honor. Good morning, Sergeant Pearson.
Good morning.
Are you still a member of the Western District Major Crime Squad?
Yes.
Okay, if you could just briefly remind the jury some of your training and experience.
Yep, I attended the State Police Academy in 2008, where I was trained in various...
All right, we don't need to know credentials.
Processing unit in New Canaan.
Was Detective Matt Riley still the evidence officer?
He was.
Okay, what was your role in that search?
I was tasked with assisting, so no primary function, but just in searching and assisting the unit as a team.
Could you describe the property of 61 Sturbridge Hill Road?
Yep, it was a single-family residence, like a colonial structure on, a fairly open lot, and the house was, I would consider it under construction still. It was not in a completely finished, inhabitable state.
Okay, this is the house that Pavel was working on, right? This is the house in New Canaan that Pavel was on site at on the day that Jennifer was disappeared.
Were there any furniture or clothing inside of it?
No.
What about the outside of 61 Sturbridge? Can you describe that, please?
Okay, this makes sense. This is why Shoehorn didn't want this witness on here. He said that this is a waste of time, and she's just going to come and say that they searched it and didn't find anything. Of course he wants this one thrown out because he wants the jury to have the possibility that Pavel could be the person responsible for this. So her coming and saying, I did a search on that house, there was nothing that we found, we didn't find anything, in connection to it, is proving the defense's point of Pavel had nothing to do with this, and this is how we cleared him. And he's not wanting this to come in. He's saying it's a waste of time. They're just wasting time because she's going to come in and say she didn't find anything. But that's why this is important, because it is important that we know that the house that Pavel was working on that day, they did do a search of it. It was a thorough investigation and nothing was found.
Yep, it was a sealed up home, so it had windows and siding and such. The lawn had been planted recently, or fixed recently. There was a driveway, a construction dumpster. There were some things in the driveway and in the garage as part of the construction phase.
Did part of your search involve not just the residence, but the outside of the property as well?
Yes.
If you could just walk through the process of that search and how that was conducted.
Yep, we began with scene photography, which is something we always start with. We documented the exterior of the home, the property. There was a driveway in front of the residence, as well as accessing the garage from the roadway. We documented the grass area. There was a fenced area to the rear of the house, as well as a old structure, like a shed type building.
Did the search include, you mentioned a dumpster, did the search include the dumpster?
It did.
How would you conduct the search of the dumpster?
We physically got in the dumpster and then systematically searched through the trash, removing large items to discover everything within.
Were those items documented?
Yes.
In what way?
We photographed the dumpster as a whole, and then as we pulled things out of it, we continued photographing them.
How long did the search take that day?
We began around 10:30. I think it was 4 or more hours.
And with respect to the search result, was anything seized of evidentiary value from the interior of the house?
No.
What about the exterior of the house, including the dumpster? Was anything seized for evidentiary value in either of those places?
No.
If I may just have one moment. I have nothing further. Thank you.
So,
oh, Lord.
as far as I understand, you found absolutely nothing that you seized, right?
Correct.
And you went in that house because it was a place where you knew that an employee of Dulos had been in the critical time period. Is that right?
We knew that the house was under construction, and we believed it was a construction project of the 4 group.
And did you know that Pavel Gumieni had been in and about the property that day?
Objection. Calls for speculation, hearsay, no foundation.
Well, the question is, did you know or do you know if an employee of the 4 group was in the house? Overruled.
Could you repeat, sir? I'm sorry.
Yeah, did you know that an employee from the 4 group, Pavel Gumieni, had been in the house at or around the time of the disappearance?
I did not know that at the time.
So were you looking for information pertaining to the employee or for information pertaining to the missing person?
The missing person investigation.
And you didn't check into whether or not there was anyone who had been at the property that day during crucial times, right?
I did not.
Did you determine whether or not there was any video surveillance in the immediate vicinity that might show the property and who might be about it?
Objection. Outside the scope.
Well, the question really is, for what reason were you at the property to search? That's the question. And there has to be a reason, so the court will overrule the objection.
We were there to execute the search warrant in relation to the missing person.
My question was, did you check to see if there might be any video surveillance that would cover that property that might help in your search?
On the property, there was no surveillance located.
What about across the street?
I did not conduct any neighborhood canvass, for lack of better terms, on that road.
Did anyone you were with do that day?
Not on the 5th, no.
All right, so it wasn't part of your team that went into that house?
Correct.
And subsequently, did you learn that there was surveillance or not?
I did not.
I have no further questions.
Just briefly, Your Honor, if I may. Sergeant Pearson, you're a member of the van, is that correct?
Yes.
And were you a member of the van in 2019?
Yes.
Were you part of the criminal investigations unit?
I was not.
Thank you. Nothing further.
Is there recross? Sergeant, you may step down. Thank you.
Quick and painless. Okay, so the whole point of that,
Next, Your Honor, the state would call Cedric Candiati.
just to clear more of the stuff with Pavel and show that they did a good, thorough investigation.
Thank you. If I may have a moment, Your Honor.
Yes.
No.
Sir, if you can take that stand.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury? Please state your name and spell it for the record.
Cedric Candiati. CEDERIC CANDIOTTI.
Sir, you may be seated. Thank you.
Your Honor, may I approach the clerk and just mark a few items?
Okay, so he's from the car wash where they took the Tacoma. Jenny, that's funny. Every time I hear the van team, I picture the A team. That's funny.
Good morning, sir.
Good morning.
Mr. Candiati, by whom are you employed? Who do you work for?
Russell Speeders Car Wash.
Where is Russell Speeders Car Wash located?
265 West Main Street in Avon, Connecticut.
And how long have you worked for them?
This year will be 14 years.
What type of business is Russell Speeders?
It's a car wash detail shop.
And what is your current role?
General manager.
How long have you been the general manager?
Since 2013.
Was that always at that West Main Street location?
Correct.
And as a general manager, what are some of your duties and responsibilities?
Basically, overlook the location, in charge of payroll, operation, make sure equipment, labor is everything up to speed.
Were you working as or in that capacity in May and June of 2019?
Correct.
Your Honor, may I just have a moment?
Yes.
Your Honor, with respect to states 135, 136, 137, 138, and 134, absent any objection, the state would ask to move those into evidence.
No objection.
I just wanted to, I may have miscounted. Could I just see, look at it again, make sure I'm talking about the same?
At the car wash.
Yeah, no objection.
Now I'm going to have that.
States 134, 135, 136, 137, 138 admitted as full.
Thank you, Your Honor.
The car wash.
Sir, I'm going to ask if you can just take a look at the screen right behind you. I'll show you what's been marked as 135. Okay, sir, do you recognize what's depicted on the screen?
Yes, ma'am.
What is it?
That's the car wash right there, Route 44, community parking lot.
If you wouldn't mind, Mr. Kindahabi, can you stand up at the screen and just point?
Absolutely.
Thank you.
This is the car wash itself.
For the record, he's pointing to the middle part of the photograph?
Correct.
Thank you. And the road up on the top, what road is that?
Route 44.
Is that also West Main Street?
Yes.
And the parking lot with all the cars on the bottom right-hand corner, do you see that area?
This area here?
Yep.
Yes.
Is that where, or what is that area? If you could just explain it.
So this area is for detailing vehicle for customers.
Okay. If someone were to come into the car wash to get their car washed, where would they enter?
It will be right here. The first interaction will be with a customer service advisor. Then when it's done, the customer will drive up all the way to here, which is the main entrance, drop off the vehicle here, and go into the actually cashier, which is sitting inside.
Okay. And if somebody were to purchase more than just a car wash, does Russell Speeders have other things besides just a straight car wash?
Yes.
Okay, well, before I ask you that, where would they go to do that, to make that purchase?
So the same drill, customers pull all the way to here, talk to the customer service advisor, leave the car here. Depends the service the customer's having. The car actually travel through the building in the wash. There's another crew out here who finish the job. And if it's a detailing service, there's associate drive the car all the way to here, which is the detailing area.
I'm also going to show you States 137. If you can, sir, take a look. Is Russell Speeders depicted on that map?
Right here.
Okay. And you indicated the road above that, Route 202?
That's yes, that will be 44 or Main Street.
West Main Street?
West Main Street.
Thank you. I'm going to show you States 136 if I can.
Not doing so great with the focus.
All right, well, I'm going to move this a little bit, just up and down. If I can just have a moment, Your Honor. Do you see the car wash on that?
Yes, it's all the way up here.
Okay, and that would be the Avon area?
Correct.
Okay, where would be the Hartford area in relation to this map?
Hartford, it will be towards that area, to the right.
And Farmington?
Farmington, it will be also, I would say this area too.
Okay, thank you. You can have a seat, sir. Thank you. So I'm going to ask you a question about May of 2019. Did Russell Speeders in May of 2019 have video surveillance?
Yes, ma'am.
Did that video surveillance, I'll withdraw that. In August of 2019, did the Connecticut State Police come to Russell Speeders and ask to review that video surveillance?
Correct.
And did you provide or allow them access to review that footage?
Yes, ma'am.
How many video systems did the business have at that time?
There were two systems. One was a Lorix, it was an update, and then we have another one, it was a PC surveillance system.
When the police came to Russell Speeders in August of 2019, were you able to pull up any footage or video surveillance on that Lorix system for May 29, 2019?
The Lorix, unfortunately, didn't have any records on it. They have enough memory.
But what about the PC?
The PC, yes.
Okay. So with respect to the PC video surveillance, what areas or how many cameras did that system hook up to?
We have multiple cameras sitting in the whole car wash, and one of them is in the beginning of the entrance of the car wash. We have another one sitting on top of the customer lobby area, outside the car wash as well, in the detail area as well, too.
So I'm going to ask you some specific questions with respect to the outside of the building. Is that okay?
Yes.
Okay. Where were the cameras located in the exterior?
In the exterior area, there's cameras located right in the entrance of the car wash before the car goes in the wash. There's another camera that's sitting in the back of the car wash when customers can see when the car's coming out of the tunnel.
Was the time accurate for those cameras?
For the PC camera?
For the exterior cameras?
Oh, the exterior camera, there was an 8 minutes delay, I believe so.
Okay, what about the interior of the business?
The interior, the same thing.
Okay. When you spoke to the police, did you give them a statement in 2019?
Yes, ma'am.
And did you have an opportunity to review your statement prior to testifying today?
I do not, barely.
Well,
Oh, I'm sorry, yes, I did that.
you did, okay. I'm going to ask you specifically to take a look at, States 134. I'm going to play file 1, exterior cam 529, 911. Sir, I'm going to ask if you can just take a look at the screen behind you. I'm stopping it right at 1 second. What are we looking at?
That's actually the entrance of the car wash.
Okay. Where would the car wash be located if you're looking straight out to the left or the right?
That, in terms of...
Well, well, I'll withdraw it, and I'm just going to play it if I can, sir, if you can just take a look. And the time down here, 9:11, is that accurate?
Yes, so that's the camera have a little delay.
There's photos getting out.
Okay, sir, is that video taken from Russell Speeder's car wash on May 29th, 2019 at around 9:11 to 9:15 in the morning?
Correct.
Play clip file 2, interior. If you can, sir, just explain to me what we're looking at here.
That is the customer lobby.
And is this at 5/29/2019 at about 9:05?
Correct.
Okay. Is this the camera that's 8 minutes, 7, 8 minutes low?
Yes, ma'am.
Okay.
Look at that shaved head. So he's paying.
Okay, sir, I'm going to play file 3, labeled exterior cam. Sir, if you could just explain what it is we're looking at here, and I'll just hit play.
That's an exterior camera that is pointing to the exit of the car wash. It's actually pointing when the car is coming out of the tunnel. And there's a crew that's driving off the cars and do interior windows.
So at this screen, it says the bottom left-hand corner. Do you see that? It says 5/29/2019 at 9:21. Is that time accurate?
Yes, ma'am.
At this point in the location of that camera angle, did the vehicle already go through the car wash?
Correct.
Okay, so what is happening now?
As of right now, as soon as the car coming out of the tunnel, there's a small crew that start drying off the car, doing windows, a little of dusting off of the interior. That would be for a normal service, like quick service. But if the car need to go to the detail area, they drive them off regardless and bring the car to the detail department.
So if it was just the initial car wash, about how long does that take?
Kathy Davidson.
That for a quick service is only about 20 minutes, but a detailing takes up to 4 hours, could be.
I'm gonna stop the video at 1 minute and 35 seconds. I'm gonna show you one more video. Sir, file 4. Sir,
Welcome,
what
Raiders.
time is depicted on this video screen, please?
It looks like it's 2:28.
Okay, and 5:29?
But yes, ma'am.
Okay, so that same day?
Yeah.
Okay, I'm gonna hit play.
Welcome, welcome. Hi, addicts. Hi, RA.
So you talked briefly about the initial car wash. What are some other services that Russell Speeders provides?
We provide full services that include the outside wash, interior vacuuming, windows clean, wipe down dashboard. Those services takes about 20-25 minutes, and also we offering detailing service.
What would some services that would be included in the detailing services?
Detailing service, basically all interiors. We break it down interior of cars on 3. Basically, it could be shampoo carpets, seats shampoo, or dash door panels and console cleaning.
So there are 3 specific interior services?
Correct.
When you're utilizing one of those 3 services, do you use any cleaning products?
Yes, ma'am.
What are the cleaning products that you use?
We use all-purpose cleaners, spot carpet cleaners, and shampoo.
Is that for both the seats and the rug and the carpets?
Correct.
About how long does it take to do the car wash in an interior service?
I would say maybe like 2-3 hours, depends on conditions.
If I may.
So this is all the effort that he went through to
So I'm
clean
going to show you
that
what's marked as
Tacoma.
States 138. What is it? What are we looking at right here?
That's a detailed log sheet. Basically, we use every customer who using or having a detailed service in a car wash. We take it down, name, phone number, detail, or what kind of car, the timing, and pricing.
Now, you mentioned the word full service before. What would a full service car wash and detail include?
Full service is just a quick interior and outside wash. Full details, there's a different service that entails the whole day in the car wash because we go by appointments on that one only.
If you were to do a full detail service, would it be documented on the sheet as, is that what full means under detail?
Correct.
And you indicate that has to be by appointment?
That's correct.
What time do you have to drop off your car by that point?
In between 8-9 o'clock.
Now, I'm going to draw your attention over here to, if you could see the pen, the phone number. Wait here, 305-331-5232. Sir, who writes that phone number?
The cashier inside.
Where do they get that information from?
From the customers.
And if we follow along, this one is blank. Why would that be blank?
It could be many reasons. The customer was in a rush, didn't give it time to give it the information.
Speculation.
Well, what the witness is testifying to is what the reasons are for not giving a number based on his experience. Overruled.
It could be for customer don't want to give it to him, or was in a rush, or didn't pay at the moment, and we couldn't record it at that point.
And over here on this side, it's highlighted. Why is that?
That's kind of like the cashier highlighted just in case I go over the detail log and I didn't see a name. So she put a highlight that give me like excuse that the customer didn't provide information.
So the highlight.
Okay, so that's also kind of important because remember he took Pavel's truck, the Tacoma, to the car wash without Pavel knowing while he was at work, and took it there, had it completely detailed, paid cash, and then when he signed in on the sheet, he did not put his name. He put his phone number so they could call him to tell him when it was ready, but he did not put his name.
It would mean that the customer didn't provide a name?
Correct.
Now, the time, what does that mean?
The timing, it was when the customer approached into the front cashier.
And this one reads 9:14. Would that be 9:14 in the morning?
Correct.
Now, we get over here and we have ×2. What does ×2 mean?
So that will be the combination of the service that the customer requests. Like I say, we break it down in 3 services so the customer can pick up what service they want.
Okay, by the 3 interior services?
Correct.
So the ×2 would be which of those 3?
It could be in between carpets or upholstery, or it could be dashboard and console or carpet, either way.
By upholstery, you mean seats?
Seats, correct.
Now, down here two rows, I should say, is the DDC. What does that mean?
Dash, door, console, and clean.
Okay, so that would be only one of the 3.
Correct.
Now, above this reads full and then $250. Is that the price of a full service?
The full detail.
And full detail? And is that the one that has to arrive before 9 o'clock?
Correct.
Okay. Over here on this last column, it says needs to pay under price. What does that mean?
The cashier, as a friendly reminder, because we don't request to pay up front, so we give you the option the customer can pay when the car's ready for pickup.
I want to go back over to the name column and then the phone number column. The phone number is the same for both of these rows. Why is that?
I believe the...
Want me to object to speculation?
Okay, well, the court is going to allow the question. However, the response, the witness's response is, I believe. The court therefore will ask that the question be rephrased, such as, do you know the reason?
I will, Your Honor. Thank you. So do you know why there is 2 phone numbers on, or the same phone number on both those columns, or rows, I should say?
I don't.
Okay. And when we talk about the ×2 detailing interior services, what kind of equipment or process is that interior going through with those interior products?
So we use pneumatic tools for brushes. We use carpet brushes. We use all-purpose cleaners, spot carpet cleaner, dry shampoo, and vacuums.
And vacuums?
Yes.
Okay. And is that through the entire interior of the vehicle?
Correct.
I may just have one moment, Your Honor.
Yes.
By the way, just one quick question. There was no name given on the detail log. Do you know whose phone number it was on who belongs to?
I do.
Thank you. Nothing further.
Thank you.
It was Fotis Dulos.
Thank you.
Oh, Lord, here we go.
If I could just have one moment, Your Honor, perhaps, Attorney Rankin.
2? No.
Shoehorn's trying to work technology.
I want to start, sir, with just going to ask you about this detail log that you just testified about. To be clear, this is filled out by the employee, correct?
That's correct.
So if we were to connect this detail log to the videos that we just saw, it would be the young woman with the dark hair who was behind the counter who would fill this out?
Correct.
And the time that's indicated would be the time the vehicle that got brought in, correct?
Correct.
So the fact that there were, looks like that day there were several Toyotas brought in, correct?
Correct.
There was one at 8:06, a Camry, right?
Correct.
There was a Toyota at 8:09 that doesn't indicate a name or a phone number, correct?
Correct.
And that looks like there's a Toyota, maybe a
Sienna.
Sienna at 8:44, correct, at the time, correct? Yes?
Correct.
And then they sought that $250 would be the full detailing, correct?
Correct.
Now, it's my understanding that when you come into the line, and I'm just going to go back to, you were shown this video, this picture, Exhibit 135.
Thank you for
So in order to enter the Russell Speeder Car Wash, you have to come in from Route 44, correct?
Correct.
And you have to, this is all, in order to get to Russell Speeder, this is all blocked off here. You have to come into the large shopping center parking lot, correct?
If you're driving, yes.
That's true. If you're driving, you need to come in to the shopping center parking lot. You just can't walk into the area where the car wash is, right? And you have to go all the way down to a stop sign that's down in the parking lot of the shopping center, correct?
Correct.
And so that we're clear, even in 2019, this is a Walmart shopping plaza, correct?
Walmart.
And in addition to Walmart, there's also other stores and
Walmart, we are 21 days in, and Walmart has finally entered the trial. 21 days it took us to get here. 21 days, and Walmart has entered the building. 21 days. I thought it was never going to happen. I was starting to lose hope. Bingo. That's the free space. Walmart has finally entered. 21 days in.
Maybe even a restaurant or two next to the Walmart, correct?
That's correct.
I think there's even a Five Guys Burgers and Fries there, right?
That's correct.
So this is one of the entrances that everybody has to come in, right?
Correct.
And then there is, you have to make a turn. There are a couple of stop signs in order to pull into Russell Speeder. You then have to pull into one of these lanes that I'm pointing to that goes up to the entrance, correct?
That's correct.
And there's the express lane is on the right. Is that right?
That's correct.
And then there's for the rest of us, non-special, if we don't have our special badge or our free car wash pass, we have to get in the left lane, right?
That's correct.
And the video that we saw was from that left lane that the public that doesn't have express wash has to go in, right?
Correct.
And the camera, as I understand it, is right here, right before you pull into the building, right?
Correct.
And it's your custom, is it not, that everyone pulls up, the driver and the passengers have to get out of the vehicle at that point?
Correct.
And then when it drives into the building, that is employees of Russell Speeder that bring them in, right?
That's correct.
So when we see the vehicle move past the camera into the building, that was an employee doing that, right?
Correct.
And the individual that we saw get out of the red pickup truck was wearing like a suit with a dress shirt, correct?
That's correct.
And then you see that individual move off the camera. I don't want to play it again, I could, but they move to the right off that camera, right?
Correct.
And there's a door right here, is there not, to walk into the office just before the car gets pulled into the car wash, right?
Correct.
And it's one of these where it's on a conveyor belt of some sort, correct?
Correct.
You then have employees inside that either wash the car, you've got hoses, you've got brushes, and then it's somewhat automatic, correct?
Correct.
You even have some, if I recall, some animatronic, like mannequins that shoot water and stuff in your place, right?
Correct.
So the individual walks into the building, and I could put up that video, but I just want to see if, without doing that, if I can sort of picture, there are places where people can either watch their vehicle go through, it's all glass, right?
That's correct.
Or there are chairs, somewhat comfortable chairs that they can sit and wait, correct?
That's correct.
The customer service or the cashier is down at this end of the building, correct?
That's correct.
So when we saw the interior video image, that is close to the exit that's over here, right?
Correct.
And the camera that showed the vehicle being pulled out is somewhere, I don't know exactly, but it's somewhere shining down on this part of the lot, right?
That's correct.
And that's after the vehicle has gone through the car wash and is now outside, right?
Correct.
And then you have employees that are wiping down the water, and they may even be doing the interior, correct?
That's correct.
And when the vehicle is then completed, either it then gets brought over into these parking spots for detailing, or the person drives out and goes on their way, correct?
Correct.
By the way, let me just show you this other picture. So Exhibit 137, I asked you this, but I just want to be clear. So if this is Russell Speeder right here, the Walmart and these other stores are basically in the same parking lot, only further to the south of Route 44, correct?
Correct.
And there's a clear line of vision, if you will, to the area where the car wash is from the Walmart and these other stores, correct?
Correct.
In other words, there aren't any giant trees or walls blocking the view from there, right?
No.
And across the street, there's a Goodwill store. You see that there?
Yes.
Was that there in 2019 as well?
Goodwill, I believe so, yes.
And do you know whether they also have cameras, either Walmart or Goodwill?
No.
You have your cameras, right?
That's correct.
Okay. Now, I know that the state did not play the rest of the exterior, so I just want to play the video, if I may, to the end. They stopped it before the end.
He wants to play. What happened at the end?
I don't know if you realize I have to change that there. Oh, no, they don't have to change. So they stopped it right about around 9:21. Is that about when they turned it off? Yes, sir?
Yes, sir.
Okay, so I'm going to just play this to the end. So these are overwatching now, are your employees doing their task, correct?
Correct.
And they've opened the doors, right?
Yes, sir.
They wipe the outside, the exterior of the vehicle, correct?
Correct.
And that's to get off any extra water and maybe a little extra dirt that didn't come off from the wash itself, right?
Correct.
At any point, though, they don't climb into the bed of a pickup truck, though, here, do they?
No, they don't.
That's not part of their job, right?
They're not.
Okay. And when they complete this task right here,
Correct.
the vehicle then drives forward, correct?
Correct.
Who does the driving forward?
It could be a driver or a manager on duty.
Okay. But it's an employee of Russell Speeder that does that, correct?
Yes. Correct.
So they're still doing the interior of the vehicle at this point, right? If you look at the... Am I right?
Yes, sir.
And the exterior, they're wiping around the edge of it, right?
Correct.
But they don't even lower the tailgate on the...
No, we don't.
Let me just finish my question. I'm trying to think of the right word. They don't lower the tailgate of the flatbed of the pickup truck, right?
Correct. Correct, yeah, they don't.
And I see there's a black car driving out. That car just was in the express lane, and it goes out as well, right? And
I'm
that's
going to object at this point, Your Honor. Just narrating the video.
yes, correct. Isn't that a vehicle
So
just
there's an
going?
objection.
I'm sorry, Your Honor?
There's an objection, and the objection is you're simply narrating the video. Well, the court does not know if this line of cross-examination is leading to something other than just narration. So the court will overrule the objection, but counsel can make the objection if it continues.
I'm sorry,
overruled.
Oh, okay.
Basically, get to
So
it.
there was a car that just pulled out behind the red truck, correct?
That one right next to him?
Well, the one before I stopped the
Oh,
video.
yes.
And so the purpose is to show that what we see in the behind here is that's the Walmart we see behind there to the right, correct? Behind where the truck is out into the parking lot, right?
Yeah, correct.
And it's all part of that same parking lot there, right?
Correct.
So, it doesn't have anything to do with anything.
Now at 5:10 on the thing, or at 2100, the truck is now moving forward, correct?
Correct.
And that was an employee moving it, right?
That's correct.
Okay.
Correct.
You know what? If nothing else, he got us to Walmart.
Hopefully it'll automatically go back to the... So I wanted to just ask you a couple more questions about Exhibit 138. Now, you testified that the employee is the one that fills this out, correct?
Correct.
And the time that's put in is the time the vehicle would have been brought up to the counter, that is, that the occupant or the driver would be up at the counter in order to put in a request for some kind of detail, right?
Correct.
So the vehicle above, you were asked about this vehicle at 9:14, but this would have been a vehicle that came in at 8:44 in the morning, correct?
Correct.
And you indicated that a ×2 is different than a full detail?
Correct.
What is included, I'm not sure I quite understood. If an X2 is written down, exactly what does that mean?
It means the customer requests two individual service.
One was, you said, the carpeting?
Could be the carpeting, shampoo, seats, or dash door and console cleaning.
But you don't know which ones that was from this?
I don't, but the customer received when pull up into the driveway, talk to a associate who have a little sheet with all the services. So the customer pick up whatever service want and bring it back to the cashier.
But I'm asking you though, from this detail, this form that's been introduced, we can't tell what 2 services were requested, correct?
No, I don't.
Okay.
It's based on that.
All right, and then when it says needs to pay, for much of the people on here, except for Dylan down here at the bottom, which also says needs to pay, there's a price actually listed, correct?
Correct.
Was there a reason, just by looking at this log, can you tell why it wasn't a specific number that was written in versus needs to pay?
Just the cashier, instead of the price, because the price means that the customer paid the amount.
Upfront?
Upfront, correct.
All right, and if it's not upfront, then you put down, or you're required, when I say you, I mean the employee is required to put down, they haven't paid yet.
Correct.
Okay. And that would be done before the car could be picked up, right?
Correct.
Okay. I just have a moment?
Yes.
No.
Incidentally, without showing you that, well, actually, I'm going to show you that.
It's not going anywhere.
The other video that you were shown, you recall seeing this video. You indicated this would be at some time around 2:20, between 2:26 and 2:28 in the afternoon, correct?
Correct.
And I'm just going to call your attention to the individual who just walked through the door. And incidentally, when I asked you about the chairs, these are those chairs where a person, if they wanted to, could sit and wait for their vehicle to be cleaned and or detailed, right?
Correct.
And this is the woman who, behind the cashier. She worked at the time for Russell Speeder, correct?
Correct.
Do you still work there?
No.
It's such a waste of time. It's frustrating when he makes objections about.
And it looks
stuff
like
being a
the
waste of
individual,
time.
I see your employee counting something. Was that indicative of the fact that this person paid in cash?
That's correct.
All right. And what is your employee doing now? Going through a cash register and giving change?
That's correct.
Okay.
And the receipt.
And receipt.
And also indicate the car is in the back.
Okay. And then the individual leaves, correct?
That's correct, yes.
The individual. Fotis.
All right. The videos that we just saw, did you provide them to the investigators, or did they come and take what they wanted?
I provide access for the video system.
And they took what they wanted from it?
Correct.
So I just want to be clear, showing you again what has been marked as Exhibit 138, the log sheet. They didn't ask you for information about a Toyota Sienna that came in at 8:44, did they?
Don't remember.
And you haven't seen any videos from that?
No.
Okay. I just have a moment, Your Honor?
Yes.
No.
I have nothing further. Thank you, sir.
Thank you.
No, sir.
Yes, sir, you may step down. Thank you. Thank you.
Okay.
Attorney Manning, do we have witnesses for 2 o'clock?
We do, Your Honor.
And how many witnesses?
All right. It never goes. It never goes anywhere. Yeah. My body language starts going downhill when this guy starts talking. Ugh. He drives me crazy. Crazy. We're moving right along, though. We're almost done with day 21. Dang, how long are they? Here we go. All right, now we're to the afternoon.
We'll wait for it. Attorney.
We can continue, Your Honor. He's bringing some stuff up.
Thank you. Who is the next witness, please, Attorney?
The next witness would be Todd Holson, Your Honor, and then Dr. Gill.
We should probably take up the motion in limine first, rather than have a witness come in, excuse the jury, have argument. So the court has had the opportunity to read the motion in limine. Counsel, you may be heard.
Thank you. I don't know if Your Honor had a chance to read both the Rios in the Acosta case at 8 Appleton site, but there are some practical matters that I first want to address, and that is this report was written in December of 2023.
All right, so here we go. We are now back from lunch, and it's starting just how the morning started, with more arguing, more motions.
Could have been written and said the same thing 4 or 5 years ago, but the fact of the matter is it was provided to me at the end of December, right before New Year's, and it was not even previously presented in a draft form. I tried after that date, as did Attorney Felsen, to reach out to see if we could find any expert anywhere in the country who could testify that a medical examiner cannot and could not testify based on reading an arrest warrant and looking at other court documents and rendering an opinion without having actually examined either body or parts of a body. I emphasize that because there are a couple where there was a femur or another portion of an individual's anatomy that a person couldn't live without or could not easily survive without.
Happy 8 months.
Previous to now, the only thing that that Dr. Gill had said regarding anything was in his warrant, was in the warrant from January of 2020. And in there, he had some private conversations with the police that are not documented anywhere. And he looked at some pictures of the, I think the bra and the shirt, and said at that time, a person would not be able to survive for long based on the amount of blood. That was the only thing he said. If that's all he was going to testify to, for 4 years, I assumed either it was inadmissible or I could cross-examine if that was all he was going to say. Now he's going to say, I read the arrest warrant, and I looked at the probate findings down in New Canaan. And if you'll honor will note, I attached to my motion the probate findings of the Farmington probate judge, who rejected almost the same evidence that was used in an ex parte proceeding that no one other than the family and the lawyers for the Farber family knew about, that happened just a couple of months ago in New Canaan. So we start with the fact that, and I wanted to quote it specifically from Barrios, because that's the case that Ms. Manning, as I understand, provided. Well, she didn't give me a copy, but I'm assuming Barrios was the case. I just asked that Ms. Manning indicate that that is the case she gave to the court.
Yes, 187 Connecticut Appellate 661, a 2019 case.
Right. So, and I just took some notes specifically with regard to the Barrios case. So, interestingly enough, the defendant in that case made the same argument that an expert cannot testify under 7-3 of the Code of Evidence to the ultimate fact unless under subsection B, where he or she can give an opinion that embraces an ultimate issue where the trier of fact needs expert assistance in deciding the issue. The court then goes on to say that the defense argument there was because her testimony was not based on her medical knowledge and training, but on information obtained from police investigation, her testimony regarding the manner of death did not provide the jury with expert assistance with respect to that issue. Thus, the defendant argued in the Barrios case that the general rule regarding the inadmissibility of testimony that embraced the ultimate issue applied, and the testimony should not have been permitted. And the case, there was a couple of cases from out of state that were cited. The only one I'm going to refer to is State versus Jamerson, which is a 1998 New Jersey Supreme Court case that's in Barrios, found at 153 New Jersey 318, 1998 New Jersey Supreme Court. Now, what's interesting, though, as I continue to read the Barrios cases, the court analyzed the Jamerson case, which I submitted very much like this case in terms of a doctor opining on the nature of the death caused in a certain way based on reviewing of reports or police investigation and whatnot. But what the Connecticut appellate court said in Barrios, and I'm going to find the exact quote, the facts and circumstances of the present case support a conclusion that Williams's determination of the manner of death was based on her medical knowledge and expertise and not solely or primarily on police reports. This doctor, whose name was Williams, conducted the autopsy of the victim. She documented the injuries suffered by the victim, including abrasions, and they go into some detail. I'm not going to put them all on the record. Abrasions to the head and over parts of the body, bruising in other places, a skull fracture, subarachnoid hemorrhaging, brain injury, numerous fractures of both the scapula, the neck, lumbar vertebrae, and the left femur, and then conducted with a neuropathologist about these very injuries, and whether or not, and reviewed the victim's medical records from the hospital before she died, or he died. Then there's the quote. It is clear, therefore, that Williams's ultimate conclusion as to the manner of death was not made solely or largely on the basis of police reports, but rather on the medical knowledge, training, and experience. These facts stand in stark contrast to those set forth in the State versus Jamerson case that was set forth. So what's key to Barrios is that doctor actually performed an autopsy and then reached certain conclusions on the manner of death from having done that. The cases I cite, Your Honor, are not only Jamerson, but I cite to Tyler out of Iowa, Sosnovitz out of Arizona, that's Sosnowicz out of Arizona, and the Vining case out of Maine. But more importantly, what I do, Your Honor, is this is also clearly based on I have a copy of the report by Dr. Gill. It's almost entirely based on testimonial hearsay. It's not based on medical records or even someone else's autopsy. Now, what's interesting is apparently the defendant in Barrios, the lawyer, did not argue, maybe because it wasn't preserved, that it would be a Sixth Amendment violation to have an expert testify to an opinion based on testimonial hearsay, such as an arrest warrant, which is what Dr. Gill says he relied on, looking at some photographs, and the hearing in probate court also was in New Canaan, was also clearly testimonial in nature. It was also one-sided. As an aside, I was at the hearing in Farmington, which was the subject of Judge Evelyn Daly's ruling to not allow a finding because of the nature of the evidence. She needed more. And I remember at that time, it was one of the Farber attorneys. It was either Attorney Dranginis, who was there, or Attorney Weinstein, who represented the father's corporation or something. They were both there. And one of them, and I can't remember which one, said on the record, even if the probate court were to make a finding that that Jennifer Dulos was in fact deceased and met and died prior to Dulos, because this was actually Dulos's probate hearing, I was there because all my client's property was still in the house, and the house was now in probate, and everything that belonged to her and her daughter were still in there. So that's why I was even present in that hearing at that time. But they said, well, this would never be admissible in another case. It's blatant hearsay. It would be not admissible to prove anything in any other case. And I remember, I don't know if I said it or thought it at the time, I said, somebody's going to come up with some theory on how they're going to get this in. And I was waiting to see if that was going to happen. And lo and behold, they hold a hearing, and there was no media coverage of it, so I didn't know about it in October of this past year, where only the mother testified, Mrs. Farber testified, and one of Ms. Dulos' friends. They get the New Canaan probate judge on the basis of this one-sided hearing to conclude that she is deceased and was the subject of, I forget the exact language of that decree by the probate judge. I have to find that. I didn't bring that up. But what's also clear is there's a whole line of, so we have three issues. Right? One is the timing of this. They waited until New Year's, so we could not find an expert just to debunk this theory that a doctor of any sort could look at an arrest warrant, could look at a decree from a ex-party hearing in a probate court, and look at a couple of documents and conclude not only that Ms. Dulos is deceased, because we're not contesting that in this case, but not only but saying that, but that she was the victim of a homicide, that there's no other possibility just based on that conclusion. Now, that's based on nothing other than what's been not only presented in the court, but is nothing other than in a police sworn, in an arrest warrant affidavit, and in a decree from a probate court, again, all testimonial. So I would submit that and I keep moving around here, so I want to stick to my points in order. So the timing prevented us from getting any kind of an expert to debunk it, number one, that no doctor should be allowed to do that. In fact, to my knowledge, I couldn't find any case since the Sixth Amendment was adopted under the 14th Amendment in the 1960s under Pointer versus Texas that would allow at least no appellate decision of any repute. Could I find any decision that said that you could bring in a medical examiner saying, yeah, I read the arrest warrant, we can just conclude she was a victim of a homicide. The jury can reach that conclusion based on if there's sufficient evidence, but having the imprimatur of the medical examiner saying that in addition is quite frankly astonishing.
It's astonishing, he says. So he doesn't want the medical examiner to be able to say that Jennifer Dulos could not have survived based on the injuries that she sustained because the medical examiner didn't get to look at Jennifer's body or body parts or any of that. So with no body and no autopsy and all of that, he says that the medical examiner shouldn't be able to say that she could not have survived. And also because a lot of it is based on, he says a lot of it is based on the medical examiner. Is the medical examiner a male or female? I don't know. I don't know what I don't even know. But they're saying that the medical examiner should not be able to come up with expert testimony based on stuff that's in the search warrants because it should only be based on being able to actually see Jennifer's body. And of course, with no body, he's still trying to make his hope, I think, is still to try to make the jury believe, well, if there's no body, then maybe there's no murder, which I don't think any of us believe.
But we then get to the fact that it's not just that this doctor would have looked at maybe the work of another doctor. Here, it's based solely on police speculation. I have raised, for example, as Your Honor knows, that in these warrants that were prepared by Detective Kimball, there are many falsehoods. The court did not allow the revisiting of that, but relied on the fact that and I disagreed that it was the law of the case, but the court made a finding that the court was bound under the law of the case to Judge White's finding, even though I submitted that even Judge White conceded there were errors in the warrant, but he said it didn't affect the finding of probable cause. But you have the line of cases that starts with Crawford, goes to Bullcoming versus New Mexico, and Melendez-Diaz versus Massachusetts in the 2011-2009 that expand Crawford. So you can't even allow an expert to testify to what another expert did. That violates the Sixth Amendment, ironically. So here we're taking it one step further. It's not only based on not what another expert did, which would have been invalid under the Sixth Amendment, but we're taking not scientific stuff, just stuff that this doctor read from the police warrant and police reports, looking at some pictures, did no medical exam of his own, none whatsoever. In the Apostle case, it was the same thing. In Apostle, a Connecticut doctor opined that it was a sexual assault case, but opined that the sexual activity was forced, that it was against the will of the victim there, based solely on what the victim said, not based on a review of medical evidence. So that was in Apostle, they reversed the conviction and specifically said it was improper to allow a doctor to opine based on that.
Courtney, happy 4 months.
What's also concerning to myself and should concern the court as well is this is not a matter that I can cross-examine on, because if this witness is going to say, I relied on the arrest warrant, then chances are he's going to want to go into things he found compelling in the arrest warrant. If he does that, well, then we're getting to the point, which is one of the things that I'm concerned about, that it's one of these cases, I think it's one of the out-of-state cases, talks about it's not then the doctor's opinion about any factual basis, but his opinion on the thoroughness or the accuracy or the acumen of the detective who applied for the arrest warrant. And also the opining on the findings of the probate judge. And again, it was not something that was disclosed, was not even aware of it until New Year's, week of New Year's after Christmas and before the trial started, that we even were aware that it had happened and that there was any kind of decree issue. So
Kelly Davidson, happy 7 months.
It violates not only 7-3 and 4, but it also is irrelevant It's also prejudicial, clearly prejudicial, and it has no probative value. It's essentially taking away from the jury a finding that they would have to make based on inference after inference after inference. And I know at this point that the court has allowed in many things that I objected to, that at least I argued should not even have been admitted. So the court actually is, the jury rather, is in possession of more information than I submit should have been allowed. One of the things, for example, Dr. Gill is going to talk about is all the blood, et cetera, et cetera. Well, the court allowed in the luminol and the KM for a certain purpose, but Dr. Gill thinks that this is all blood and that it was confirmed as blood. And again, so he's relying on not only erroneous information, but again, the only way to even cross-examine him is to get into the fact that he's relying on information that's misleading and does not lead to the appropriate conclusion. And that, we shouldn't even get to that point. Having a doctor, the medical examiner, the state of Connecticut, come say, I'm going to rubber stamp what the state police did in their warrant and what a probate judge did in New Canaan is essentially taking away the right not only of the defendant to have the jury decide the case, allowing a witness basically on lay testimony, because it's not involving any of his expertise as a doctor to make these conclusions. It's based solely, as opposed to Barrios, where that doctor actually performs an autopsy, to give an opinion on the ultimate issue, and without the opportunity to even cross-examine on that underlying issue, because that's going to bring in whether or not a judge signed a warrant, what the judge signed for, and how many lies there were in that warrant by Detective Kimball. So based on all of that and the cases that I cited, I submit that the court should preclude it. And then there's my caveat. If the court is even inclined to allow it, I submit, and I've asked for a Porter hearing. And I've asked for a Porter hearing because there's no case, there's no article I can find where a doctor has been allowed to testify in a contested case.
We need not get that far yet.
Okay, but all right, but I just want.
Okay, let me say this about that, because I see a couple of you have asked about the medical examiner being allowed to give expert opinion. The problem is that what the defense is saying, and he does have a point, unfortunately, is that the medical examiner's testimony, in order to give expert testimony, it would normally be like, if I'm going to give expert testimony about something that I'm considered more than a like my expertise on it is more than like just a layperson, then it would be based on, information that I'm able to look at that and then form my opinion or whatever. What he's saying is that the information that the medical examiner is looking at is not information like, exactly how much blood was collected or, seeing like the actual evidence or, again, no body, etc. What it's based on is what was written in the search warrants and the information that was written down by police officers. So he's saying if they're saying in these warrants, that like this tested for blood and this tested for blood, and the medical examiner's looking at that being like, that's a lot of blood, there's no way that she could have survived that. He's saying that wouldn't be that's not the same as giving an expert opinion, because that's based on a layperson's description of what had happened. Unfortunately, he does have a point on this, and it could present appellate issues if it is allowed in. So I kind of have to agree with him on this one.
The court to be aware that, this would be the first time that I can find anywhere, and I tried to look up articles about it. There was questions about identifying people from DNA and whatnot. That's not in dispute, but using it in a contested case and arguing as a medical examiner in a criminal or even a civil case to prove something, there's no peer review articles on that issue that I can find.
Thank you, Your Honor. I just want to start by...
and I will say this. If you look at the shirt and you look at the bra and you see how much blood was on there, that's a lot of blood. But is that what the medical examiner looked at? According to Shoehorn, he's saying that the medical examiner didn't look at that the medical examiner looked at the arrest warrant and reports, not the actual evidence. And if you did look at those two items that had so much blood on it, is that still, even if the medical examiner would have looked at that exact evidence, would they still have been able to say then that was an unsurvivable amount of blood? I wouldn't know. I'm not a medical examiner, but he's saying that the medical examiner didn't even look at that it was all based on the reports, which is different.
Discussing the timing issue, counsel did bring up the fact that this was in the arrest warrant. The arrest warrant was signed in January of 2020. There's a whole paragraph that is devoted to Dr. Gill and his statements, including what he reviewed, which is all similar to what he reviewed now, absent the probate report that just came out this past fall. In that paragraph, it indicates that he had made an opinion and that he was prepared to indicate that Jennifer Dulos had sustained an injury or multiple injuries that he would consider non-survivable without medical intervention. He characterized it as an event of homicidal violence to likely include some combination of traumatic blunt force injuries, such as bludgeoning, beating, and or sharp force injuries, such as stabbing and slashing. That's only part of his opinion that was in the arrest warrant. Your Honor, I indicated when I submitted the witness list, his name was on it, as well as the fact that what he would be testifying to. I did ask for him to document it.
Okay, so this is another time where the prosecution is saying, look, dude has waited until the last minute right here to now give this objection when he's known all along that not only was this testimony, or this witness going to be called in to give testimony, but also this was in a report and this is part of it. So now here you are waiting till the last minute right before we call them, and now you want to, file this motion.
In a report under State versus Manusis, as well as to clarify exactly what he would be testifying to for counsel's edification. That is why a report was written. Otherwise, we would just be going off what was in the arrest warrant, Your Honor. They have had ample notice that the state's position on Jennifer Farber Dulos' death has been, since the beginning, a homicide of violence. That has been for 4 years now. So the idea to stand here and say that we don't know how to combat this, they've had 4 years to do so. With the argument that the opinion of the chief medical examiner in the state of Connecticut, who is an expert in forensic pathology, his determination of whether or not she is deceased and the manner and cause of that death is irrelevant and immaterial, which is counsel's words, in a conspiracy to commit murder case, I don't even think needs to be addressed at how ridiculous that sounds. It is very relevant, it is very material as to whether or not Jennifer Farber Dulos is deceased. That is a factor that the state is submitting, is put before the jury. They can take what weight they want of it. Counsel, he is subject to cross-examination. Counsel can certainly effectively cross any issues that he wishes to do so. I would also refer to Section 7-4 on opinion testimony by expert witnesses. They can clearly base their opinions on evidence that is not admissible. I refer, Your Honor, to Section B. The facts themselves need not be admissible in any way, shape, or form, as long as if they are using it for the limited purposes of basing their opinion on, which is what Dr. Gill will be testifying to. Now, going forward on the Barrios case, I actually see the quote that counsel indicated as saying almost the exact opposite, saying that the forensic pathologist in that case can make a determination based on the medical knowledge and expertise and not solely and primarily based on police reports. Dr. Gill is not basing his opinion based solely on police reports. If that were the case, then we can call anybody off the street, say, read this report and tell me what you think. That's not what's happening. We are taking somebody with skill, experience, education, and years of testifying to forensic pathology and asking him based on that knowledge and experience, as well as a variety of items that he's looking for, not just, by the way, police reports, lab reports, photographs where he can make his own determination and come to an opinion that he is entitled to make under 7-4. I also believe that Barrios provides him with that. The concept that you can do the entire, death consideration, I'll call it, for a forensic pathologist.
Okay, remember the fresh paint trial? Think about how it ended up being overturned because the expert who gave testimony about the paint being fresh, it turned out that they weren't able to actually verify that that was expert testimony. This is kind of the same thing. So even though the person may have been, an expert at paint or whatever, just like this, medical examiner is a medical examiner, doesn't mean that the information that they were given or, reports they had or whatever, like in whichever case you're talking about, like they can be an expert witness, but if what they're saying is not admissible, it could end up being overturned like it was in the fresh paint trial. Because then remember, we had to go through that whole trial again without, like, you can't say fresh. Don't say fresh. That's the new F word. Don't say fresh. So this is kind of the same thing. So they're trying to, they're trying to say, yes, this is an expert witness, but you can't present expert testimony on something that you're not able to give actual expert testimony on, if that makes sense.
And make a judgment call at the end of your consideration and not consider law enforcement is belied by Barrios and statute. It's just what they do. The idea that you cannot make that call because somebody is good at hiding a body is belied by anything that is out there. Just because a body has not been found does not mean that a medical examiner cannot make a determination. I don't think that makes sense in any way, shape, or form. Counsel cites the Apostle case. I actually read that completely different as well, because that court indicated the determination of whether or not a sexual assault was consensual or non-consensual is something that it's not outside the ken of a regular juror. And that is why the expert testimony was excluded, because it was something that was not that expert's opinion for what they were offered for, which is a doctor on his medical experience and knowledge. Dr. Gill is an expert in forensic pathology. He is here to offer his opinion based on his review of numerous factors and numerous police reports. Counsel has all that. Counsel has been aware of that since 2020, and I think it is entirely relevant and material to our case and the case against Mr. Troconis. So I would ask the court to deny his motion.
Well, the court has heard what it needs to hear in order for it to determine whether it will grant or deny the motion in limine. Both counsel referred the court to State versus Barrios, 187 Connecticut Appellate 661, a 2019 case. The court is reading from Section 2 of that opinion. In that case, Susan Williams, a pathologist in the Office of the Chief Medical Examiner, who had performed the August 11, 2014 autopsy of the victims, indicated initially that after that autopsy, further investigation was necessary. Circumstances pending further investigation was the conclusion. On December 24, 2014, she amended the manner of death to homicide. The court is looking at the facts in Barrios and the facts in this case. In Barrios, there was an autopsy. The first autopsy yielded the conclusion, circumstances pending further investigation. Now, at that time, the State Medical Examiner's Office had to classify the manner of death as one of the following: unable to determine accidental, suicide, natural, or homicide. As of August 11th, unable to determine would have been the conclusion. So the question then becomes, well, what changed between August 11th and December 24th? Law enforcement reports. The jury in this case has more evidence to consider than Dr. Gill. The code states that concerning an ultimate issue, opinion by an expert, an opinion by an expert on the ultimate issue is admissible essentially if that expert assistance is needed by the jury in deciding the case or deciding the issue. And the issue here is whether or not there was a homicide. It is clear to this court, based on the 4 weeks of evidence that the jury has heard, that the jury can come to its conclusion and it need not rely on expert testimony. Again, the jury has heard more than Dr. Gill could testify to. The motion is granted.
Okay, so he granted the motion to limit the testimony, and that's actually a good point. He says that the code says that, expert testimony is allowed if they need, to provide help for the jury to, come to a conclusion or understand stuff. He has a really good point, though. The jury has heard more evidence than Dr. Gill has. So, I don't think that they'll have any trouble coming to the conclusion that, yes, this is a homicide.
And who was the next witness, please?
Todd Holston, Your Honor.
Bring the jury in.
Bring the jury.
Evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Please state your name and spell it for the record.
Todd, T-O-D-D, Olson, H-O-L-S-O-N.
Olson, you may be seated.
Your Honor, if I may just approach the clerk and mark a few items, I would also stipulate for the record the presence of the jury. If I may just have a moment.
I stipulate the presence of the jury. So.
Thank you.
Good afternoon, sir. How are you?
Fine, thank you.
Mr. Wilson, do you own 386 Wheat Street?
Yes, I do.
Okay. If you can just explain to the jury, please, what kind of property is it?
Sure. The property is a residential property. It's known as Weed Farm. It's on about 32 acres, and it consists of two different properties, but it's known as 386 Wheat Street. There's a fence around the entire property.
Weed Street. This should be
two,
the bike
two gates
video.
at the two entrances off of Weed Street.
Sir, how close are you to Waveney Park?
I would say about a mile.
Is that north or south? Where, in what direction?
I would say it's south.
Do you have any video surveillance on the property?
We do.
Yep.
Did you have video surveillance in 2019?
Yes, we do.
Could you please just describe a little bit about the video surveillance, particularly the surveillance you had that covers the road in 2019?
Sure. The camera system is a server-based system that resides in our house. The software program is known as DW Spectrum, and it time syncs with the internet. There's a total of 75 cameras on the property, 5 of which are close or facing toward Weed Street.
So the time of the 5 that are facing Weed Street, is the time accurate?
Yes, it is.
So
Can
one
I
of
have
them
one
was
moment, Your Honor?
7:31 a.m. I think is what they said.
That's fine. That's fine. If I can, just for the record, Your Honor, the TV screen behind the witness displaying to the jury is off. The state's going to show 139 at this point and inquire of the witness, if I may, Your Honor.
Yes.
Sir, is that TV on in front of you?
It is not.
Actually going to show you what's been marked as file 1. You can actually take a look at that screen in front of you, sir. Do you recognize what's depicted on that screen?
Right now, it says no signal.
All right, hold on.
Thank you, Nurse for God. Nan R, Gunner, K Blue, Angie Burr.
Okay. Do you see it now?
Yes, I do.
Jean Rano.
Do you recognize what's depicted on that screen?
I do.
What is depicted on that screen?
Thank you, Nurse for God.
This is a camera that is on the north side of our carriage house facing toward Wheat Street.
And I'm going to press play and have you watch the video if I can. Oh, there we go. Now, sir, the file I showed you has been marked as a video feed 1. Is that from time 7:31:50 to 7:32:06? Did that fair and accurately represent what came out of video camera 1 on your property on May 24th, 2019?
Yes.
And by the way, did the police come to see you in 2019?
Yes, they did.
Did they ask for review of your video surveillance system?
They did.
What did they ask for?
They asked for a block of time between 7 a.m. and 12 p.m. on May 24th.
Did you provide them with the video cameras for that time period?
Yes, I did.
And is this one of the camera time frames that you provided to the police?
Yes.
Okay, state would offer file 1, Your Honor.
I just have a couple of questions to clarify, if I may. Sir, in just looking at the same thing you just looked at, it looks like it's stop action. Was this, when it was given to the police, was it a full, I forget the word I'm looking for here. Was it a stop action, or was it an actual video that flowed?
It was an actual video. It's continuous feed.
And so what we're seeing, you agree, with some kind of stop action, sort of like in a bank where they do it every 5 seconds or 10 seconds?
It captures at 30 frames per second, but I'm not sure. I'd have to see it again. But
wasn't what we just saw not an actual continuous feed, but stop action? So isn't that what we just saw?
Objection, Your Honor.
I said it's continuous.
This is voir dire. It's the integrity of the offer. So if the integrity of the offer goes to whether it's continuous or stop action, the court is going to allow it.
So it is, what was the question again, please?
Yes, what we just saw, that wasn't a continuous feed. It looked like it was a stop action. You see a car and then you don't see the car, it disappears. Wouldn't that make this stop action that we just saw?
I really can't answer that. It is continuous feed.
What you have is continuous feed, but what we just saw was not, correct?
Could I see the video again?
Could I ask that it be shown to the witness again, please?
Perhaps it is a little choppy based on what I'm seeing.
So it's choppy. That's not how you know your system operates, correct?
That is the way the system operates. It's
what you just looked at is, are you saying it freezes and then shows something after, or is it like a video? It should show a smooth.
He said 30 frames per second.
My particular system has 75, or at the time had 75 cameras on it, and it's a server-based system. So perhaps there's a little choppiness for that reason.
Well,
before you proceed, counsel, the threshold question would be, in this court's view, do you regularly view video of events that have occurred earlier in the day or in the past?
Yes, I do regularly view events during the day and also the history.
Bugdog,
Now,
get
in
to 5
that review, or in those
memberships.
reviews, do you see stop action video running, or do you see continuous video running?
I see continuous video running. And I object.
Laura Brunson, Linda Cutshaw, White Paint, Hannah Fullwood, and Idaho Mom were all get to memberships by Bugdogger. Thank you, Bugdogger.
Your Honor, the state would offer it. This is a 16-second clip out of that day, the way that it was played. He indicated it's a fair and accurate representation of what he saw. Whether it plays choppy or not, there's no indication. I can inquire whether or not there's any indication that has been tampered with or changed, but the state would offer it as a fair and accurate representation of that 16-second time frame.
Well, then, there has to be an additional question. Sir, did you view any of that video that you just saw, either prior to the police requesting it or afterward?
I did not view either before or after.
Your Honor, if I
Well,
can,
the court hasn't concluded.
I apologize, Your Honor.
Because the witness has said he didn't review that particular video before or after, he is not able to indicate whether at the time he could have viewed it, there was stop action. If he testified that when he viewed it, it was continuous, but today it's stop action, then there would be a question of the integrity. But that's not what the witness can testify to. So the court will allow it. The objection is overruled.
Happy anniversary, Dina.
Sir, I'm going to take a look at your screen, please. I'm going to show you what's been marked as file 2. Marked 73130 to 73146. Do you see the screen, sir?
Yes.
Thank you. Do you recognize the camera angle?
Yes, I do.
Where is that camera angle from?
That camera is facing Weed Street, and it's at the service or south entrance of our property.
And this video feed is actually 31 minutes long, sir, if you could just keep watching a little bit. Does that fair and accurately represent what your camera angle looked like in 2019?
Yes.
And this encompassed the time period that you gave to the police?
Yes.
And the state would offer it, Your Honor.
If I may.
Yes.
As you're watching this, you also notice this is stop action, right?
I would say it's choppy.
Choppy. But you, when you've looked at your system, let me ask you this, did you have the same system in 2019 that you have now?
Yes.
When you would watch any of your videos from these cameras, was it smooth, continuous video action that you were watching?
As I see it today?
No, normally.
Well, normally, as I see it today, I've upgraded the system, so because we've added cameras during that period of time, so perhaps it's improved over time.
Okay. Well, I'm talking about if we go back to 2019, was your video from this angle, was it a continuous, smooth video, or was it stop action where a vehicle will appear and then disappear, and another one will appear and then disappear?
It was a long time ago, back in 2019, so I can't really say.
So can you even say that this fairly and accurately represents the way your camera feed operated in May of 2019?
I would generally say yes, it is.
It is. So
Yes.
that it was a stop action camera that you had, right?
I'd object, Your Honor.
Well, now it's not a matter of voir dire, it's a matter of cross-examination. So the witness has testified that it's a continuous system. He refers to the video progression as choppy. Counsel refers to it as stop action. The witness has not testified that he had a stop action system. The witness has also testified that when he reviews video, there does not appear to be, when he reviews video of past events, there does not appear to be what he refers to as a choppy progression of the video. So the court is going to overrule the objection.
Nurse for God gives another
Sir, do you have a
membership. Thank
specific
you.
player on your camera video surveillance?
Yes, I do.
What's the player called?
It's called DW Spectrum.
And is that specific to the, I think you said, how many, 90 cameras you have now?
Currently 85 cameras.
Is that specific to those 85 cameras?
It is.
Okay, and when the police inquired with you on your video surveillance, did they come in and download the video from you?
No, I downloaded it through the help of the company DW Spectrum.
Okay, and you actually downloaded, did you then provide it to the police?
Yes, I provided a thumb drive.
Okay, and that was with the help with your company?
Yes, that is correct.
Okay. And I'm going to show you video feed 3, please. Sir, if you could take a look at the screen in front of you. And do you recognize what's depicted in that video?
Yes,
What area is that?
that is also the service entrance, the service or south side of the entrance to the property.
And does that fair and accurately represent what the video camera looked like in May of 2024 between the time period of 7:30, 1:30 and 7:30, 1:45?
Yes, it does.
Oh, 2019, thank you.
Again, I'm going to not ask the same questions again, but I thought, have you watched any of these videos before today?
Sandra Oliver was gifted a membership.
Recently, I watched them just to familiarize myself with this, but.
The particular ones that you're just looking at?
Right, but I had not seen them prior.
When you watched them, were they choppy like this?
I would say they're the same as what I recently watched.
And you mean when you watch it this year, correct?
Yeah.
But I just want to be clear, but your system at the time was not a choppy video, correct?
The system at the time,
Oh my gosh, he keeps asking
I
the
don't
same thing.
recall it being choppy or not choppy.
Ugh.
I'll just have the same objection.
Overruled.
He's
So
driving
I'm going to have
me
you take a look at
crazy.
video feed 13.
He's driving me crazy.
Do you recognize what's depicted in that video?
Yes, I do.
What is it?
This video is attached to the south side of the carriage house and is facing south.
And sir, if you could watch the video. Does that fair and accurately represent what your camera feed looked like on May 24, 2019 between 7:31:30 and 7:31:45?
Yes.
State would offer that, Your Honor.
I have no objection to this one.
What's the number, please?
That file would be video feed 13. Your Honor, this is all out of States 139.
Is States 139 offered in its entirety?
I have, Your Honor, I have one more video feed. Counsel requested I go through each one. So if I may do that first.
Yes.
Video feed 18. Sir, if you could take a look, do you recognize what's depicted on the screen?
Yes, I do.
What is depicted?
This is another camera on the north side of the carriage house, and it's facing north.
Does that picture fairly and accurately represent what your camera feed looked like on May 24, 2019 between 7:31:53 and 7:32:09?
Yes.
Okay. There are two maps on the file as well. I'll show you those now. First, mark 386 Weed Street and New Canaan. Sir, do you recognize what's depicted in that map?
Yes, I do.
Is your property depicted in that map?
Yes, it is.
State would offer that as well as, if I may do the next one and do them both together. Sir, do you recognize what's depicted on that map?
Yes, I do.
This is titled 386 Weed Street map, Your Honor, on States 139. Do both the maps fairly and accurately portray your residence 386 Weed Street and the surrounding area?
Yes, it does.
Okay. State would offer the entirety of 139, Your Honor.
Other than my previous, I don't certainly object to the map, so I'll just reserve what I had previously argued about the videos. But
States 139 admitted as full.
Thank you, sir. If you wouldn't mind taking a look at the screen behind you.
All right, let me slow it down so we can see.
Sir, is 386 Weed Street depicted on that map?
Yes, it is.
Would you mind if going up to the screen and just pointing to it?
This is the entrance to the property. The property goes all the way back and encompasses this area.
Is the entrance and exit to your property on Weed Street?
Yes, it is.
Is there any other way to get onto your property from any other street?
No, there is not.
Now, you moved your finger throughout the, I guess, entirety of the middle of the map, is that correct?
Yes, that's correct.
Is there a fence surrounding your property?
Yes, there is.
Okay. Sir, do you know where 69 Wells Lane is?
It's approximately over here.
Is there a way to get from your property to Wells Lane through the, I guess, the brush and the trees?
Not really. There's brush and trees. There's the fence, and then there's wetlands, some wetlands in between.
Okay. And the fence is the one surrounding your property?
Yes.
Okay, thank you. One more map, sir, if you can. And your property, if you wouldn't mind pointing it out, please. This is Weed Street and New Canaan map. And for the record, he's pointing to the, again, the middle bottom of the screen. Sir, what road does Weed Street interact with on the top?
Weed Street goes to Frogtown Road.
And does Frogtown Road interact with Wells Lane, or intersect with Wells Lane, I should say?
Yes, it does.
If you could just point that out. Thank you. Now, do you know where Waveney Park would be?
Waveney Park is off the screen to the bottom right.
Okay. Thank you, sir. Now I'm just going to play video feed 1. You can have a seat.
So if Waveney Park's off the screen to the right and his his property is kind of in between, and then there's Jennifer's house, and then that road that connects to his road also connects to Wells Lane. So it would make sense that that would be the bike route that Fotis would take.
Now, again, if you can explain to the jury what camera angle this is.
Sure, this is the camera on the north side of the carriage house, and it's pointing mostly east, but a little bit toward the north.
And that road going across, I guess, left to right, what would that be?
That would be Weed Street.
Oops, sorry. And I'm going to play video feed 2. Okay. Sir, if I can, I'm going to pause this. What area is this?
This is the A camera pointing toward Weed Street at the south entrance to our property.
So the camera we just saw, is that towards the right or towards the left out of this exit or entrance?
The previous camera's to the left or north. This camera's to the right or south.
Okay. And this is between 7:31:30 and 7:31:46.
That's a pretty gate. Okay, so you can see the bike right there, just barely.
I'm gonna stop it there and play video feed 3.
Hold on, let's go back. See, right here, you can barely see the bike going. Right here, it's, and then again right here, right there.
I'm gonna stop it there and play video feed 3, 7:31:30 and 7:31:145. So,
see.
And do you recognize this area?
Yes, I do.
What area is this?
That's the same camera facing Weed Street, and that's the one to the south, or as I mentioned before, to the right.
And I'm going to play video feed 13, sir. Now, this 1, 2, 3, 13, 18, are those your camera numbers?
Yes, they are.
Okay. Sir, what area is this?
This is a video camera on the south side attached to the carriage house, and it's pointing south.
The roads on the right of the screen, you can see those, are those to your property?
Yes, that's Weed Street.
Okay. Oh, that's right, you're facing Weed Street over here where my cursor is?
Yes.
Okay. And through the trees and brushes over here?
Yeah, that would be Weed Street.
Okay.
Oh, that's where I am. Hold on, let me move myself. Oh, you can see right there. That one's more continuous video.
And one more camera, sir. Video feed 18.
Hold on, let's go back. Okay, look, you can see right here. Right there. You can see. This is the clearest of them, even though it's blocked by a lot of the trees. That's a good camera.
And one more camera, sir. Video feed 18. What area is this?
That is a camera attached to the carriage house on the north, toward the north entrance, and on the right is Weed Street.
And this is 7:31:53 to 7:32:09. I'm going to play it. This is Weed Street up here.
That is correct.
Okay.
Oh, there he goes. Oh, that one's really clear. Oh, let's go back. That one's the best one yet.
This is
Hold on, let's go slow.
Weed Street up here.
That is correct.
Okay, that one's a much better video. See him over here? And you can definitely see it's dude on a bike in dark clothing. Beth Henderson, thank you for the super chat. Thank you, thank you, thank you.
Stop it there. Sir, how many hours did you give the police department back in 2019?
From 7 a.m. till 12 p.m.
I'm going to show you, Market states 140. If you can just take a look at the screen in front of you.
Maybe. Dun dun dun.
Actually, going to stop it there. Sir, do you recognize this area?
Yes, I do.
What camera angle is this?
That's the camera attached to the carriage house facing north. Weed Street is on our right, or on my right.
Is this the same camera angle that we just witnessed?
Yes, it is.
Okay. Bring it back a little bit. Okay. Sir, is that between 10:30 and 10:30, well, 10:30:05 and 10:30:15 seconds?
Yes, it is.
Did that fairly and accurately represent what your camera angle depicted on May 24, 2019?
Yes, it is.
Did you provide that to the police?
Yes, I did.
State would offer 140, Your Honor.
No objection. 140 admitted as full of case exhibit.
And briefly, sir, if I could just turn your attention to the screen and
Oh,
sir, did you indicate where Waveney Park is in relation to your residence?
Yes, I did.
And where was it?
It is approximately a mile away
Okay.
toward the south.
Thank you, sir. I have nothing further, Your Honor.
So, there goes the Suburban.
No questions. Sir, thank you. You may step down.
Thank you.
No questions after all that. Lord of mercy.
Thank you, Your Honor. I have nothing further at this time.
Thank you. Does the state have witnesses to call tomorrow morning beginning at 10?
I do, Your Honor.
Thank you. So, ladies and gentlemen, that concludes today's session. Plan to resume tomorrow at 10 o'clock.
Okay, so
Please.
since this one ended a little early, we can get into a little bit of 22 before we finish today. Okay.
For quick transaction, criminal business is now open and settled. The Honorable Judge Randolph presiding. Good morning, Your Honor.
Good morning. Please be seated. Thank you. Is the state ready to proceed?
I am, Your Honor.
Thank you.
Your Honor, may be heard briefly?
Yes.
Your Honor, if the state intends to call Mike Mann first, the only thing I'd like to do is admit and mark as an exhibit 4 pages. I can pass up a copy. I don't plan to admit it, but I do need it marked for ID.
I don't plan on calling Attorney Meehan first, Your Honor. I have a lay witness here.
Okay, we can address that after. Thank you, Your Honor.
And I would also indicate if counsel wishes to introduce anything, she could do so in the course of her cross-examination. I would like a copy, and I can hand up counsel copies of what I have for the witnesses as well. I do have a disc for Mr. Hudkins. I can hand that over, and a copy for the counsel. Is there anything that needs to be addressed before the jury needs to come out?
No, Your Honor, I thought it would be smoother to do it that way, but we can do it once I get up for cross. That's fine.
That's fine. If I can, Your Honor.
Bring the jury up, please.
Bring the jury.
It's only 2 steps.
Okay, so this is yesterday.
Continue with the
Watch a little
state
bit of
case.
Thank you, Your Honor. The state would call Garrison Hudkins to the stand. If I may just approach the clerk.
Yes.
Yeah, I figure as long as I'm feeling good today, we'll keep going a little bit.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Please state your name and spelling for the record.
Garrison Hudkins, Hudkins.
So you may be seated.
Thank you. Good morning, Your Honor.
Good morning, sir. How are you?
Good morning. How are you?
Mr. Hudkins, where do you reside?
2 Jefferson Crossing,
And how long have you lived at 2 Jefferson Crossing?
since 2010.
Who did you buy your house from?
We bought our house from Fotis and Jennifer Dulos.
When did you first meet Fotis Dulos?
We met Fotis when we were looking for a home. We moved from New Canaan to Farmington. And when we were looking for a home, this home was for sale. We made a phone call and we went and visited the home. And Fotis was a builder of the home and he showed us the home himself.
Did you also meet Jennifer Dulos?
Yes, we met her at that same time when we visited the home.
And who owned the property? Who owned your house basically before you purchased it?
I'm sorry.
Who owned the property before you purchased it?
Fotis and Jennifer owned it themselves.
And after you purchased it, where did they move to?
I believe they moved to a home in Avon, and while they were building the house for Jefferson Crossing next door to us.
No, you say next door to you. Where is 4 Jefferson Crossing?
4 Jefferson Crossing is the home.
Thank you.
I'm going to use directions immediately to the east of our home.
Now, I'm going to actually, may I just have one moment with counsel, Your Honor?
Yes.
Thank y'all so much for the gifted memberships.
Your Honor, state would offer 141. I don't believe there's any objection. I would ask that it be moved into evidence.
Stage 141 admitted as full.
I'm going to open a file
Sandra Oliver, happy 9
labeled
months.
map. I can and ask you, sir, if you can just take a look at the screen behind you.
Okay.
And do you see where Jefferson Crossing is on that map?
I do.
Would you mind standing up, sir, and pointing to it?
Jefferson Crossing, the road is right here.
Are you also familiar with Mountain Spring Road in Farmington?
I am.
Is that depicted on the map as well?
Mountain Spring Road was
Yes, it is.
the
Or
workhouse.
could you please point to it, please?
Mountain Spring Road runs here all the way down to Route 4.
Thank you. And for the record, you're pointing to the bottom left middle of the screen?
I am.
Thank you. Sir, if you wouldn't mind standing up there for a minute, I'm going to open a file marked map of Jefferson Crossing. And sir, do you recognize what's depicted on the map?
I do.
What is depicted on the map?
Well, primarily, it is the road Jefferson Crossing in the area of Farmington. To the west, I'm going to use directions northeast, southwest. To the west is Eli Road. Jefferson Crossing, runs east-west into a cul-de-sac. There's 7 homes on Jefferson Crossing. It's a private road.
I'm going
We have a
to
homeowners association.
Well, I'm going to scroll in a little bit. Is your residence depicted on this?
It is.
Could you please point to it? Okay. And Jefferson Crossing?
This is Jefferson Crossing down the cul-de-sac.
And the road to the left, please, going, I guess, north and south?
From here down is Eli Road.
And sir, where's 4 Jefferson Crossing?
4 Jefferson Crossing is right here.
Now, sir, you indicated this was a houses built by Fotis Dulos. Did you also have a housing association?
We did. We had a homeowners association.
Okay, if you wouldn't mind having a seat. Who was involved in the homeowners association?
Well, all the homeowners were members of the association.
Could I at least have a timeline, Your Honor? This is now the foundation, at least in terms of when was involved.
Sure. We'll start with around the time period of 2017.
2017.
Yes, sir.
There were all the residents of Jefferson Crossing were members of the homeowners association.
Including Fotis Dulos?
including Fotis Dulos.
And did you have meetings?
We did.
And where were the meetings held?
Up until 2019, we had those meetings in Fotis's offices at 4 Jefferson Crossing.
Prior to 2017, would Jennifer attend those meetings?
She would.
Okay. And after 2017, did she attend any of those meetings?
So the meetings were usually held in the beginning of each year. So it'd be in the beginning of 18, beginning of 19, and et cetera. So she did not attend the meeting in the beginning of 18.
Now, in 2017, did you learn that Jennifer had left 4 Jefferson Crossing and Fotis Dulos?
I did learn that, yes.
Prior to 2017, what would you characterize your relationship with Jennifer Dulos as?
Very friendly. I mean, Jennifer was a great neighbor. Our kids attended the same school. We saw them at school functions. The kids played. We saw them in the neighborhood. We saw them out and about. We had gone to their home for Greek Easter, as an example. They came to our home for like an Oscar viewing party. We went out to dinner with them a couple times in West Hartford Center. So, neighborly.
Did you ever meet Michelle Troconis?
I did.
When did you meet Michelle Troconis?
In August of 2017.
Could you please explain that first meeting?
Yes. Fotis called and asked if he could come over for a drink to introduce us to Michelle. Michelle, you see, was moving into 4 Jefferson Crossing. And Michelle also had a daughter that was my daughter's age, and they were going to be attending the same school. So Fotis wanted to introduce Michelle and her daughter to our family as a way to get into the neighborhood, to get to know the neighborhood.
And when was that?
It was in August of 2017.
Now, I'm going to draw your attention to Memorial Day weekend of 2019.
Okay.
Did you learn that Jennifer had been missing since May 24th?
I learned mid-morning on the 25th that Jennifer was missing.
How did you learn that information?
Well, in the early morning of the 25th, a neighbor had called me before.
Objection, hearsay.
Well, the state is probably not offering for the truth, but to indicate how this witness came to know about Jennifer Dulos being missing. Overruled.
In the early morning of the 25th, a neighbor had called me on my cell phone, which during the work week would not be unusual, but on a Saturday it would, alerting me to the fact that an unmarked Farmington police officer was on the road. And he had no indication as to why he was on the road. And he asked him, but the Farmington police officer would not tell him. Later that morning, as I mentioned before, we moved from New Canaan to Farmington. Friends from New Canaan had sent my wife a news article.
Objection, hearsay.
Overruled.
If you can, sir, is that how you learned about Jennifer Dulos being missing?
That's correct, from a news article, correct.
Okay. Did you speak to Fotis Dulos that weekend?
I did.
Where were you when you spoke to him?
I was in the front of my house in my driveway.
What were you doing?
I was taking my dog for a walk.
What did Fotis Dulos look like?
He had a shaved head, and I did not recognize him initially.
What did the dog look
He
like?
was riding a one-wheel scooter past my home up towards Eli Road. And that was unusual to see someone doing that, especially towards Eli Road, but more importantly, I didn't recognize who it was. It is a private road, as I mentioned. So I didn't know who it was.
Around what time of day was this?
About 8:45 in the morning.
Did you speak to him?
He did approach me, and that's when I recognized his voice and recognized it was Fotis.
What did he say to you?
Well, at first I said to Fotis, how are you? And his response to me was, Jennifer's missing, right?
And what did you say?
I said to him, yes, I'd heard that. I hope she's okay, but I have not heard about the children. I hope they're okay.
What was his response?
His response was, he asked me how long we retained our security video and to make sure it didn't get deleted because he needed to prove that he was there on Friday.
Did he say anything else to you?
He did.
What did he say?
He talked about going to New Canaan on Saturday and how the police seized his phone. He talked about his attorney telling him that they need to develop a chronological timeline of where they were on Friday so that they can produce it if needed.
Did he use the word they?
He did use the word they.
That they needed to develop a timeline?
He did.
Did there come a time when Fotis Dulos spoke to you again?
He did.
With respect to your camera and video surveillance?
He called me on May 30th, on that Thursday, asking to come over at that point in time to review our video.
And did you allow him to do that?
I was at the office. I was working, and I told him that wasn't a great time to do that.
Did you ever speak to him again?
Not until the summer.
Wow. Now, I do want to ask you about your video camera and your video system. Did you have cameras in place on May 24th?
I had 2 cameras in place on May 24th.
What type of cameras were they?
They were Ring cameras.
And where were they located?
One was located on the corner of our garage facing the parking area near our 4 garage doors, and one was a doorbell cam by our mudroom facing out the eastern part of our driveway towards Jefferson Crossing.
Did you subsequently get a third camera?
I did.
When did you do that?
I got that camera on May 26th.
Where did you place that camera?
I placed that camera in the northwest corner of the house facing out towards the road.
If you can, sir, I'm going to scroll into the map behind
So he
you.
got another camera right after he talked to Fotis.
Would you mind standing up and just pointing to where you installed that camera
The
on
one-
May 26th?
That camera would have been installed on this corner of the house,
Okay, and what area did it capture?
this area towards Jefferson Crossing.
And you installed that after your conversation with Fotis Dulos?
I did.
And after you had learned that Jennifer had been missing?
I did.
Sir, was that camera motion activated or a continuous stream?
It was motion activated.
Could it pick up the motion that was on the road, cars passing and the like?
Yes, it could.
And was the time accurate?
Yes, it was.
Now, how long did you say you lived at Jefferson Crossing? You can have a seat, I'm sorry.
Since 2010.
And for how long did Fotis Dulos reside at 4 Jefferson Crossing right next to you?
I believe they moved in the 2012-2013 timeframe.
Okay, so between 2012 and 2019, particularly the time period of 2019, are you familiar with the vehicles that were associated with Fotis Dulos?
I am.
What were those cars?
There was a black Suburban, there was a Ford Raptor, there was a white Jeep Grand Cherokee, there was a Porsche Cayenne, but that hadn't been seen for a while. I believe that was crashed. And then from time to time, there was a red Toyota Tacoma that was parked at 4 Jefferson Crossing for periods of time.
Who owned, to your knowledge, the red Toyota?
Objection, hearsay, no foundation.
Well, the question is, who owned, to your knowledge, the Toyota Tacoma? Well, the court's going to sustain the objection.
Mr. Huggins, do you know somebody by the name of Pavel Guilmini?
I do.
How do you know him?
Pavel worked for Fotis for a long time. He did a lot of maintenance for us, for the association up and down the road. And part of that maintenance was he did all the snow plowing for the road and for our homes, for a lot of our homes up and down Jefferson Crossing.
Do you know what vehicle he uses to plow the roads?
Yes.
What vehicle is that?
It was a red Toyota Tacoma.
Did you see that vehicle parked at 4 Jefferson Crossing from time to time?
I did.
Okay, particularly in 2019, did you see that vehicle parked?
I did.
Where was it usually parked?
Um,
Okay, check.
It was usually parked in this area,
How could you see it from, you're putting to, I'm sorry, the lower right-hand corner?
kind of the southern part of the driveway.
Okay. And were you able to view it from the road?
We could view it from our driveway.
Now, sir, I'm gonna, at some point, did the New Canaan Police or State Police come to your residence and speak to you?
They did. They came to our residence on May 27th.
And what did they ask of you?
So 3 officers came, 2 from the state police, 1 from New Canaan.
Objection, non-responsive.
Well,
What did they do?
well, the court is going to allow Attorney Manning to ask the question again.
What did they ask you to do, sir?
Well, first they asked for our video. They also asked what we saw, the cars that we knew were used from time to time at 4 Jefferson Crossing. They asked about the relationship as we knew it between Fotis and Jennifer.
And did you allow them access to your video camera that day?
Well, I did not. We were frankly on our way to a Bruins game, and we spent about an hour with them and then hustled off the Bruins game. And when we returned home, we then emailed them the videos.
Okay. When you say you emailed them the videos, what do you mean by that? If you could just explain.
So with the Ring camera, you can download each snippet, and I downloaded what was not us tripping the cameras and emailed it to Officer Deke in New Canaan.
Now, on, what day was that, by the way?
I'm sorry.
That
what
you
day?
downloaded the cameras and emailed them to
I
the...
think we started downloading them on when we got back from the Bruins game, and then emailed them on that Tuesday.
Did that include was that before or after the new camera was installed?
Well, we emailed them after the new camera was installed.
Did there come a time when you reviewed footage from May 29th of 2019?
There did.
When did you do that?
Around July 27th, I looked at it.
Why did you review May 29th in July?
Well, when I spoke to Fotis on the 26th, he requested that I not have anything deleted. I did not know what the retention policy was for the Ring service plans. So then I learned at that point in time it was 60 days.
Objection, hearsay.
Well,
What do you learn?
well, the phrase, "what I learned," need not be considered hearsay. The court does not know what the balance of the statement is.
If I may, Your Honor, it's the fact that the ring camera, his retention period, he learned was 60 days. State's not offering that for the truth of the matter that it was 60 days, just what he did with that and why, what steps he took after he learned that information. So it's not offered for a hearsay. I would also.
Objection is withdrawn.
Thank you. Sir, if you can continue.
So that was at the 60-day time period. And when I was originally requested by the officers who came to our home the 27th, they were only looking for video from the 24th. So when I was looking at all the cameras, I was looking to see what they had and preserve that video so it wasn't erased.
And did you find, or did you preserve any video or send it to the police in that July date?
I did.
What did you send?
I sent them, I believe, 2 videos of vehicle movements on Jefferson Crossing on May 29th.
Why did you choose those videos?
For a few reasons.
Okay, May 29th is the car wash day, too. So it's interesting that, we'll see what he says about it, but that's interesting. May 29th is the day that Fotis took the Tacoma to the car wash.
Number one, I wasn't asked for video after the May 24th timeframe. But in seeing the movement of those 2 vehicles in tandem, coupled with my odd interaction with Fotis on the 26th, coupled with what was well-known, publicly available.
Here we get now getting into hearsay.
Well, if it appeared in the media, it's well-known, overruled.
What was well-known at the time of movement in the north end of Hartford, that movement just struck me as odd.
Did you send those clips to the police?
I did.
Sir, I'm going to show you what has been marked as file 529804. I'm going to stop it first, sir. What are we looking at?
So this camera's, we'll call it facing north from the northwest corner of my home, out over my driveway and my front yard and onto Jefferson Crossing.
And what time is this recorded?
8:04 in the morning.
So this is about an hour before they pull into the car wash with the Tacoma. Okay, there's the Suburban. Looks like the Suburban's pulling into Fort Jefferson Crossing.
Okay, sir, I'm actually going to ask you a few questions about this video if I can. Now, as we play it, this street in the middle, do you see the cursor?
I do.
Is that Jefferson Crossing?
That is Jefferson Crossing.
Okay, where is Fort Jefferson Crossing?
So,
Wait,
to the
that
right
couldn't
of
have
the
been the Suburban. Hold on, that couldn't have been the Suburban because the Suburban had a thing on top of it. Hold on.
Where is street in, if I can? Okay.
That doesn't have the thing on top, so that's not the Suburban. Oh, the Yukon.
Okay. Sir, I'm actually going to ask you a few.
Okay, remember the. I could be wrong. Let me just stop speculating and we can listen. Well, no, I'll tell you what I'm thinking because I could be wrong, but we'll see. Remember on the car wash videos, there was Michelle had rented. Because at this point they've taken their cars, I think, right? Or was this? Yeah, I think this was like right when they took their cars. So she had rented that Yukon, and remember we saw the Tacoma pulled into the car wash. Fotis was driving it, and then Michelle was driving that rented Yukon, and then he got into the Yukon with her. So it looks like that's what that might have been.
Questions about this video, if I can. Now, as we play it, this street in the middle, do you see the cursor?
I do.
Is that Jefferson Crossing?
That is Jefferson Crossing.
Okay. Where is Fort Jefferson Crossing?
So, to the right of the screen, you'll see a tree line, and Fort Jefferson Crossing is to the right.
And where's the driveway to Fort Jefferson Crossing?
It's probably about 50 yards to the east of my driveway.
If you can, sir, would you mind pointing to it on the screen?
Sure. So Jefferson Crossing will be behind these trees right here.
Okay. And if I were to bring the file back, around 14 seconds, do you see a vehicle in that area?
I do.
Okay, actually. Is that vehicle turning into the driveway for Jefferson Crossing?
Yes, that vehicle is turning the driveway for Jefferson Crossing.
Okay, is this the video clip you sent to the police?
That's one of them.
You can have a seat, sir. I'm gonna play, I apologize, 529-856. If you could take a look. And I'm gonna stop it there briefly, sir. Is this the video that you sent to the police as well?
That is one of them, yes.
And why did you send this clip?
Well, as I said before, what we knew
I'm gonna hit play.
in July, what we knew, based on the media reports, it was different.
Objection. The fact that we're in these reports is one thing, but now he's getting to what he learned in the media.
Well, the question was essentially, what's the reason you sent these videos to the police? And this witness is explaining his reason.
Yeah, but the fact that it, based on something in the media, answers the question, I would submit that anything else would be just clear hearsay.
Well, the witness is explaining what he did and his reasons for it. Overruled.
If you can, sir, explain why you sent this video to the police.
So again, based upon that interaction I had with Fotis on the 26th, based upon the fact of what we had learned from the media at that point in time and the visits to North End, I had two cars leaving in tandem, which was not consistent with normal vehicle movement patterns.
And you've lived at that residence for how many years at
Okay,
that point?
can we just take a moment to like appreciate this guy and his he's like, well, based on what I knew and what I'd heard, that's not consistent. Like, he is totally like one of us. Like, he would be like what one of us would be doing. We'd be like looking at stuff like, that don't match. I'm gonna send this in. Like, he's very he's on it, doggone it.
9 years.
Now, you indicated you were familiar with the vehicles and the vehicle patterns.
Yes.
Do you recognize this vehicle, the red truck?
Yeah, that's Pavel's truck.
And what about the vehicle behind it?
Well, that vehicle is that's a GMC Yukon XL. That was a rental.
Okay. Was that the vehicle that we saw in the previous clip?
It was.
I'll say that's the 804 one.
He's good. Okay, now it's returning back.
And I apologize, I wasn't sure if I said the time of the second video. Just pause it there. 5:29 at what time?
8:56 and 43 seconds.
I may just have one moment, Your Honor.
So 8:56. So they leave, and then they pull into the car wash at 9:11.
Sorry, with respect to, I'm not sure if I got your answer. With respect to the 804 clip and the 856 clip, that black vehicle, is it the same vehicle?
It is.
Thank you. I have nothing further.
Cross-examination.
Wait, what time did it pull back in? Where's the time on this? It doesn't.
And I apologize, I wasn't sure if I said the time.
Dang, I need her to move her stuff.
It's the 804 one. And I apologize, I wasn't sure if I said the time of the second video. Just pause it there. 5:29 at what time?
8:56 and 43 seconds.
I may just have one moment, Your Honor. Back to
I wanted to see that.
Cross-examination.
I'm just going to start with what we were just looking at a minute ago. You testified that you were very familiar with the comings and goings of all the vehicles at the Dulos home or at his office. Is that correct?
I don't think that's what I said.
You said it was unusual for two cars to be driving down Fort Jefferson Crossing at the same time, correct?
I did say that.
And you said that the vehicle that you saw was a GMC vehicle?
A GMC Yukon XL.
And you knew it was an XL?
Yes.
And are you in the car business?
I am.
And which company, what company do you sell cars with?
We have an auto auction.
Oh, okay. And you had listed the cars that were associated with the Ford Group in the Dulos home, correct? You mentioned 3 or 4 vehicles?
I did mention some vehicles, that's correct.
Right. Did you ever meet any of the other employees at the Ford Group?
Yes.
So you knew, for example, did you know an Andy Loomis who worked there?
I did not know Andy, no.
Did you know a Guillaume Villaday?
I did know Guillaume.
Did he drive one of these cars?
At that point in time, Guillaume wasn't around.
He wasn't there in 2019?
I don't recall him being an employee in 2019, no.
All right. So you kept track of who was working at what time at the Ford Group?
I just don't recall seeing Guillaume around in 2019.
Didn't realtors also come back and forth from the Ford Group offices?
Of course they did.
Did you take down any of those videos or record any of those?
No,
Did you send any others besides the 2 we just saw to the police
I did.
from May 29th?
I don't recall how many I sent from May 29th, but I did send a few.
So we're only seeing the 2 that someone else picked out among the ones you sent, correct?
Correct.
Let me just ask you, and incidentally, a GMC Yukon XL was not a car that was generally, as you said, associated with being at the residence of 4 Jefferson Crossing, correct?
Not prior to May of 2019, no.
And did you look at a whole bunch to see how many days that Yukon stopped at that house?
No, I did.
And I assume, as being involved in the auto business, you don't work out of your home.
I do not.
So let me just then, you talked about meeting Mr. Dulos and meeting Jennifer, correct?
I did.
And knowing their children, right?
That's correct.
And at some point, you said in August of 2017, you were introduced, I think you said, to my client, Michelle Troconis?
That's correct.
And her daughter was the same as one of your children?
That's correct.
Did your children go to Renbrook School?
Yes, they did.
And then she went to, her child went to Renbrook too, right?
I believe for 1 year, yes.
And I just want to be extra careful about the conversation that you had with Mr. Dulos. I think you said it was the Sunday after you had heard that Jennifer was missing. Is that what you said? It was like a couple of days later?
I did say that, yes.
And you called saying that it was on the Sunday, the 26th?
It was on Sunday, May 26th.
Okay. And according to what I just wrote down, he came up to you and you said you first didn't recognize him. Is that what you said?
That's what I said.
So when's the last time you had seen him before that you said you didn't recognize him?
Oh, that was 5 years ago. I don't know the answer to that.
All right. You didn't see him like on a daily basis, right?
No.
He wasn't someone who hung out in his yard and you're out by the mailbox chatting with him.
Not when you have 2.5 acre properties with wood between you, no.
But you did know, I assume, that he was involved in competitive water skiing. I assume you knew that, right?
Oh, yeah, sure.
So you also knew that in the past, he had cut his hair really, really short because as a competitive water skier. Didn't he tell you about that?
Objection. Calls for hearsay.
Well,
Speculation.
Well, the question is, there was a narrative and then there was a question. He was a competitive water skier. He cut his hair short, which is not a question. Didn't he talk to you about being a competitive water skier? So the question is, did he talk to you about being a competitive water skier?
Okay. Can you answer that question?
I can answer that question.
All right.
The answer is yes.
The answer is yes. Did he ever invite you to watch him do any of his tricks or jumps or anything down at the water skiing lake down the street?
Objection. Relevance outside the scope.
Your Honor, we went through 7 years of the relationship. I'm at least entitled to ask a couple of questions about the nature of that relationship.
Well, did he ever invite you? Is a preliminary question. Did you ever go would be more focused.
All right. It's a preliminary question. Did he ever invite you to go watch him?
No, he did not.
And I take it you never went and watched him?
No, I did not.
Perform or compete?
No, I did not.
But you also know that in prior years, he'd cut his hair for water skiing.
Objection, Your
correct?
Honor.
Well, the question really is, did he have the same kind of haircut in prior years? That's the question. And if that's the question, overruled. If that's not the question, sustained.
Well, that'll be the question then. In prior years, do you recall that he had cut his hair short?
As I say before, he had cut his hair short, but I've never seen it that short. I did not recognize him when I saw him that day on the 26th.
Okay. So if I showed you pictures from previous years, that would not refresh your recollection as to whether he had ever cut it that short before?
Objection, Your Honor.
Well, the witness did not indicate he needed his recollection refreshed or he didn't remember. He said he'd never seen it that short, sustained.
In any event, he came up to you that day and he told you that let me get this straight. that his attorney said that they need to develop a chronological timetable, correct?
He used different words, but I'm paraphrasing what he said, yes.
Right, but you were asked specifically about whether or not, and I think the specific question is, do you recall that he said the word "they" in his request regarding your cameras, right?
I'm sorry, can you repeat that one more time?
Yeah, I believe the state asked you specifically, did Mr. Dulos use the word "they" in his statement that his attorney said they need to develop a chronological timeline?
Yes.
You remember that word being said specifically, correct?
I do.
So in your response, the "they" referred to his attorney and him, correct?
Objection.
Well, the witnesses testified that the word "they" was used. And the question now is essentially, what did the witness think "they" meant? Sustained.
You gave a written statement, did you not, back in 2019?
I did.
Did you review your statement?
I did.
And your statement was actually taken under oath, correct?
That's correct.
And it was given on June 14th, 2019, right?
That's correct.
And didn't you, in your sworn statement, write down or state that Mr. Dulos said it needed to show that he never left his house and that he was here Friday? Do you remember saying that in your statement?
Can I read a copy of my statement?
Of course. Let me mark it. When was the last time you saw your statement, by the way, sir?
Oh, I looked at it maybe a couple weeks ago.
Yeah, just have this marked and stapled, please.
So he's going over all this about the timeline and what they meant. In any event, he says that so much, Elizabeth. In any event.
Showing to counsel. Marked as Exhibit EE for ID. All right. May I approach?
Yes.
Now, sir, you're entitled to read the entire statement if you wish, but I'm going to call your attention to the paragraph on the subject that we're talking about right now. So if you need to read more, please feel free, but I'm going to call your attention on page 2, just to this paragraph there, see if that refreshes your recollection about what you told the police in your sworn statement. Did that refresh your recollection?
It reflects my recollection of what's in the statement, yes.
Right. And you never used the word "they" in your statement with regard to that statement by Mr. Dulos, did you?
I did not in the statement, no.
That's what all this
I
is
would object,
about.
Your Honor. At this point, counsel is mischaracterizing the statement and the word "it" and "they." From my reading, the word "it" refers to his video camera system. The witness testified that the word "they" was in reference to a timeline they needed to develop.
Well, the statement speaks for itself, Your
Well,
Honor.
then the court has to read the statement.
May I approach?
Yes.
This paragraph here, Your Honor. And I believe it's the state that's misrepresenting what it says.
Oh my gosh. This judge is like so over it. So he's trying to, he's focusing on the fact that when she asked this witness if he was saying that they needed to come up with a timeline, and he said he specifically remembered, she's like, do you specifically remember him saying they? And he said yes. And so now Shoehorn's like, you didn't use the word they in your statement. So he's trying to say that he's giving inconsistent statements. Because he didn't use they in this statement, but he's also not pointing to him saying I. He's
Is the
saying
defense
it.
referring to the first full paragraph on page 2 of 3 of the statement?
Yes, Your Honor.
Well, counsel, would you point out the language that brought your concern?
statement right after the question mark there.
Well, of course, the statement is not in evidence, but the court does not see how this statement is in any way inconsistent with what the witness testified to.
If Your Honor pleases, I will note the word "they" does not appear anywhere in that paragraph. The word "he" and "it" appears.
Oh my gosh.
Well, the issue, as the court understands it, is what did Fotis Dulos say concerning the video?
Exactly, Your Honor.
That they needed it. That's how the court understood the testimony.
Right.
Now, the court cannot, at this point, understand whether they refers to the defendant and someone else, Fotis Dulos and someone else, or the police. They needed it. So at this point, the court is going to sustain the objection.
I just want to be clear. Anywhere in your statement regarding your conversation with Mr. Dulos, did you ever use the word "they" in describing the conversation in your written statement?
I'm sorry, I don't understand that question.
Did the word "they" appear anywhere in your written version of your conversation with Mr. Dulos?
Not to my recollection.
Well, would looking at it again refresh your recollection?
The court is not going to allow that because you're asking the witness to find the word "they" in the statement. The word "they" is not in the statement. The court does not even follow what "they" refers to. So to essentially cast that failure to use the word "they" as an inconsistent statement is not persuasive.
I love this judge. I love
During the
this judge.
time that you met with, you said you knew Mr. Dulos over the course of many years, correct?
I did say that.
And you testified that, you had like a neighborly relationship with him, correct?
I would describe it as neighborly.
So you got to see him in scenarios other than in this formality of requesting to see or that you keep your videos, correct?
That's correct.
But you wouldn't consider Mr. Dulos a friend, would you?
I would not.
In fact, when you talked to the police, you told them that he was condescending towards women, correct?
Oh.
He could be condescending towards women, yes.
Is there a reason that you suggested that to the police at that time?
There was a reason.
Could you tell us what that is?
He was very condescending to my wife.
Oh.
And not just your wife?
I can tell you the reason why I said that, and the reason was he was condescending towards my
Okay.
wife.
And you found that a little offensive, I take it?
I did.
Let me just have a moment, Your Honor.
Oh, dang. I mean, it's not surprising, but.
Nothing further.
Nothing further, thank you.
Okay, you may step down. Thank you.
I love that judge was just like, okay, no, we're not going to sit there and let him try to find the word "they" written somewhere in that statement. He's so tedious.
Your Honor, may I have a moment with Attorney?
Yes.
I'm not sure who is doing this.
He's so tedious.
I leave it up to the court if Your Honor wishes, we can take a short recess, or if I can call him in and we can start.
Well, there are matters that counsel wish the court to take up, and, well, would counsel approach, please?
Sidebar? Sidebar. Dang.
Your Honor, if I may. Mike Meehan to the stand, please.
Oh, Meehan, this is the guardian ad litem.
Morning. Yeah.
You could please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
Certainly. Michael Meehan, M-E-E-H-A-N.
Mr. Mr. Meehan, you may be seated.
Thank you.
Here we go.
Good morning, sir.
Good morning.
Attorney Meehan, you are an attorney practicing in Connecticut.
I am.
Are you allowed to practice law anywhere else?
No.
Do you have your own law firm?
Yes.
What is it called?
It's called Meehan Law now.
Do you work with other attorneys in your law firm?
I do. I have 4 other lawyers in my office.
How long have you been an attorney?
1996.
And do you specialize in a particular field?
Currently, most of my practice focuses on family law. I still do practice criminal defense work. I used to do a lot of that. I don't do it as much anymore. And we keep a very small amount of civil litigation in the practice as well.
As part of your work in family law, do you frequently get appointed?
I thought about this, Elizabeth. He could be trying to say like, oh, well, you didn't even like Fotis. You said he was, condescending to your wife, so you didn't even like him. So you're just trying to show stuff that could get him in trouble. Or he could be trying to paint Fotis into be the bad guy so that, it can all be pinned on Fotis. It's like he goes back and forth sometimes. I feel like sometimes he's trying to pin everything on Fotis, and sometimes he's trying to like say Fotis didn't do anything. So I think he kind of goes back and forth, but he just, he's so tedious.
Appointed as a guardian ad litem.
I have.
What is a guardian ad litem?
A guardian ad litem is a representative of children here in Connecticut. It could be either a lawyer or a psychologist. You have to be either licensed by the state for either position, and you have to now be certified to act as a guardian ad litem.
And what are some duties and responsibilities? Well, is guardian ad litem also called a GAL?
Correct.
Okay. What are some duties and responsibilities of a GAL?
The primary duty and responsibility of a guardian ad litem is to represent the best interest of children. So in essence, one might say you become sort of the eyes and ears of the court. Typically, guardians are appointed in family matters where there are either limited issues or a general amount of disputes regarding issues of custody, and custody disputes include decision-making issues for the children between both parents and or where the children live and or how frequently they get to see the other parent. And so typically, when parties in a family matter are in disagreement on those issues, many times either the court will on its own motion or the parties will either move the court or the parties will agree for the appointment of a guardian ad litem.
And were you appointed as a guardian ad litem in the Dulos versus Dulos case?
I was.
When were you appointed?
My recollection is that I was appointed sometime in the end of August of 2017, on around the 24th of 2017.
And had the divorce already started?
It had.
How many children were you GAL for?
5 children.
What were their names?
Petros, Theodore, Constantine, Christian, and the youngest one went by Noel, but I think she was Cleopatra Noel.
And in 2017, did you meet with Jennifer Dulos?
I did.
When did you first meet her?
I met Jennifer probably shortly after my appointment, sometime in August of 2017.
Where was she living at that time?
She was living in New Canaan.
Did you ever meet her at 69 Wells Lane in New Canaan?
I did.
And did you meet Fotis Dulos as well?
I did.
When did you meet him?
I met Mr. Dulos again around the same time, shortly thereafter, sometime in August of 17.
And Michelle Troconis, have you ever met her?
I have.
When did you meet Michelle Troconis?
I met Mr. Troconis sometime after I met Mr. Dulos in August of 17. It would have been sometime, within that month of September or so.
In 2017, did Fotis Dulos ever express to you a desired outcome between himself, Michelle Troconis, Jennifer, and for Jefferson Crossing?
Yes.
And what was his desired outcome?
Well, when I met with Mr. Dulos, he had expressed his preferences and what he wanted to see happen at the conclusion of the case, which is ultimately, it was his goal to have everyone live in the house together, that being Ms. Dulos, along with the children, along with Mr. Troconis and her daughter as well.
He indicated he wished
no, sir.
Jennifer, Michelle, and all the children reside at Fort Jefferson Crossing?
Correct. No, sir.
When was that?
I wish somebody would ask me to live in the home with me, my husband, our 5 children, plus his mistress and his mistress's daughter. I'd end up on an episode of Snapped.
That was, I think, early
No,
on in
sir.
one of my first interviews with him, sometime in 17.
No, sir.
Now, where was he living between 2017 and 2019?
He was living at Fort Jefferson.
As a GAL, are you or do you attend every court hearing?
Yes, unless I'm excused by the court for some reason. Sometimes there's financial disputes that don't require the guardian's attendance. I wouldn't attend to that.
In November of 2017, was a parenting plan in place?
Yes, I was able to help the parties reach an agreement on a parenting plan somewhere around the month of November of 2017.
And what exactly is a parenting plan, if you could just explain?
A parenting plan is a document that gets filed in family cases, which really defines the issues of custody. Who gets to make what decisions for the children, how those decisions are made, where do the children live, how frequently do they see each parent, what happens during holidays, what happens during vacations. In essence, all of those things get boiled into a parenting plan. And at that time, the parties had, by agreement, reached a temporary agreement regarding parenting.
In November 2017, based on that plan, was Michelle Troconis and her daughter allowed to have contact with the children?
Yes.
How long did that last?
Well, it lasted, at least from the time of that plan, ultimately to some point in time in January of 2018.
Okay, so that's not a very long time. Now, he's saying that, because remember, we've heard a lot about how the kids were not supposed, according to the court documents, were not supposed to be around Michelle at all. And so, but the original agreement they came up with in November of 2017 was that they could, and it was only 2 months later that that all of that changed. So I think that's, I don't remember having read that their original parenting agreement had it to where the kids, that Michelle was allowed to be around the kids. So that's, but that only lasted 2 months.
Thereabouts.
And what happened in January 2018?
Well,
if I can just withdraw that, I'll strike that, Your Honor. It's an open question. In January of 2018, what happened with respect to custody or parenting plans with relation to Fotis Dulos?
Mr. Dulos had his parenting time suspended by the
So
court.
this is when everything changed.
And what does that mean?
It means simply he was not permitted to have any contact with the children.
And that also includes Michelle Troconis?
Those orders at that time extended to Mr. Troconis as well.
For how long was Fotis Dulos not able to have any contact at all with his children?
There was a period of time for which he had no contact. Contact was gradually reintroduced sometime in the month of February of 2018, and he was able to have then limited supervised contact with the children.
What is supervised visitation?
Supervised visitation is a form of visitation that the court will typically utilize to make sure that the safety of the children are being protected, and it would require the presence of a third party, either during the entire visit or at certain times of the visit. And the third party could be anyone from, a family member to a paid professional.
For how long did that supervised visitation plan stay in effect?
Well, it was an order, not a plan. So the supervised visitation order remained in effect from January of 2018 through really the time period for which the case was dismissed.
And thank you for clarifying that for me. Order versus plan. Can you just explain the difference?
Sure. So when I use the term order, that was as a result of something that the court had issued, a ruling, a decision, an order. The plan, as we were talking about before, ultimately became an order, but it was because of agreement of the parties.
Okay. Oops. Dang it. I didn't mean to hit that. What time were we at?
Weeks ago.
Yeah, just have this mark.
Yeah.
For that prior period of time from January.
I'll find it. So that's an important thing too, I think, for the jury to hear. This is one of the things that they had made the big deal about. Sorry, I was trying to find the place. Because this is good for the jury to hear, because this was an order. I know I'm not allowed to hit buttons. I know, I'm sorry. But this was an order of the court. So this is one of the things, they're not allowed to talk about the sealed court hearings and stuff, but they are allowed to hear about this being an order that he was not allowed to have anything but supervised visits. And that's from 2 months after their original plan. He messed all that up, and then the whole rest of the time he was only allowed to have supervised visits.
Children live, how frequently do they see each parent, what happens during holidays, what happens during vacations. In essence, all of those things get boiled into a parenting plan. And at that time, the parties had, by agreement, reached a temporary agreement regarding parenting.
For Fotis Dulos.
Where were we?
Mr. Dulos had sought supervised visitation, and that he sought that over quite some time. And ultimately, the court granted his request for supervised visitation, when previously there was an order of no access. And I believe the court issued its ruling on that in March.
He was also originally allowed to have no access to them, and he had to try to get the supervised visits, and they did end up doing that. So he, like, when he first messed up, he wasn't allowed to see them at all.
March of 2019.
And did that, well, when there was supervised visitation that was scheduled for Fotis Dulos and the children between March 2018 and May 24th, 2019, was Michelle Troconis allowed to have contact with those children?
No.
So if the children were present at 4 Jefferson Crossing between March of 2018 and May 24th of 2019, what would Michelle Troconis and her daughter have to do?
Not be present.
And was that for every visit throughout the course of that year?
It was, to the best of my recollection, after the court had entered orders in March of 19, those orders permitted the children to go back to 4 Jefferson Crossing, where they had not been permitted to go to for that prior period of time, from January of 18 up to that point in time.
Okay.
And so from March of 19 on, the children were permitted to go to 4 Jefferson pursuant to the orders, but Mr. Troconis could not be present.
So between March of 2018 and March of 2019, the children weren't even allowed to go to 4 Jefferson Crossing?
Correct.
And Michelle Troconis was not allowed to have contact with the children during that time period?
Correct.
In March of 2019, were the children allowed to go to 4 Jefferson Crossing?
There was no restrictions about their being able to go there, but there were restrictions as it pertained to supervision and Mr. Troconis' ability to go, to be present during parenting time.
Did those restrictions include a supervisor continuing to be present during the visitation?
Correct.
And did those restrictions also include Michelle Troconis and her daughter having to have to leave if they were there?
Correct.
And did that stay in effect until May 24th, 2019?
Yes.
In March of 2019, did you have a telephone conversation with Fotis Dulos and Michelle Troconis?
I did.
What was the subject of that conversation?
The subject of that conversation was the decision that had just been issued by Judge Heller regarding Mr. Dulos' motion for supervised visitation.
Okay, so this is March of 2019. So now we're 2 months before her disappearance.
And what was that motion for, or what was the decision?
The decision was that Mr. Dulos would be permitted to have supervised visitation with the children, but also there were limitations on that visitation, including Mr. Troconis and her daughter not being able to be present.
And this conversation occurred over the phone?
That's correct.
How did Fotis Dulos sound?
Okay, so that goes against what he was telling people about how everything was going his way and he was about to get full custody.
On that day, Mr. Dulos was down. He was concerned, and he was upset.
And what did he say to you?
If I may, I know I have a file note on this, and perhaps if I could have an opportunity just to refresh my recollection, I want to be consistent with my note.
Well, let me ask you this, sir. Are you required to take notes as a GAL?
I am.
Is that part of your responsibilities and duties as a GAL appointed by the court?
It is.
And do you take those notes as a part and parcel of your duties as a GAL? Are they done in a timely manner?
Yes.
If I may just mark something here.
Yes.
Your Honor, State's going to offer 142, if I can, absent objection. Sir, can you just ask you a couple questions about that briefly?
Is there an objection to State
No, Your Honor.
142? 142 admitted as fault.
Thank you. Do you recognize that, sir?
I do.
What is it?
This is a copy of a note that I made to the file dated March 21, 2019.
Is that the note that you took regarding the telephone conversation between Fotis Dulos and Michelle Troconis?
Yes, it is.
And if I may, thank you. Sir, if I can just have one moment, Your Honor.
Fotis and Jennifer met in college, but they didn't date, and then they ran into each other again at an airport years later when he was married to somebody else, but ended up getting divorced that year and married Jennifer.
Sir, did you call Fotis Dulos that day? Or?
He called me.
And what did he say?
Generally speaking, he called to talk about the court's decision that had just granted his motion for supervised visitation, but it placed the restrictions on his parenting time so that Ms. Troconis and her daughter couldn't be present. And generally speaking, he was upset about that.
And did he say anything specifically about expressing his feelings about the continued litigation? And if I can, I'll refer while the computer's not working. I can do that.
So again, him getting the supervised visit, like his limitations from the court are supervised visitation, but again, Michelle is still not allowed to be around the kids. So this is the opposite of what he was apparently telling people about how he is about to get full custody.
If that helps to refresh your recollection.
He's full of bull butter. As Ricky Watson would say.
Yes.
And what did he say?
He indicated that he was concerned that the continued litigation would have an adverse impact on his relationship with Mr. Troconis.
And what did you say in response?
Nobody cares about the mistress. Get over it.
I indicated to him, really just in summary, that the court had issued a decision which created a pathway forward for Ms. Troconis and her daughter to be able to work with me, with both parties, in an effort to try to provide access to them at a future date, but that I wasn't his lawyer and I couldn't advocate for him and deal with issues within the context of the litigation.
And did you subsequently speak to Michelle Troconis as well?
I did.
And what did she sound like on the phone?
She was down as well. She was frustrated. She had expressed disappointment and really just a lack of understanding as to why the court had not allowed access between her and the children.
And did you make any suggestions?
I did. If I may just take a look at the note.
Here's a suggestion.
Thank you.
Actually, sir, it is an exhibit and the Elmo is not working, Your Honor. I'm going to ask if the witness can just publish the note by reading it.
Well, it's a full exhibit. The witness can read it.
If you can, Attorney Meehan, if you wouldn't mind just reading the whole note.
Not a problem. Thank you. So this is dated March 21, 2019. It's titled Phone Call with Fotis Dulos and Michelle Troconis. It states, today I received a phone call from Fotis Dulos who wanted to discuss the court's memorandum of decision regarding supervised visitation. Mr. Dulos was upset because the court didn't grant immediate access between Michelle Troconis and Nicole and the minor children. Mr. Dulos was concerned and didn't know if he could continue on with the litigation because it was having an adverse effect on his relationship with Michelle. Mr. Dulos repeatedly asked if I could intervene and do something on behalf of the children regarding this issue. I reminded Mr. Dulos, as I have throughout the case, that I do not represent him and am not permitted to act as an advocate for either party. Fotis asked if I could speak to Michelle Troconis. I agreed and he placed her on the phone. Michelle wanted to know what she had done to cause the court to order that she not be permitted in contact with the children. I informed her that the court's recent decision created a pathway for the parties to start discussing a plan to reintroduce her and Nicole to the children to work with me as GAL. I asked her even if she had ever met or spoke with Jennifer Dulos. She indicated that she hadn't, but would be open to speaking with her or meeting her for coffee to discuss being reintroduced to the children. Michelle indicated that she didn't move here for all this and that she felt badly for the children and Nicole. She believes that they have all been the victim of this litigation. She is also divorced and she doesn't act this way with Nicole's father. Her tone was calm but very down. The conversation lasted about 5 minutes with her. The conversation ended after that.
Thank you, sir. Now, that was in March of 2019?
That was March 21st, 2019.
And at some point, did Fotis Dulos indicate that he thought the custody case was going to change in his favor?
Yes.
When was that?
That would have been probably at the end of April 2019.
So a month before.
It is now 11:17. We're going to stand in our morning recess until 11:35.
A document marked for ID purposes only and asked that it be filed conditionally under seal. The state was kind enough to prepare an envelope. So if I can pass it up to the clerk and represent on the record what it is, It is the final 4 pages of the custody report that has been the topic of discussion. On the front page of those 4 pages is a release, and it states, pursuant to the order of the court at the May 25th, 2021 hearing, a complete copy of the custody evaluation in the above matter is attached to this letter. As stated on the record, the report is released to the defendant and all dissemination restrictions apply pursuant to Practice Book 25-60. The pages that are enclosed are pages 67, 68, and 69, which are the conclusion pages of the report. If I can please pass it up to the clerk.
Yes, thank you.
Thank you, Your Honor.
Just if I may, if counsel can just get me a copy of everything that's contained, so I can just have a copy of what that is then.
Didn't you give her a copy?
This is the sealed report they're putting.
Attorney Meehan, you may take your seat. Thank you. You can bring the jury out.
Bring the jury.
Just for the record too, Your Honor, I have no objection to that being lodged as part of the case for the state's position.
Thank you.
Good morning, still, Attorney Meehan, how are you?
I'm fine. Good morning.
Just a couple.
Look, okay, so this is what I believe they started fighting about yesterday, right? So they just put that sealed document that they're not allowed to talk about it sealed. They're not supposed to know anything about it. And she pulls it up on her laptop. How she has it is beyond me. And apparently zooms in and puts it on like huge font so that people behind her, including like the photographer and stuff, can see what it says. So just so you know, I know that like, I don't want to give like a spoiler alert because like this is like, you know, all the drama that happened yesterday, but I also want to be able to watch, you know, watch the messy mistress do her thing.
More questions, okay?
Certainly.
At some point in 2018, around that, at some point in April of 2019, did Fotis Dulos indicate that he believed the custody case was going to change in his favor?
Yes.
And when was that?
It would have been sometime after the custody evaluation report was complete.
Would that be around April or May of 2019?
That would have been probably the end of April 2019, yes.
How did Fotis Dulos react when he read that evaluation report?
I was present with him and his lawyer when he reviewed the report, and he was a combination of emotions, I think. On the one hand, he was encouraged. On the other hand, he was upset and outraged. But ultimately, you know, his concern was he was concerned for the children.
And did he file a motion?
He did.
How did he react after that motion was, well, I should ask a foundation question. Was that motion heard in May of 2019?
He filed a motion with the court and ultimately was heard in May of 2019, yes.
How did he react after that
Okay,
motion?
so in April of 2019, he thought that he was going to get full custody, apparently.
Motion had been heard.
And then it was
Well, the
heard
motion
in
was started, it had not completed, and he became frustrated after the first hearing day that we had on his motion.
Was the supervised visitation still in place after the May hearing?
It was.
And nothing had changed?
It had not.
Did you speak to Fotis Dulos after Jennifer had been reported missing?
I did.
When did you do that?
I received a phone call from Mr. Dulos the morning of May 25th, early in the morning.
How did he sound?
He was very excited in the course of the call. I mean, I have a detailed note on it.
Again, did you document a note as part of your duties as a GAL?
I did.
Okay, if I may just approach the clerk.
Yeah.
So if he's saying in April that he thinks that he's going to be able to somehow all of a sudden get full custody, in whatever world he's living in, then in May when they had the hearing, all of the same restrictions were still in place, and then so he was not happy about that. And then of course May after that hearing is when Jennifer disappears.
Excuse me, Your Honor, the witness will be reading, just the witness will be instructed just to read at a moderate pace for the interpreter.
Certainly, thank you.
Okay, so these are his
Your Honor,
notes.
State would offer 143. I don't believe there's any objection. I'd ask to be moved into evidence.
No objection to States 143.
No, Your Honor.
States 143 admitted as full.
Thank you. Attorney Mann, what is 143, please?
Exhibit 143 is a copy, another file note that I made. This one dated May 25, 2019, and it's titled Jennifer Missing.
Do you make these notes, by the way, around the time that the event occurs?
I do.
And is that part of your duties as a guardian ad litem?
It's part of my practice, but yes,
Okay. As that's a full exhibit, I'm going to ask if you can read that, please.
certainly. It's titled Jennifer Missing, dated May 25, 2019. Today, I received a phone call from Fotis Dulos at 10:26 a.m., who informed me that Jennifer Dulos was missing. He stated to me, "Mike, have you heard the news?" I replied, "No." He then stated, "Jennifer is missing." I noticed the tone in his voice to not be down or somber, but to be more excited.
Oh.
I don't know what to attribute the tone to his voice to. I asked, "When did she go missing?" And he indicated sometime yesterday, 5/24/19. I asked him where he was yesterday and whether he had an alibi. He said he was home in Farmington all morning, then in meetings. He mentioned he had cameras in his house. He immediately asked about the children and wanted me to address their safety. He told me they were in New York with Jennifer's mother and Lauren. He went on to tell me that Jennifer had made dental appointments for the children in New York and that he didn't know about the appointments or agree to them. A review of OFW shows Jennifer did advise him of a New York orthodontist on 5/13/19 via OFW and offered to advance the cost. I ended the call with him and began getting phone calls from Attorney Midler, New Canaan PD, and Jacob Petranker. I spoke with New Canaan PD, and they informed me of the investigation involving Connecticut State Police Major Crime Squad. They informed me that Jennifer's home in New Canaan was a major crime scene. The police asked for permission to interview the children, and I authorized the police to speak with them.
Sir, as part of your responsibilities as a guardian ad litem between 2017 and 2019, did you speak often with Jennifer Farber-Dulos?
I did.
And after May 24, 2019, have you heard or seen Jennifer Farber-Dulos since then?
Sadly, I've never spoken to her again.
Thank you. I have nothing further.
Oh, Lord.
Thank you.
That's interesting. Fotis didn't sound sad or concerned. He sounded excited. Did you hear the news? She gone. Figures.
Attorney Mann, good morning.
Good morning.
I'm going to come up and grab that back from you if you don't mind.
No problem.
Thank you. You said you were the guardian ad litem for the Dulos children from August of 2017 through 2019,
Correct.
and you were appointed by the court.
Ultimately, yes.
Is that a situation where the parties need to agree to have you appointed?
Not always, but in this case, the parties reached an agreement on my appointment.
By parties, it would be Jennifer Dulos and Fotis Dulos?
Correct.
And Fotis Dulos and Jennifer Dulos were engaged in litigation during that time period
2017, yes.
related to parenting and custody?
Correct.
And that litigation was between them. It wasn't Michelle Troconis. She wasn't a party to that in any way.
Ms. Troconis was not a party to their divorce, no.
The court can appoint you as a GAL. You can have certain duties. Some of those duties can be limited by the court.
Correct.
Were your duties limited in any way when you were appointed by the court to be the guardian ad litem for the Dulos children?
Only to the extent that the parties had reached a signed agreement that set forth my duties, but those duties really mirrored the official duties as listed on a court form that we have. So in essence, it was all duties.
And were your duties ever during that time period restricted in any way by the court?
No.
As the guardian ad litem, you had said that you represent the best interests of the children.
That's correct.
That you're basically the eyes of the court.
That's correct.
You're a fact finder for the court.
Correct.
You don't work for Fotis.
No.
You didn't work for Jennifer Dulos.
Correct.
And you certainly don't work for Michelle.
That's correct.
During those 2 years, between 2017 and 2019, and not to get into what you said, but did you at times report to the court about your findings and what you thought was in the best interest of the children?
I did.
Did you do that based on interviews with the children?
Amongst other things, yes.
Also interviews with Fotis Dulos?
Correct.
And Jennifer?
Correct.
And you met Michelle before?
I have.
You, I think, had dinner once at 4 Jefferson Crossing sometime at the end of 2017?
I did.
And you also spoke to mental health experts?
I did.
And treatment providers?
Yes.
Did you also speak to the parties' attorneys?
I did.
Did both parties have attorneys?
Ms. Dulos was represented by counsel the entire time, and Mr. Dulos was represented by counsel at times, was also self-represented at times.
Let's start with Ms. Dulos. She had an attorney at one point. To start out, was that attorney Eric Broder?
Correct.
Did she at some point switch attorneys?
She did.
And she had Ruben Midler represent her?
Correct.
At some point, Fotis Dulos had an attorney named Jacob Petranker.
That's correct.
Did he at some point switch attorneys?
He did.
Was Mike Rose one of his attorneys?
He became one, yes.
Was Mike Rose Fotis Dulos' attorney in April and May of 2019?
I believe so, yes.
You had said at times that Fotis represented himself.
Correct.
Did Fotis file his own motions?
He did.
Did he make his own arguments to the court?
He did.
Fotis isn't an attorney, is he?
Not to the best of my recollection, no.
To get a timeline here, you talked about sometime in January of 2018, you had said that Fotis' visitation was suspended by the court.
Correct.
And at some point in the spring of 2018, were you aware that Fotis had filed a motion to modify that order?
That's correct.
During the course of the spring of 2017, there were many months of hearings?
Of 18.
Spring of 2018.
Yes,
And those hearings occurred over the course of several months
that's correct.
related to visitation.
Amongst other issues, yes.
Parenting issues, though.
Correct.
During the course of those hearings in the spring of 2018, from January until mid-2018, did the court ever enter interim orders?
The court did.
And were those orders permitting Fotis to have supervised parenting time with the children?
Yes,
Was Fotis' supervision had by a court-ordered supervisor?
yes,
Was that Dennis Puebla
that's correct. And his group.
and his group? So other people who worked for Dennis Puebla would also be monitoring that supervised visitation?
That's correct.
So during the course of those hearings, pursuant to the court's orders, Fotis would be able to visit with the children?
During the time period, yes.
At some time during that time period, there was a court-ordered custody and psychological report that was to be prepared?
That's correct.
Is that requested by the parties?
Are you asking me in this case or just in general?
Can either party request it in general?
Either party has the right to ask the court to appoint a court-appointed evaluator or to ask the Office of Family Relations to conduct a custody study.
And that custody study helps the court make a decision related to custody and parenting issues?
It is a piece of information that the court can consider when entering orders for custody, yes.
And in this case, do you know whether one of the parties requested that such a custody report be prepared?
I believe so, yes. I'm trying to recall the time period.
Was it sometime in 2018?
There was a motion to have a private custody evaluation. And I believe the motion was filed, yes, by one of the parties.
In 2018?
That's correct. It may have been filed sometime in 17, but acted on in 18.
Not getting into the contents of this particular custody report at all, I'm talking about custody reports in general. You had mentioned that sometimes they're prepared by family relations.
Correct.
Can you tell the jury a little bit what family relations' role is here in the courthouse related to custody evaluations?
I'm going to object, Your Honor. Relevance to anything in general with respect to the custody, family relations.
There's already been testimony that the custody evaluation was prepared by a private party and not family relations, so it's not relevant.
I can ask related to private ones. Can you tell the jury a little bit about what, in general, a custody report entails?
I'm going to object, Your Honor. Relevance to...
The court understands the question. Custody reports are going to entail, all custody reports don't entail the same information. So that question is too general to be useful to the jury.
I can ask follow-up questions, Your Honor. Do custody reports involve interviews with the parties?
Generally, yes.
Sometimes do they involve evaluations by treatment providers,
Sometimes, yes.
mental health treatment providers?
Sometimes, yes.
And one of the factors that is addressed in custody reports is a parent's psychological status.
That is one of the factors under our custody statute.
I'm going to object, Your Honor.
These questions are running over the double yellow line. Sustained.
I like the way he explained that.
In this particular report, was somebody appointed to conduct a custody evaluation?
Yes.
Who was appointed as an evaluator?
Objection.
Sustained.
Was it a psychiatrist who was
Objection.
appointed?
Sustained.
Can't get
Did both
into
parties
it.
agree on who was going to conduct the evaluation?
Objection.
Well, did both parties agree that's overruled?
Yes.
Did the court accept that individual to participate in the evaluation, to conduct the evaluation?
Objection.
Sustained.
How long
You
did it
cannot get
take
into
for this
it.
custody report to be prepared?
Objection.
Well, what's the ground?
Your Honor, even getting into the length of time it takes to prepare it suggests that it's the contents suggest it opens the door to what was involved in conducting and creating that report, and also the relevance of how long it takes.
Well, the court will sustain the objection on relevance grounds.
During the course of the custody report being prepared, were there hearings in court related to custody and visitation?
Yes.
Let's skip to March of 2019. You had indicated that it was Judge Heller in this case who handled the family matters?
That's correct.
She entered orders allowing Fotis to have supervised visitation.
Thank you, Ricky Watson.
Correct.
By that point, March of 2019, was the custody report well underway?
Objection.
Well, this is another way of trying to determine through this witness how long did it take to prepare the custody report. Sustained.
Sustained.
Was it your understanding in March of 2019 that the custody report was about to be completed?
Objection.
Sustained.
She's trying to get it in. This is not
During
allowed.
in that March 20th order from Judge Heller, was Fotis Dulos allowed supervised custody, supervised visitation?
Yes.
And it was sometimes at Fort Jefferson
It was permitted at that time.
and sometimes in Fairfield County?
Correct.
And in that order, Judge Heller ordered the parties to work together with the guardian ad litem.
Correct.
And that's you.
Correct.
And to come up with some kind of process or timetable to have Michelle and her daughter Nicole to be able to be present during that visitation.
That's correct.
And that was based on your recommendations.
I want to be mindful, as I understand, the court's issued an order of protection regarding sealed hearings, confidentiality, et cetera. My hesitation in answering the question is, if you're asking me a question that requires a response about something that I recommended in the context of a sealed hearing, I'm not necessarily sure that that's in keeping.
That's covered by the protective
I can
order.
rephrase that, Your Honor. You at the time were the guardian ad litem
At the time of,
Judge Heller's order.
yes,
And in the months prior to.
correct.
Your role as guardian ad litem is to be the eyes and the ears of the court.
That's correct.
And you provide feedback to the court
Correct.
upon which she bases her decisions.
That's correct.
You had told the jury about a phone conversation that you had with Fotis Dulos the following day.
Yes.
March 21st, 2019.
Yes.
Is that correct? And you prepared, you take notes
That's correct.
of your conversations with parties?
Yes.
Related to your communications?
Correct.
And you did in this case?
Yes.
Did you take that note on or about March 21st, 2019?
Thereabouts, yes.
And you said that Fotis wanted to see if you could do something to facilitate contact quicker.
Correct.
Did you learn at some point that Michelle's plan was to move out of state?
I became aware that she was looking to move away from all this, yes.
And by all of this, you mean the litigation?
That's correct.
All right, because it was your understanding that Michelle didn't have that kind of relationship with her family
That's correct.
or the father of her child,
Correct.
and it was very disappointing to her,
That's what she'd expressed to me, yes.
and she didn't want to be around it.
Correct.
And she told you she felt bad for the kids.
Okay.
She did.
Can we just throw this out there? If Michelle was so uncomfortable with the litigation and she doesn't understand what's going on with all of this, okay, maybe you shouldn't start seeing a man who's married with 5 children and then move into that woman's house. I'm just throwing ideas out there on how we can avoid things like this. Just brainstorming out loud. Maybe if you don't want to have to deal with your boyfriend's divorce, maybe you shouldn't have a boyfriend who's married. Just an idea. Just an idea.
You explained that the court's order was a positive development,
Correct.
that it represented progress.
Correct.
And you did think that at the time?
Yes.
And things were progressing
Slowly, but yes, they were progressing.
through the courts,
Correct.
pursuant to the court orders.
Correct.
And at the time, Fotis was working with his attorney?
Yes.
At that time, it was Mike Rose?
Yes.
Sometime in April or May of 2019, there was a custody report that was completed.
Correct?
Do you remember what date that was?
It would have been sometime in the last week of April, perhaps the 26th or 27th of April, 2019.
Would it refresh your recollection to look at a document?
Perhaps.
All right, may I approach her?
Your Honor, I'm going to object to this line of questioning as to when, what date, what any particulars with respect to the custody report. If this is just a foundation question,
It is.
Well, the question is, at some point, well, the term "at some point" is meaningless. It was completed. And the answer is yes.
Your Honor, the date that we're talking about is just a month prior to the incident for which we're here. And during the state's direct, this time period was especially an interest to the state, as well as Fotis's mindset and the way that he was reacting to the release of the report within this specific time frame.
So if the question is, was it completed on such and such a date, the witness can respond.
Was the report completed on or around April 24th, 2019?
Thereabouts.
You reviewed that report?
I reviewed the report.
You gave the parties the opportunity to review the report,
I offered both parties an opportunity to review the report with their counsel, yes.
but you did not disseminate the report. You didn't make copies of the report and give that out to anybody?
No, I did not.
And that is pursuant to a statute or a court order?
Well, in this particular case, there was no agreement previously by the parties regarding the publication or dissemination of the report. It's my general practice with these types of reports that they not be provided to parties or to their counsel unless there's a court order that limits or controls the dissemination of the use of such a report, because we don't want these reports falling into the public realm in any way. And in this particular case, there was no actual court order in that regard, but there was discussions and work towards that. So that's to answer your question.
So you did not disseminate the report to anybody?
Correct.
But the parties had an opportunity to review that report at your office?
That's correct.
Did Fotis come to your office and review that report?
With his counsel, yes.
He was there with Mike Rose?
That's correct.
And reviewed the report, and you indicated that as a result of the report, he was encouraged?
That's correct.
All right. And without getting into the discussion, did he tell you why he felt encouraged?
Well, that's going to run counter to the protective order. Of course, not going to allow that question.
All right. You had also indicated he was upset and outraged.
That's correct.
As a result of reviewing that report, did Fotis' attorney file a motion with the court?
He filed a motion with the court.
Was that a motion for custody?
I'm going to object, Your Honor.
Well, the fact that the parties read the report, the next question gets into what would be the nature of what he read such that he would file a motion for custody, which gets into the content of the report.
This is my last question in that
It
line.
doesn't matter whether it's the last question. The question is whether it's inadmissible, sustained.
Bam.
In May of 2019, was it your expectation that Fotis' access to the children was going to continue to progress?
Objection.
Sustained.
Gosh.
In May of 2017, was Jennifer Dulos more agreeable to visitation?
Objection, Your Honor.
Well, in May of 2007.
Of 19, I apologize, Your Honor.
Well, if that question isn't covered by the notes, the court is not going to risk having any content pulled from the page of the custody report.
It's not from the
with that
custody report, Your
question.
I believe so.
You were still the GAL in May of 2019?
Yes.
And you were still involved with parenting and custody issues related to Fotis Dulos?
Yes.
And part of those, one of the aspects of that was supervised visitation?
Correct.
Were you aware that Mr. Dulos was allowed supervised visitation during that period?
Yes.
Was that supervised visitation a little more flexible during that time period?
Just so I understand the time period, which time period are you referring to?
In May of 2019?
The parties had been communicating a little more frequently and with a little more ease.
With a little more ease?
Yes, in regards to his parenting time.
And were you aware that Jennifer had allowed Fotis to visit with the children at her home?
Yes, I was aware of that.
All right, at 69 Wells.
Yes.
Following that filing by Fotis' attorney, Mike Rose, in May of 2019, there were court hearings?
Yes.
And were there scheduled court hearings for after May 24th, 2019?
Yes.
You had another conversation with Mr. Dulos on May 25th, or 25th, 2019, or was it 24th, 2019?
I spoke with Mr. Dulos, if I recall, on May 25th, 2019.
And he told you that Jennifer was missing?
Correct.
He also told you that Jennifer had scheduled dental appointments for the kids?
Correct.
And he told you that he was unaware of them?
I'd have to look at the note as to whether or not he was aware of it or not.
All right, we're looking at it, refresh your recollection?
Please.
Hi, Chrissy Bacon. Happy anniversary. 7 whole months.
Okay, can I have the question again?
Yeah. Dawson.
Yes.
In that phone conversation, Fotis told you that the children had a dental appointment in New York of which he was unaware.
Correct.
And he told you he didn't agree to that?
I don't recall if he said he didn't agree to it, other than just he was not aware.
You were able to check in something called OFW?
That's correct.
Is that Our Family Wizard?
That's correct.
Can you tell the jury what OFW, Our Family Wizard, is?
Certainly. Our Family Wizard, also known as OFW, is a computer service, application service that sometimes are used in cases that allows parents to be able to communicate back and forth with each other. And many times when we have cases like we had in this case, we use that as a tool so that we can document when messages are sent between parents, and the guardian is sometimes invited into those communications. As I was here, I can monitor these communications. And it also allows each parent to see if, as and when, certain messages, when they're sent, are read. Because many times these involve decision-making issues. They need to be done in a timely fashion. And frequently we are met with, I didn't know, I wasn't aware, when we can track that on OFW.
In this case, you were able to track that?
That's correct.
And you knew that Fotis was in fact aware that there was a dental appointment?
Via the OFW message.
And that Fotis had lied?
If that's what you want to call it.
And Fotis lying had been a problem throughout the course of your role as a GAL from 2017 to 2019?
Uh-oh.
Again, Your Honor, I don't mean to interfere, but if the question's going to information that would call for me to have to testify about something that was subject to a sealed proceeding.
Right. Well,
I can ask.
At this point, this is now character evidence. And so the code the code states that evidence of a person's character is not admissible to prove action and conformity therewith on a particular occasion. However, there may be evidence introduced as to character for truthfulness or untruthfulness, but that can only be done by opinion or reputation, not at the start by specific instances of conduct.
Attorney Mann, you didn't...
So the court hasn't finished.
Thank you.
Sustained.
Thank you. You as the guardian ad litem did not represent Mr. Dulos?
No.
But you had many conversations with him throughout the course of your representation of the children?
Correct.
Was it your opinion that Mr. Dulos lied an awful lot?
Yes.
When you were speaking to Mr. Dulos on May 25th, 2019, he told you that Jennifer was missing?
Correct.
This judge is awesome.
And you asked him where he was the day before?
Correct.
And whether he had an alibi?
Correct.
And you told him to make sure he had every second accounted for?
I'd have to look at the note again to see exactly what I said.
Do you recall telling him words to that effect?
Again, I'd have to look at the note, Attorney Felsen.
May I approach, Your Honor?
Yes.
It's interesting that she said, did you say that? And then he's like, I'd have to look. And she's like, so did you say something like that? But it's like she didn't want to show him. Interesting. So I wonder if he did tell him that.
I got a chance to refresh my
Thank
recollection.
you.
I don't see that in the note.
Whether or not you see that in the note, do you recall having a conversation with Fotis about accounting for his time on that day?
I think we had a general conversation about that. That's the reference to the being at home and the cameras, et cetera.
And the importance of doing that?
Well, I didn't give him any instruction of what was important or not.
You didn't give him any instruction at all, right?
Correct.
Because you weren't his attorney.
That's correct.
But you did indicate that he should have his time accounted for.
Again, I don't think I gave him any instruction.
It wasn't an instruction, but you did discuss that with him.
I discussed where he was, what he was doing, whether or not he had an alibi.
Thank you. I have no further questions.
She's trying to make it sound like
Nothing further, thank you.
Thank you.
she's trying to make it sound like he just like he was telling him like, well, you told him he needs to account for everything, right? And he literally said, no, like that's not what I said. They had a general conversation about where
Your
he
Honor,
was.
our next witness is actually coming from out of state. They will be here around 2:30. I would ask some indulgence in a longer lunch.
Thank you. How many witnesses are scheduled for this afternoon, Attorney?
Just one, Your Honor.
Ladies and gentlemen, we'll reconvene at 2:30.
Okay, they took a
Please
long,
do not discuss the case.
They took a long break that day. Let's see if we can. It's almost 4 o'clock. Let's see if we can get in a little bit more, since we haven't been able to. They did a short day yesterday too. So let's see. Okay, so this is yesterday afternoon. That guardian ad litem was good. He was good.
Judge, just before we bring in the jury to call the next witness, I did just want to bring a legal issue to the court's attention. Attorney Schoenhorn indicated to me yesterday that he would be objecting to the AT&T records coming in without an authenticating witness. I don't know if that's still his position, but it was my intention to use those records at this time.
I will just note, Your Honor, that the state provided me with an affidavit, which I believe does not comport with new evidence 9-3A, although there are two affidavits. One is dated yesterday, or maybe, what's the date? It's not yesterday, a couple of days ago. The other is dated a couple of months ago. But in any event, I submit that, well, there are two issues. One is it states that the specific records and the certification have to be provided in sufficiently in advance of the offer to provide an adverse party with a fair opportunity to challenge them. So this was provided within the last couple of days, this affidavit. But in any event, I don't believe the affidavit complies with subsection A3 of new 9-3A. It appears to, on its face, the business record affidavit comply with a federal rule. It specifically recites the federal rule, but Connecticut's code of evidence is different in that respect. And specifically, it requires that the affidavit state either that it is based on the entrant's own observations or on information of others whose business duty it was to transmit it to the entrant. And I submit that neither of those are in the affidavit. Therefore, I've indicated to Mr. McGinnis, actually at least 2 weeks ago, that I was going to request that an AT&T representative appear. And I had indicated even to Your Honor that part of the issue was to explore whether or not these records were obtained or were subject to erasure, that were therefore obtained in violation of the Fourth Amendment. But I'm just sticking right now we're not making a constitutional argument to my claim that under new Rule of Evidence 9-3A, which was approved in 2022, that the affidavits do not comport with the requirements of that section under the business record authentication requirement, and therefore a business custodian of records would be required to testify.
Judge, obviously I disagree. I think that the affidavit itself fully complies with 9-3A. Just with respect to notice the opposing party, my recollection is we've been going back and forth as to whether or not someone was going to be required. And it wasn't really until last week that Mr. Schoenhorn indicated yes, for sure, that he was going to demand that someone from AT&T be present. But I'll just note the following for the record. With respect to Mr. Dulos' records, I would imagine he's had those for several years, although I guess he could represent the specific date. I wasn't involved with the case at that point. And with respect to Mr. Troconis' records, he's had those since at least November 16th, and that affidavit is, that was a more recent search warrant, as the court will recall. And I could pass forward a copy of one of the affidavits. They look the same if the court wants to, check it against the subsection. But I can tell you, Judge, that this affidavit fully complies with 9-3A. It indicates that the person making the affidavit is qualified to authenticate the records because they're familiar with how the records were created, managed, stored, and retrieved, that they are true duplicates of the original records. They were made at or near the time of the occurrence of the matter set forth by or from information transmitted by a person with knowledge of those matters. They were kept in the ordinary course of the regularly conducted business activity of AT&T, and they were made at AT&T as a regular practice.
I would ask the court just to look at the affidavit. And like I said, I think that the business record rule may be an exception to the confrontation clause, but I would argue that it would have to be strictly construed in order for that to be admissible. I have no objection to the court looking at it. I believe it doesn't comply, and it would be a simple matter to look at.
Well, if it's a confrontation argument that they're making, Judge, then you can dispense with this pretty easily. These are business records that are not kept for the specific purpose of criminal litigation. And so obviously if they're kept in the ordinary course of business as this
Y'all, real quick, let me move myself. Look, you can see down here on the computer, on her laptop.
affidavit attests to, then there is no testimonial piece of this because they weren't generated for the purpose of criminal litigation. So I think if that's the argument, then I think the court can quickly dispense with it. But I'm happy to pass forward a copy of the affidavit.
Thank you. Well, the court hears two arguments. The court hears one argument concerning authentication and another argument concerning business records. There is a business records exception to the hearsay rule. That exception requires, well, is this a business record or is it a public record?
It is a business record, Judge.
If it's kept in the regular course of business, and it is that business's business to keep such records in its regular course, that seems to have jumped both hurdles, if it's a business record. The question now is whether it is authenticated. And the claim is that, well, the court should probably read the affidavit. Thank you. Well, according to the Certificate of Authenticity, paragraph A reads, all records attached to this certificate were made at or near the time of the occurrence of the matter set forth by or from information transmitted by a person with knowledge of those matters. That seems to satisfy Section 9(3)A. The entrant is not indicating that it is from his or her own personal observation, but from, and this is the difference between the public records exception and the business record, or rather authentication section of the code. The public records exception requires the entrant either to have personal knowledge or someone other than the entrant who has personal knowledge who has the duty to transmit. 938 does not require those who have a duty to transmit to have a personal knowledge. It reads, the information contained in the record was based on the entrant's own observation or on information of others whose business duty it was to transmit it to the entrant. The others need not have personal knowledge. So the court, in reading section A, concludes that the affidavit satisfies section 938.
Deputy Mark, then for ID, then for the record.
Yes, thank you.
I have no objection to that, Judge. I do have the records themselves, which I'm going to be introducing on a disc. They're, the affidavit is actually on this disc, so I don't know if the court needs to mark that specific one, or I suppose we can.
We should probably mark both.
Sure. And I'm just going to take an opportunity to mark the two exhibits.
Yes.
If that's right.
Come on.
Judge, the state calls Special Agent Kevin Hoyland of the FBI.
FBI agent on the stand.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
Kevin, K-E-V-I-N, Hoyland, H-O-Y-L-A-N-D.
Thank you.
Mr. Hoyland, you may be seated.
Thank you.
Good afternoon, Agent Hoyland.
Good afternoon.
Would you just tell the jury where you're employed?
I work for the FBI,
What is your current title with the FBI?
special agent,
How long have you been a special agent with the FBI?
since 2012.
And I know this is probably goes without saying, but FBI stands for Federal Bureau of Investigation, correct?
It does, yes.
And as far as education, how far did you go in college?
I have an undergraduate degree in finance. I have a MBA, Master's in Business Administration, and I also have my CPA license.
Where were you employed prior to being a special agent with the FBI?
I worked at Dunkin' Donuts Corporate in Massachusetts.
Now, with respect to your responsibilities with the FBI, what are your responsibilities as a special agent?
Presently, I'm a full-time member of the Cellular Analysis Survey Team, otherwise known as the CAS team.
And what is the CAS team?
The CAS team is a specialized unit of investigators responsible for analyzing phone records provided by the cell phone companies to understand the general location of where a phone was or wasn't when it had made or received phone calls.
And how many people are part of the CAS team?
Across the country, there's approximately 80 or 90 of us. 20 of us, like myself, do it full-time.
And of the 20 that do it full-time, how many are situated here in the Northeast?
Just me.
All right. And in fact, you drove down from New Hampshire today to testify. Is that correct?
I did.
And would you mind just telling the jury what historical cell site analysis is?
Sure. So historical cell site analysis involves taking those records I mentioned that the phone companies keep in a normal course of their business and reviewing them and reviewing the cell tower information that gets recorded every time your phone makes or receives calls. And by looking at that information and where those towers are physically located on the earth, I can begin to formulate an opinion as to the general location of where a phone was when it had made or received those calls or text messages.
And what would be the purpose of doing such an analysis?
The purpose for that is to understand, again, the general location for a device. So our unit gets called upon for kidnapped children, Amber Alerts, fugitives, really any investigation where there's a phone in play. Using these historical records is very helpful to understand, again, where that phone is to locate the person holding that phone.
As part of CAS, have you received any specialized training regarding cellular telephones, technology, and historical cell site analysis?
I have.
Please explain the training you received.
Sure. Today it's...
Let's get through training. We don't need their training.
Have you been...
We already know the training. Get to the data.
States Exhibit 147.
All right, here we go. What we got? What we got?
Thank you. I'm just going to ask if you wouldn't mind looking at that. and tell me what it is.
This appears to be the report I put together for the case.
And did you prepare that in the ordinary course of business?
Yes.
Judge, I move it in.
Which one are we talking about?
The PowerPoint. Let me just compare it.
Which number is that, please?
145. I'll take it back so that Mr. Schonhorn can.
I just want to compare it.
I love their training. I just love to skip through it also.
States 147 is a DVD, which also contains States 145, just so that I can display it on the screen. Do you have an objection to this?
Well, I have no objection to him using both. I think one should be a letter A of the other exhibit rather than a separate exhibit, so the jury understands it's the same exhibit, just one's in electronic format and the other's in paper. I don't know if it should be two separate exhibits.
Well, it probably does not make much difference since there will be a list of all of the exhibits, but it will be 145A.
So let me just have the clerk remark this.
The whispering freaks me out. Sounds like Michelle and her attorney whispering.
Handing you States 145.
Thank you.
Agent Hoyland, can you just tell the jury what phone numbers and devices you did the analysis for in that particular PowerPoint?
Sure. In this instance, we're looking at phone number 860-478-8625, which was an AT&T number, as well as a 305-331-5232, which was also an AT&T number.
And who are those phone numbers associated with?
The first phone number, the 8625, was associated with Mr. Dulos, and the 5232 was associated with Mr. Troconis.
Bring the data. Yeah, they whisper like right around those microphones so you can hear them.
Yeah, I'll slow down.
Oh, wait, let's see. Oh, look how big that, okay. Okay. All right, messy mistress. Hold on. Look how look how big the type is. Now, okay, if she wants, if they want to give her a translator because English is not her first language, fine, but that don't mean she can't see it. Like, that's, okay, that's a little... Get it together, woman. I mean, that's...
Okay. We'll disregard the... oh, all right.
Like, look how big that type is. She got it, like, all the way
displaying States Exhibit 138, which is a detail log sheet.
Messy mistress.
And I'm going to see if I could zoom in. Agent Holland, is that visible in front?
Now I can see it. Yep.
Okay. All right. And sir, States Exhibit 138, I'm just going to direct your attention to a phone number here on the left-hand side, 305-331-5232. Are you familiar with that phone number?
That is the phone number associated with Mr. Troconis.
I'm sorry? That's
the phone number associated with Mr. Troconis.
Understood. Okay, thank you. Oh, and just before I publish the cast PowerPoint, Judge, the AT&T records were marked as States 146. I'm going to move those into evidence at this time.
Well, based on what I indicated before, that's...
States 146 admitted as full.
And Agent Hoyle, I am going to be displaying your PowerPoint. However, you have the hard copy in front of you too if you need to refer to it. Is that all right?
I love a PowerPoint.
Sounds great.
Missy Russell, happy anniversary. 3 whole months. Happy anniversary. I'm glad you're here.
All right. Agent Hoyle, can you just tell us what this first page is?
This first page is just the traditional cover sheet indicating the phone numbers that I looked at, the corresponding FBI case, and when I completed the analysis.
And can we just go to the next page, page 2? Can you briefly just tell the jury how a cell phone works and communicates with a cellular?
Well, you don't need to know how a
Verizon.
cell phone
It's
works.
I have a detailed record.
Now, you mentioned a cell tower. What is a cell tower?
We know what a cell tower is.
Those big
Reach out to
and over call detail records. They're essentially billing records. It just says who called who, when that call occurred, date, time, how long it lasted. What separates call detail records from billing records, though, is it also gives us that last piece of information. What cell tower did the phone utilize for that particular call?
If we just go to the next, well, actually, before we go to the next slide, you had also mentioned sectors earlier. You said you were going to get to that. Can you explain what a sector is?
Yeah, and actually, it might be easiest if we could move one slide ahead to help visualize it. So the design on the right here, imagine you're in the air and you're looking down on top of a cell tower. A cell tower, it covers 360 degrees, a circle, right? Most towers are broken up into sectors.
We already know this part, right? We know this.
Encompass data information such as FaceTime calls or FaceTime audio calls?
Those particular types of transactions, so anything related to an app, which FaceTime, iMessage, all of those things are carried over the data side of the network. So all the carriers have 3 distinct sets of information. There's voice calls, there's text messages, and then there's data. In this case, we didn't get data. But even if we had, it wouldn't show us transactional levels of detail. So it wouldn't show us a FaceTime call. All it would show is that at some point a data session had opened up, it had requested resources from a tower. It remained open for a period of time, bytes were exchanged up and down, and then it closed. We can't infer what's going on when those situations occur. The phone could have been in a FaceTime call, the phone could have been sending iMessages back and forth, it could have been on WhatsApp, or the phone could have just been turned on and sitting on someone's desk and an email notification came in, or some other pop-up where it wasn't user initiated.
And you had mentioned that you were asked to review cell phone records. Actually, can we go to the next slide? And would you just explain to the jury what we're seeing in this slide?
Sure. So these particular illustrations are what we will see most commonly in the slides and the maps that I completed for this report. So the pie wedge that you see behind me, that reflects the sector the phone had utilized at the timestamp shown. One thing to point out is that the shaded area on that pie wedge, that's not the coverage area. And I want to be very clear about that. That is merely a visual to help understand that that's the direction that that particular sector faces. At the bottom, you see a call-out box. It lists the cell ID, the phone number that had created that transaction, the timestamp, which is adjusted to local time, whether or not it was an incoming call or text message or outgoing, how long the call lasted is the next number, that 36 in this example, and then lastly, the far right is the opposing number. So if I spoke with you, my number, and we were looking at my records, my number would be on the left side, your number, the number I spoke with, would be on the far right.
Now, were you asked to review records for cellular phone number ending 8625 belonging to Mr. Dulos?
Yes.
And also with respect to a cellular phone number ending 5232 belonging to Michelle Troconis, is that correct?
Yes, it is.
All right, and I'm just going to ask you to go to the next slide. And this particular slide just shows the phone number and account information for that particular subscriber, is that correct?
Correct. This is the AT&T subscriber information for number ending 8625, which comes back to Mr. Dulos.
And the next slide. And this slide provides information for Michelle Troconis' device, is that correct?
Correct.
And is it your understanding that Maricela Areza is her mother, or you're not sure?
I'm not sure, actually.
Okay. Next slide. What are we seeing here?
There was a handful of locations that investigators had provided to me in support of me doing my analysis. Those locations are shown here with the address in the middle, as well as a corresponding map icon. On each of the slides, on the maps themselves, I have a legend where this information is there as well, so it's not like you need to memorize it. But a residence in Farmington, a property on 80 Mountain Spring Road in Farmington. There was an area in Hartford that I was asked to look at. Russell Speeder Car Wash in Avon. And then lastly, on this map, you're going to see a bunch of blue dots, and those are going to represent the other AT&T towers in the area that the phone didn't utilize during the time frame mapped out.
And did you use any particular software to map this out?
Yes.
What software is that?
The software we use is known as ESPA, E-S-P-A.
And what does ESPA do?
ESPA takes the records that we receive originally from AT&T and visualizes them. So AT&T records contain a lot of the information I just mentioned. That allows us to put dots on a map, allows us to visualize which cell towers were utilized, where those cell towers are located in correspondence or in relation to the locations provided here.
All right, you have the next slide, please.
Color coordinated and everything.
All right.
This guy is after my own
Agent
heart.
Hoyland, I don't know if it would be easier for you to step up to the screen at this point for the next several slides,
Sure.
just to kind of explain to the jury what we're looking at here. And just before we, there's a big screen behind you.
Is that okay, Your Honor? Yes. Thank you.
And just before we get there, there are various boxes, and the top of the box is blue and begins with the letter CID. Could you just indicate to the jury what that means?
Sure. So using this as an example, CID represents cell ID. So that is the AT&T identifier for the particular tower shown here. So each of these call-out boxes are associated with different events during this time period of the evening of May 23rd, 2019 through early morning hours of May 24th. So just as an example, this box up here, CID 2582, this is the tower and sector represented by CID 2582. There was a total of 4 transactions from 1008 through 1012 from into Mr. Dulos' device. So as you'll notice, there's 2 colors up here. I have black associated with Mr. Dulos' device and green associated with Mr. Troconis'. So whenever you see those colors, you know that that's the particular phone that we're talking about. Taken in totality, though, what we have here is a handful of activity from these 2 devices utilizing towers and sectors all facing back towards the residence. This particular cell site up here, CID 20123, is unique. It's known as a femtocell. So if anybody, either themselves or has a relative that has really poor cell phone reception in their house, they can buy a device to plug in to their internet to boost the signal, essentially. It's known as a femtocell. It gets a unique identifier, and the particular lat and long of that cell tower is the latitude and longitude of the house. What this means is that that particular femtocell is installed in the residence, and so when the phone is using that particular CID 20123, we know that the phone is at the residence or on the property.
And there's a green marker also in the center of the slide, which just indicates the jury what that is.
Of course. So this green marker represents 80 Mountain Spring Road. As you can see, they're in close proximity to one another.
Okay, so the green
again,
is...
this is consistent with
this
both
is the
devices
workhouse.
being in and around that area on the evening of May 23rd, 2019. through
This
the
is their house.
12:59 a.m.
And this is the workhouse.
May 24th.
Okay. And we're just going to go to the next slide.
Look, I love me some data.
Agent Hoyland, could you just indicate to the jury what we're
perked
seeing
right
in
up.
this slide?
Of course. So the next morning, beginning at 7:16, Mr. Dulos' device utilized the home cell site, I'll call it, the femtocell, the one that's stationed at the house, for this incoming call. At 7:45, Mr. Troconis' device utilized this tower and sector up here, facing away, obviously, up in Avon. There was an outgoing call placed for nearly 1,000 seconds. At 8:02, Mr. Troconis' device utilized this tower and sector here back closer to the house. This would be consistent with Mr. Troconis' device traveling back south towards the residence between 7:45 and 8:02. At 8:38, and again at 8:41, Mr. Troconis' device used the home cell site. There were outgoing calls at that time. This would be consistent with her device now being at home at 8:38. However, prior to that, at 8:26, there was an incoming call.
Wait, hold on. Hold on. I want to... Hold on.
Miss-
Let's go back just a minute.
Obviously, station. Of course.
The...
Agent Hoyland, could you just indicate to the jury what we're seeing?
Okay, the first slide that they showed was from the night before. Oh, I love data. Give me all the data. That was the night before, and it was whatever 7 something until midnight, and the or 12:59 a.m. or something like that, and it was showing that their towers were consistent with them being like at home. So now this is the next morning, 7:16 a.m. till 8:41 a.m. So this is, some of this is going to be important because this is going to corroborate some of the stuff, but I want to see if there's any new stuff in here too. This is what they were doing on the day of the disappearance. Now we are to the 24th. This is that morning.
In this slide?
Of course. So the next morning, beginning at 7:16, Mr. Dulos' device utilized the home cell site, I'll call it, the femto cell, the one that's stationed at the house, for this incoming call.
So that's Fotis' phone at home.
At 7:45, Mr. Troconis' device utilized this tower and sector up here, facing away, obviously, up in Avon. There was an outgoing call placed for nearly 1,000 seconds.
7:45.
At 8:02,
Michelle's in Avon.
Mr. Troconis' device utilized this tower and sector here, back closer to the house. This would be consistent with Mr. Troconis' device traveling back south towards the residence between 7:45 and 8:02. At 8:38, and again at 8:41, Mr. Troconis' device used the home cell site. There were outgoing calls at that time. This would be consistent with her device now being at home at 8:38. However, prior to that, at 8:26, there was an incoming call to Mr. Dulos' device through that same home cell site. That call was an international call from a Greece number. That call was answered and lasted approximately 18 seconds.
That's the one from his friend in Greece.
So roughly, just to be clear, roughly 12 minutes after the call from Greece, Ms. Troconis' device utilized the home, what's the terminology?
Called the home cell site for
home cell
simplicity's
site?
sake?
Is that
Yes.
correct?
So the chronological would be 8:02, Ms. Troconis' device is using this tower and sector here, west of the house. Then at 8:26, there's the call from Greece that is answered. And then at 8:38, Ms. Troconis' device itself places an outgoing call through the home cell site.
Next slide, please. Agent Horn, can you tell us what your conclusions were with respect to this slide?
Sure. So starting down here again, CID 20123, the home cell site. Mr. Dulos' device has a litany of incoming calls that are not answered. That first one is at 8:02, and they continue until 12:17. The first call that is answered, or the first activity that shows user interaction, would be this outgoing call at 1:19 for Mr. Dulos' device. Also noted in here is another call from Greece at 10:33. Concurrently, Mr. Troconis' device leaves the area of the residence and utilizes this tower and sector up here. At 9:38, there's an outgoing call, and then at 10:04, there's an incoming call, both through the same tower and sector. By 11:52, her phone has returned to the house, places an outgoing call through that home cell site. Can't say, of course, where her phone was between 10:04 and 11:52. There was no activity to map out. But that is sort of the totality of what's going on here.
And Agent Horn, you'll forgive me because I have a hard time seeing the screen. Can you just indicate to the jury how many missed calls Mr. Dulos had after the Greece call?
Well, I'm going to object. I don't think that's within the scope of his testimony or his purview. His testimony has to do with cell towers, not how many were answered or not answered. That's not his field.
Well, there was testimony that there were a number of calls that went unanswered. That's already in evidence. And so counsel is asking how many went unanswered, overruled.
We have, there was a total of 9 incoming calls that were unanswered.
And if we go back to the previous slide, was there additional unanswered calls between 7:16 and 8:41?
Yes, with Mr. Dulos' device, there was one unanswered call at 7:16, and then the call from Greece at 8:26.
Okay, so from 7:16 a.m. until 1:19 p.m., the only phone call that was answered or where there's user activity is this call from Greece. Is that correct?
I believe the 119 is an outgoing call, but yes, prior to that, there was a total of 10 incoming calls that were not answered. One answered call at 8:26 from Greece.
Okay, and I think we can jump ahead 2 slides, actually. Agent Holm, with respect to this particular slide, can you just indicate to the jury what your conclusions were?
Sure. At 1:53, Mr. Troconis' device received an incoming call from Mr. Dulos, and she had utilized the home cell site, as shown here. Mr. Dulos' device utilized this tower and sector up here near Avon to place that outgoing call. This would be consistent with the 2 devices not being together, not being at the home at that time.
Next slide. With respect to this slide, 3:16 to 5:16 p.m., can you just indicate to the jury what your conclusions are?
Of course. So we're still on May 24th. Here at 3:16, Mr. Dulos' device placed an outgoing call to Mr. Troconis. Ms. Troconis received that call through this tower and sector here. All right. Mr. Dulos then placed another outgoing call to Mr. Troconis at 3:35. Mr. Troconis' device received that phone call through the tower, the home cell site that we're calling it. There was some additional activity with Mr. Dulos' device as well as Mr. Troconis' device off of this tower and sector at 3:39. Mr. Troconis used it at 3:57. At 4:06, Mr. Troconis' device now utilized this tower and sector down here to receive a text message before subsequently returning eventually to the residence at 5:16 when she received an incoming call from Mr. Dulos again. Mr. Dulos' device, interestingly enough, at 4:48 and 5:06, utilized the home cell site before returning up and using this particular tower and sector at 5:16.
So, sorry, go ahead.
I was going to say, all told, a lot of activity. It's a little bit of a busy slide. But there was 4 total calls between Mr. Troconis and Mr. Dulos at 3:16, 3:35, 3:57, and 5:16.
And Agent Hoyland, I wanted to ask you, I want you to assume, with respect to CIDs 51149-16 and 51149-9, I want you to assume that when Mr. Dulos' user activity occurred, that he was at 80 Mountain Spring Road for a moment. How would he be hitting off that tower all the way at the top of the slide?
Yes, so as I mentioned earlier, the phone doesn't always use the closest tower. It's going to use the tower it sees as best. One way to think about that is here. We have, imagine we're standing in an office building or in a courtroom or at a window. We have direct line of sight to that cell tower that was on top of that roof that I'd mentioned before. Now, let's say my phone sees that cell tower or cell site. Now, on the other side of the building, maybe only a block or 2 away, my phone sees another cell site. My phone would likely choose that one, even though it's a little bit farther away, because it has clear line of sight. There's no obstructions. The radio frequency from my phone doesn't have to go through the concrete and rebar and rest of this courtroom and courthouse to reach the tower that's a little bit closer. So in your situation, here's the residence. There are some cell sites that are a little bit closer. This I know because I looked. It's a very densely wooded area. Where this particular cell tower sits, there happens to be a ravine that sort of crisscrosses down towards the residence. When you have densely wooded area, obviously woods and trees can't grow in water, right? So what it ends up doing is it creates a funnel where radio frequency could just sort of travel right down that path. If the phones were down here and still using this cell site, that is what I believe would have happened. Unfortunately, it is too long ago to go back and do any further testing to confirm the actual coverage areas of these particular towers.
Understood. Next slide. All right, this is activity from 3:16 to 3:35. Can you just tell the jury what we're looking at here?
Sure. This is just a pared down version of the slide before. I'm just focusing on the 2 calls that I had mentioned. So at 3:16, Mr. Dulos placed an outgoing call that Mr. Troconis' device received through this tower and sector here. And then at 3:35, his device placed another call, which Mr. Troconis received at 3:35 at the home cell site.
And just with respect to, this information doesn't always, this information doesn't tell us exactly where a phone is that correct?
Correct. It's not a pinpoint precision, the phone is on this street corner kind of thing. We know that the phone had to see the particular towers and sectors shown as best as to wherever they were on the earth.
But what's the significance of the home cell site with relation to where a phone would be?
Well, as mentioned, the home cell site's unique because the femtocell, or the device that the phone would connect to at home, is designed to provide all the coverage to the residence. Think of it as like Wi-Fi. If you go too far out into your yard, you might lose Wi-Fi connectivity. The same applies for a femtocell. Additionally, femtocell, you have to have phones whitelisted to use that. That means that the device, you have to tell the device that this phone, this phone, and this phone can use this particular cell site. No other phones can. So,
that's important.
Given those 2 things, when the phone is using the 20123s, that tells me that it is most likely at the residence.
I get so
All right,
excited.
and this is activity summary 5/24/19, 7:47 to 8:27. Can you indicate for the jury what we're looking at here?
Of course. So as you can see later in the evening on May 24th, Mr. Dulos' device travels away from the residence and utilizes this particular tower and sector here at 747. This is in the vicinity of Albany Avenue there in Hartford. He makes an outgoing call to Mr. McElwain, is my understanding. At 8:15 and at 8:26, Mr. Troconis' device received incoming calls through the home cell site, putting, again, the device home at that moment. And then at 8:27, Mr. Dulos' device placed an outgoing call through the home cell site. That tells us at some point between 7:47 and 8:27, Mr. Dulos' device traveled from the Hartford area back to the residence.
Next slide. All right, and now we're jumping ahead to May 29, 2019, 8:39 a.m. to 9:13 a.m., and then 2:20 p.m. is the slide. Could you just indicate for the jury what we're looking at here?
I have to. So on this morning at 8:39, Mr. Troconis' device received, again, an incoming call through the home cell site.
Okay, so now we're 8:29. Okay, so this is now 8:29. I don't know where the heck I got 8:29. I'm trying to skip us all the way ahead to dang August. We are now 5 29. So this is the car wash day that we're looking at.
Roughly 18 minutes later, her device utilized this tower and sector here for an incoming call.
What happened to the sound?
This morning at 8:39, Mr. Troconis' device received again an incoming.
Oh my lord, what happened?
May 29, 2019, 8:39 a.m. to 9:13 a.m.
I'm gonna cry.
All right, and now we're jumping ahead to.
Stop working. Y'all can hear it? Why can't I hear it? Share.
May 29, 2019, 8:39 a.m. to 9:13 a.m. and then 2:20 p.m. is the slide. Could you just indicate for the jury what we're looking at here?
I have to. So on this morning at 8:39, Mr. Troconis' device received again an incoming call through the home cell site. Roughly 18 minutes later, her device utilized this tower and sector here for an incoming call, before then utilizing this cell site up here adjacent to the Russian Speeder car wash. That was for an outgoing call at 9:12, and then followed by an incoming call at 9:13. Both of those numbers were with, both of those calls were with a number 203-918-4877, which was provided to me as another phone number for Mr. Dulos. Now, jumping forward in the day, we pick back up at 2:20. Ms. Troconis' device utilizes that same tower and different sector at 2:20 for an incoming text message, consistent with her device being back up in the area of the Russell Speeder car wash.
And I want to direct your attention to between 9:13 and 2:20, specifically approximately 1:40 in the afternoon. Did Mr. Troconis' device receive a phone call that's not reflected on this slide?
That's correct. So Mr. Troconis' device had received a phone call from a number associated with the Russell Speeder car wash. The cell site and location of that was not relevant to my analysis at the time and was not included on here, but the call itself stated exactly this.
Next slide. Okay. Thank you, Agent Horn. You can have a seat. Thank you. If I just have a moment, Judge.
Oh, I love the data.
Nothing further, Judge.
Thank you.
May I just return the exhibits?
Yes.
Or actually, if you want to hang on to that, I suppose.
Why do I feel like I'm about to get annoyed? Don't argue with the data, Shoehorn.
Use the paper exhibit, so excuse me for that. Oh, do you have?
Sorry.
I thought it was just returned, so I didn't
realize
realize
you meant this one.
Thank you. I'm going to use the Elmo to ask you some questions about that. Good afternoon, sir.
Good afternoon.
So, as I understand it, you were asked to plot certain cell tower activity based on 2 cell phones. Is that correct?
That's what my report reflects, yeah, the 2 phones.
You were told, or how did you determine that both of those phones were AT&T subscribers?
That information, the records provided by AT&T were given to me by the prosecution.
So one of the things that you said in your report, and I'm just going to point to it, on page, there's actually, the numbers are hard to read, but it looks like it's the 3rd page of this exhibit. And I'll just make it so that you can see it a little bit better.
Oh my gosh, I'm really not in the mood to listen to him.
The second bullet point on what I believe to be page 3, although it's cut off on the paper copy, says that when powered on, mobile devices constantly scan their environment looking for the cell site which provides the strongest, clearest, and overall best signal. That's what you testified to, correct?
That is correct.
And the next sentence says, this signal generally comes from the cell tower / cell site that is closest to the mobile device, or the tower with the best line of sight. You wrote that, right?
I did, yes.
So that's an alternative, right? It's a disjunctive, correct? It's either this site that is closest to the mobile device or the tower with the best line of sight is what you wrote here, correct?
Those would be the most likely towers that the phone would see as best. Yes.
Towers, plural, correct?
Tower that the phone would see as best? There's only one tower that the phone would see as best.
Right, but in terms of where it's choosing, I mean, I'm using a word like choice, but where the phone decides, if you will, to connect, it's either the closest or it's the one with the best line of sight, correct?
No, that's not only the two options. I believe I said the signal generally comes from the cell tower cell site that is closest or the one with the best line of sight.
So generally, it's one of those two.
Generally, yes.
Sometimes it might be the same location, correct?
The tower that it sees as best is the one with the best line of sight?
Yeah.
Yep.
Okay. Now, did you actually go to any of these tower locations?
Okay, pause. You know what? Remember when Melly's attorney, what was her name? I blocked it out because she annoyed me. Remember when she was going over, like, trying to do the cross-examination on the cell tower information, and she kept getting it wrong, and she was like, so you're saying this, and he was like, no, that's not what I said. That's the vibes I'm getting already with this.
Locations in the Farmington Valley of Connecticut.
I had no need to.
Did you look at a topography map of the area?
I did, actually.
Is that one of the items that was shown to you when it was put up on the screen a minute ago?
A topography map is not included
You
in
didn't
my
use a
report.
topography map to create this report, did you?
The visualization of the records as shown in my map was done by software, where we reach out to Google Maps and pull map tiles. I, as part of my typical process, go and look on Google Earth to look at the topography, look at the area where the cell towers are located to generally understand what's going on. Is it an urban area? Is it a rural area? Those factors potentially could impact my opinion as to the general location of a device.
Incidentally, did you also look at any of the applications by the phone companies regarding their towers and what area they sought to cover through any of the ones that you just testified about?
Their applications where?
To build them.
No.
You're aware that that's public source information, correct?
It's available on the FCC website.
And sometimes within a state as well, correct?
There is probably some sort of state licensing authority.
And are you trained to actually be able to read the technical details of the towers and their azimuth angle and all that stuff that comes from engineering?
I feel like I can read most of it, yes.
Okay. And do you have a background in engineering?
I do not.
What is your educational background, by the way?
I have an undergraduate degree in finance, a master's, MBA, as well as a CPA license.
Okay. And do any of those degrees require a background in engineering in order to complete those degrees?
They do not.
That's a stupid question.
I want to ask you specifically, and I'm just going to, if I may. There's pictures of the things. I'm going to mark this for ID.
Look, she's still got it up over here.
I'm going to ask you specifically about the tower that you refer to in your report, as you called it, the home, I don't want to use the incorrect terminology, home cell site?
not a tower.
Generically, I refer to it as the home cell site for simplicity's sake.
And you use that term because it's you testified it's the closest to the home itself?
No.
Well, yes, because the latitude and longitude for that particular device.
Okay, that home cell site that he's talking about, remember the part about, I don't even know where he's going with this, but I have a feeling I'm going to get annoyed. But remember he said that that's only, that's used to give, like in the home or whatever, he said that you have certain cell phones that can connect to it and the rest can't or whatever. So I have a feeling that he's going to have a hard time understanding that part.
Place the device at the residence. It was a femtocell, as I mentioned, a cell signal extender for the home.
Cell signal
And the one you're referring to as the home cell tower is the one that's marked as CID 25802 in your report? Is that correct?
That'd be incorrect. It would be the CID 20123 to the right.
The one to the right. And which one does this specifically go to in the diagram?
So that particular CID or cell ID refers to the green circle that's at the residence. As
That's,
it's a
that's the address, that's the home.
correct, and that's the latitude and longitude for that particular home cell site that was provided by AT&T.
And when you say it's a cell site, could you explain again when your home becomes a cell site? Does that mean there's a tower on the roof like you pointed out the window at that apartment building out there, or something different?
No, something different. So it's a small device that you
already
would
explained this.
buy and install by plugging in and connecting to your internet.
Literally
It
already
allows your signal to get boosted, in this particular case for AT&T, within the home so that you have better reception with your AT&T phone. To install it, you need to obviously power it on, have it near a window so it can take a GPS measurement of where it's physically located, and then you're ready to go with it.
So would it be fair to say it's like a booster to your cell site in case you're in a difficult area?
Yes.
That's a yes? Yeah. Now, you're also familiar with Wi-Fi connection, somebody's cell phone connecting by Wi-Fi, correct?
Yes, I am.
Now, if they have Wi-Fi and internet, would the phone connect to the home cell site or to a cell tower or to neither?
Can you ask that?
If they were using their phone using Wi-Fi signal from their home, would that phone also connect to either the home cell site or an external tower?
So if your phone was at home and you had your Wi-Fi turned on, but you were not in airplane mode, so you still had cellular connectivity with your device, depending on what you're doing with the device, it would either route over Wi-Fi or through the home cell site.
And if it routes through the Wi-Fi, it would not show up on your diagram, correct?
Correct. If it was a Wi-Fi call, there would be no cell site associated with it in the records. If we look at AT&T records, in many instances, Wi-Fi calling is in fact shown, but again, no cell site is shown with it. So I wouldn't be able to map that out.
All right. Now, with regard to the tower that you referred to as CIT D25802, this one over here, did you look at any information about that tower? And where it was specifically where it was located?
Yes, it appears to be co-located with a Verizon cell site as well.
When you say co, that means it's a Verizon and AT&T site?
Yes, the physical pole itself has antennas for both AT&T as well as Verizon.
And did you look at any of the details for the construction and reasons given for the need for that particular tower?
No, because it wouldn't impact my analysis.
Well, you did indicate, did you not, in your report? Again, I'll go back to page 3 for a minute.
No. Lord of mercy. Hi, pretty girl. Hi.
And I'm just going to refer you down at the bottom of your report after it says cell sites and sectors. The second to last bullet point states that the location of a cell site is often determined by sales marketing capacity, improvement of coverage, or expansion growth of a service provider. And then you go on to say something about overlapping coverage in urban areas and less in rural. But let me just ask you about that first sentence. Right? Have you ever read an application by any of the major cell companies about the need to put a tower and what they're trying to cover with that particular site?
I have definitely read applications for cell tower placement. I can't recall if it included the reasoning behind it, but again, it wouldn't impact my analysis at all.
Well, let me ask you a question. In your experience, doesn't the cell company have to justify their need for yet another cell tower in an area that has that?
Judge, I'm just going to object at this point to relevance.
Well, the issue at this point is, as the court understands the questions, have you ever read the applications? Response was yes. The witness has read applications. Have you ever read applications and essentially considered the reasoning for cell tower placement that may or may not be contained in the application?
Happy anniversary.
Relevance to the issues in this case.
Well, it was a preliminary to the next question, which I will refer directly to the report, but I would just ask if he ever has, if I may have a little bit of leeway with regard to that.
Well, the leeway is really a 2-lane road, not 4, because the reason for the application seems beyond relevance, but the court will allow the question.
Beyond relevant.
Did you ever look to see whether any of these towers were, as you note in the last bullet point on that page, that antennas on cell sites have a downward tilt and are pointed towards the earth? Did you check to see if that was the case in any of the cell tower locations that you put on your map?
I didn't need to check that because that's the standard. Their towers have to be, the antennas have to be pointed down towards the earth. There has to be down tilt. If the antennas were pointed straight out, radio frequency would just continue forever and shoot over the top of all of the customers that are down on the ground. So every cell tower has slight down tilt.
Okay. Well, you had indicated that the newer towers can be just on something like a telephone pole or even something shorter than that or lower than that. What I'm trying to indicate is it obviously can't point too straight down or it'll only cover the area around that phone pole, correct?
That would be correct, if it was pointed straight down. Yep.
So as I understand cell towers, radio frequencies sort of travel out, not in a straight line, but sort of like in a cloud-like direction, like waves that go out from a source location?
So radio frequency itself is a wave. That it operates in a wave similar to any other type of frequency. The sector itself is designed to, yes, propagate out the signal, all 120 degrees as shown. Radio frequency does travel in a straight line though, even though it's a wave. So when it hits something, it bounces off. It can have refraction, reflection, etc. But it's not the radio frequency itself is not sort of like a spaghetti noodle, just making its way through the air. It's a straight line.
Straight line, but in a downward direction, correct?
Yes.
Now you, I'm going to just mark this for identification.
What's he even doing? I'm trying so hard not to be annoyed. I know he's doing his job.
You indicated that as part of your analysis, you look at Google Earth topography.
Mm-hmm.
That's a yes?
Yes, sorry.
And did you look at it for the particular towers that we're dealing with here?
I did, yes.
Did or did not?
I did, yes.
So are you aware that the home cell site is on top of a mountain? Are you aware of that?
The home cell site, the latitude and longitude for that was on top of the house.
Is what?
The latitude and longitude provided for that home cell site, the femtocell, corresponded with the house.
And were you aware that the house is on the top of a mountain?
No, I was not.
We're aware that the mountain is surrounded by valleys on both sides of that house.
When I looked at the house on Google Earth, it looked like a very nice property that had a lot of space between its neighbors. I didn't look at the altitude of the residence relative to the areas around it.
You also noted on the last paragraph of your report that antenna arrays are fine-tuned to provide a specific area of coverage, correct?
That is correct.
And that is something that, again, that would be in the application, publicly available information about the purpose and the area of coverage that the provider wants, correct?
I imagine so, yeah.
I'm sorry?
I would imagine it would be, yeah.
Incidentally, if there is a home cell site, as there was on 4 Jefferson Crossing, if a person was in the home, would it necessarily attach to that site unless, as I asked before, the person using their phone was attached to the Wi-Fi?
Well, again, it would depend on what the settings and configurations were with the phone at that time relative to whether or not it was in airplane mode and what activity was being conducted on the phone. So historically, phones would utilize Wi-Fi when surfing, using high resource intensive activities like surfing the web, internet, data session type activities, and then fall back to the cellular network for phone calls. Now, if Wi-Fi enabled calling was active on the phone, then the phone could use Wi-Fi to place calls, receive calls, etc.
In fact, I'm going to just be clear about one thing. You did indicate that line of sight was one of the, or best line of sight is one of the algorithms, if you will, that the cell device looks for. I'm using the wrong terminology, but it's trying to attach by line of sight, correct?
Yes, line of sight is an important variable or factor that could impact the phone's decision as to which tower and sector it sees as best.
Right. And when you talk about best line of sight in your report on page 3, I mean, I'm using your words here, right? We literally mean line of sight, a visual, that there's no obstruction that would make it difficult for the signal to pass through, correct?
The traditional definition of line of sight would be that. We have clear line of sight to that cell site up there on top of that roof. There's nothing between us and that cell site.
So that, we'll use that as an example. So we see that tower, there's glass here, but if whichever company owned that tower, there would be a direct line of sight standing in this courtroom or sitting in this courtroom towards that tower, and if that is on your subscriber's, it's one of your subscribers' company's devices, it would maybe attach to that tower, correct?
Yeah, and if we were sitting here as my analogy before mentioned, if that tower and sector provided the best service and has clear line of sight, your phone would choose that potentially over one that's a little bit closer. That might be on the other side of the courthouse because the radio frequency from your phone doesn't have to travel through the rest of the courthouse, right? It doesn't have to go through the concrete and rebar. We have clear line of sight. Windows is not going to impact the radio frequency from your phone.
So going back now to, and again, this page of the exhibit is cut off, but it looks like this is probably a 9. Because the next page looks like it's probably a 10. You see where I'm pointing, right?
I had it before. Yep.
That's 10, even though the copy it doesn't show it. And then 9 is page before. So again, if I'm referring to this particular tower, which you indicated is 25802, correct?
That is correct.
You're aware that this particular tower is on a farm in the valley that you mentioned the river in, correct?
Correct.
And are you aware that just on the other side of this river, there's a 600-foot cliff?
I was not.
That would affect line of sight towards 4 Jefferson Crossing, wouldn't it?
It could, yes.
I'm going to show you some, and I'll show it to you unless. To these? Yeah.
Like what? Okay, what's the point of this? We.
I'm going to show the witness some images that I'm not going to yet show to the jury, so I want to make sure that we've turned that down. And I just want to make sure if I put this into my machine, this is Exhibit GG for identification, that it doesn't show up.
I'm trying so hard not to be annoyed with him.
By the way, did your report, which has been entered into evidence, Exhibit 145, include coordinates, GPS coordinates of where these sites were and whatnot?
The sites themselves?
Yeah. The actual maps that you included in your report, do they include GPS coordinates?
The dots themselves were generated off of the GPS provided by AT&T.
All right, so I'm going to ask you if you would just look. I'm going to just make sure the main screen is off. It's off. Do you recognize this to be? A Google Earth topography map?
It's showing no signal on my screen here.
Can you see it okay on your screen?
No, it's showing no signal. It's a blue screen.
It's showing no signal. Oh, can you see it okay?
Press
No.
to allow the small screen to.
Yes, I am.
And do you agree that it encompasses some of the same area that's in the diagrams in your report that we've just all seen?
It does.
And down at the bottom, you see there is a topography elevation profile that's included from a spot along the road up to 4 Jefferson Crossing. You see that?
I do.
And assuming, for purposes of your testimony, that the distance from the tower, which is 189 feet, to 4 Jefferson Crossing, which is at an elevation of a gain of 731 feet, that would affect the ability of a tower in the valley to reach 4 Jefferson Crossing, wouldn't it?
I would expect that is just to orient myself, is the blue line, the left side of that blue line, where that tower was that we were just discussing?
Well, do you want to compare it to your diagram?
Yeah, I think it should come from the witness and not counsel, Judge.
Well, if the witness had a question. However, counsel shouldn't answer the question.
Right.
Counsel should just give the witness his map
Right.
so that he can orient it to the ID exhibit.
All right, thank you. Yes, so do you mind repeating your question again?
Yes. Assuming that the pinpoint of the blue line that you asked is the location of the tower to Jefferson Crossing, and assuming also you're familiar with the elevation profile of Google Earth, would the fact that the tower elevation of 189 feet up to a total of gain of 731 feet to 4 Jefferson Crossing affect the ability of that tower to reach the location of 4 Jefferson Crossing?
Judge, please support. The question is vague. There's multiple towers. I'm not sure which one counsel is referring to.
It's one I had shown him. I can't do both at the same time. We talked about the exact same tower that he's now looking at his map on.
Could you just identify it for the record?
Well, the question is, the ability of a certain tower, well, it wouldn't be the tower itself, the ability of the signal, the court understands the question to involve, to reach 4 Jefferson Crossing at that elevation if the tower is at 170-something feet, and the 4 Jefferson Crossing elevation is around 700 and something feet. That's how the court understands the question.
Yes, Your Honor. Can you answer that?
So in this situation, I would say that it's hard to say. I can't say for certain one way or another. I think that the tower that is at 100 and whatever feet, I don't recall how tall the tower was, but it wasn't a small little light pole one. But additionally, when radio frequency, it propagates, it travels out, it bounces off of things. It can sort of essentially walk its way up a side of a mountain. I've seen it when I was in Colorado many, many different times at a much greater elevation than called 600 feet. Without further tools, and obviously we can't go back in time at this point, I can't say one way or another.
So let me ask you a different question. Didn't you just testify a few minutes ago that cell towers aim downward?
They do.
So now you're saying
Judge,
that they crawl up the side of a mountain?
Objection.
Oh my God.
If I may. We still haven't identified the tower number.
I'm sorry,
Well,
for the record, I didn't do that.
The difficulty is that the jury cannot see the ID exhibit.
Right, I have a couple other pictures I'm going to show, but I'll for the record indicate we're talking about CID 25802 is the cell tower at issue. All right. I'm going to show you a couple of other images, if I may. So were you aware, for example, just from your review, that this particular cell tower is on a farm in Farmington on Town Farm Road?
I looked at the tower. I didn't know if it was a farm, but it was behind a structure off of the road.
Well, I'm showing you an image which is on my exhibit for ID GG. It's just counted as 1114 JPEG. Right? Does that refresh your recollection that the tower was disguised as a tree on a farm next to a farm?
Disguised as a tree, yes. This angle is different than the one I remember looking at. I was looking at it down the driveway with the tree in the back.
But you remember that you're saying you looked at Google Street View?
Correct.
Okay. So you recall, though, that the tower you did look at was actually a pole with fake pine needles on it, right?
Yep.
So even though it's a different angle than this picture, this fairly naturally represents the way the tower looked next to the farm.
Yes.
And I'm just going to show you, if you used Google Maps, Street View, showing you first image 1113, do you recall this is what's across the street from the cell tower?
Well, Judge, I'm going to object to counsel testifying. He should ask the witness a question.
Cross-examination.
Right, well, the court is cognizant of different styles. Some lawyers don't ask a question, they just make a statement and expect the witness to answer. Other lawyers use a leading question with a question. The court has allowed latitude for both. So you can ask the leading question, counsel, but the court has accepted your style as a different style.
I either say thank you or I don't know. But I don't know if that's the question.
The objection's overruled.
Oh, okay. So if I just zoom in, right, you recall that there's almost a sheer cliff between where the cell tower is and Avon Mountain. You want me to zoom in closer? Did you see that when you were using the Google Street View?
I did not turn away from the tower to look at the eastern direction.
But you don't dispute that this is, in fact, the area directly across the street from where that farm and the cell tower.
I'm taking you at your word. I never looked at it. I don't know.
Well, right now, we're going to take our afternoon recess until 4:15. Ladies and gentlemen, please do not discuss the case.
We've got an hour left. Well, less than that, I guess, since they're doing a break. So we can finish this day if you want to. And then just do the next day. Look at Panda Lucy. Panda Lucy! You're so precious. You're so precious. You're a cute little panda. She's like, why do you have me dressed up? We'll just finish it. We're almost done. And then that way we can do...
That was just about.
You want me to take your panda out?
Mr. Blake, please.
Yes, Judge.
Thank you.
So I understand that I'm just going to indicate that during the break, the state has withdrawn any concern, so I'm offering GG as a full exhibit.
I have no objection.
Defense GG admitted as full.
So now it'll be So I'm going to go back, Agent Whalen, to the Google Earth diagram that I had showed you earlier. You indicated you recognize. Oh, that's the one I have. Sorry.
Yep, it's still on the screen.
Okay, great. All right, so earlier I had asked you about Google Earth and that it also has the topography feature. And you talked about the blue line, which is the location where that particular cell tower, which we identified as, I think CID 25802 is located, correct?
That sounds correct, yes.
And that following the topography, the elevation gain was 731 feet, correct?
Yeah, I don't know how that's calculated. It looks like it's 189 on the left side from where the dot is to.
189 is the height of the tower, correct?
Is that what you obtained? It looks like 189 is the marker where the blue dot, the left side of that blue line would start at 189 and then grow up to roughly 700, just over 677 on the right side at 4 Jefferson Crossing.
Okay.
But semantics.
And you did talk about you were asked a question about the tower that it was up somewhere in Avon on 44, and you indicated that oftentimes the signal will travel through a river valley, an open area between trees. You indicated as a likelihood for a signal to travel farther, correct?
Judge, I'm just going to object to misstates the testimony. I didn't ask about Route 44.
Well, there was testimony concerning travel through trees. And there was testimony concerning obstructions for signal. So the court is going to allow this testimony overruled.
In my experience, when they are either natural, natural made, types of structures, or valleys, gullies, or a river where there's dense woods on either side and there's a cell tower at one end of that river, then it creates essentially like a funnel, right? It's just like imagine like a skateboard kind of ramp, right? The radio frequency would travel down that path because the obstructions are on the right and left side of it. It's not in the river.
So the point being, though, that depending on topography, where the person or the cell phone is or cell device is in relation to the tower depends on the topography at the airport, correct?
It does, yes.
So I'm going to just show you that you had previously identified, I call it image 114. And the jury is asking, you recall that having looked at these images on Google Street View, you observed this farm, correct?
Correct.
And would you just identify for the jury what exactly is the cell tower in this picture?
Sure, may I? Yes. Thank you, Your Honor. So in this particular instance, it is the fake tree. In certain communities, they only will allow companies to build cell towers if they help them hide within their natural environments. In this case, it's a fake pine tree.
And if I zoom in a little, are you able to identify some of the actual antenna within the fake tree branches to demonstrate that that's what this is?
Yes. From this view, it appears this is an antenna. That might be an antenna. Looks like there's another row of antennas on that level, and even possibly maybe a third row in the fake tree.
Okay. So also during the break, you had an opportunity to look at what was across the street from this tower, correct?
Yes, you showed me the Google Street View.
Right, and this is the view from across from the farm, is that right?
It is.
And when I refer to the mountain, we were talking about this large natural landscape with a couple of houses up at the top, correct?
Yes.
And I believe you would agree that if this is something like 600 or 700 feet, and the tower's at 190, whatever the number was, 195 feet, and it's pointed, the antennas are pointed downward, that it would be difficult for that tower to connect to a cell phone that was located at that moment at 4 Jefferson Crossing, right?
Based on the topography, it looks like Jefferson Crossing is just over the apex.
It's on the other side facing the Hartford direction, which would be the opposite
Well,
side.
I'm going to object, Judge. Counsel's testifying.
Well, we put in that drone video, Your Honor, so I'll rephrase the question. I will. Assuming that the house actually is on the other side, certainly on the other side of the street at the top of that mountain, and it's facing towards either the University of Connecticut Health Center in the direction of West Hartford on this western side of Avon Mountain, would it not be very difficult, if not impossible, for that cell tower to connect to a cell device that was located inside 4 Jefferson Crossing?
Based on the topography shown from that Google Earth, I would agree with that statement. Okay. I think that the way the cell tower works, obviously it's down tilted, right? So the radio frequency comes off that tower and eventually will hit the ground. When it hits the ground, it'll bounce back up. Depending on the angle, it'll start to fill in the gap on that mountain. Remember I mentioned it's sort of like climbing up the mountain? That's what I mean by that. It's purely a physics geometry thing. However, once you get to the apex or the top of that mountain, there's nothing to stop the radio frequency. Would continue on forever. So if something was on the other side of the top, I would find it extremely difficult that cell tower would provide coverage to that house, let alone the best coverage for the phone.
Okay. So all of this is to, and there's one more picture I'm just going to show you. This has been marked as 115, and this is just another view from just south of that cell tower and the farm. Again, you agree that this is a rather steep cliff on the mountain, correct?
It appears to be to have some good height to it, yes. A couple hundred feet, for sure.
Now, assuming, again, just for my question, that as the mountain goes south towards the right of this image, it gets lower down, is it more likely, that is, that the mountain is not as steep, that a cell tower located at Town Farm Road, the one I showed you at the farm, could reach down this valley even further than where the tower is?
I'm sorry, you're going to have to repeat the question because I got lost a little bit.
I'm sorry, I'm not.
Is there a picture maybe you could use?
If we go back to your, do you have your report still there?
I do not.
You do not. I think maybe this clerk has it. And I'm not going to put it up again, but if I turn, let's say, to page 10, show you, may I approach your honor?
Yes.
Page 10.
Thank you.
If the tower, as we indicated, is located CID 25802, could it travel south along that river valley further and to attach to cell phones that were even further away?
You mean like down in this area?
Yes.
I would think that would be plausible.
Okay. So as I understand then your testimony, the location of where a cell device attaches to a cell tower doesn't have to be the closest location, does it?
It does not, no.
And if there is an obstruction, whether it's a building or in this case a mountain, it could deflect that signal even further away, maybe miles away from where the cell tower site is, correct?
Well, if it reflected the signal continues on forever. It eventually ends up in space. So once it gets reflected, deflected, whatever, it would continue on whatever path it was on. But
so even in a valley, if it's pointing down the valley, if there's a mountain keeping it, shall we say, constrained on one side, it could continue down as long as there's no further obstruction, right?
yes.
I did a poll with the first ones I saw.
Incidentally, if a person is speaking on or using their cell device and it's attached to a particular tower as they move, the cell device will then attach to different devices along the route of travel, correct?
By different devices, do you mean different cell towers?
To different devices, different cell towers, correct?
Correct. So if you start a call and you drive down the highway, your call will get handed off as you travel along the highway. If those handoffs didn't occur, you'd have a drop call. So the network's designed to have slight overlap between towers so that your phone can seamlessly hand off from one tower to another as you travel.
Although there is probably data somewhere that would track each tower that would a person connects to, correct?
Yes, and that information is provided in the AT&T records.
But in AT&T records, if you start let's say a telephone call at point A, you travel through B, C, D, and E during that same call, it will only show the end location and not the interim location, cell tower, from the provider, correct?
That would be incorrect. So AT&T is the only carrier which does in fact show you all of the handoffs that a phone has during voice calls or data sessions, up to a maximum of 20.
But Verizon would, of course, not show that, correct?
Verizon and T-Mobile do not.
Judge, may we approach?
Well, is there an objection?
There is an objection. If I could just be heard at sidebar, Judge, I assure you.
Well, the court is aware of what the testimony is at this point, but the court does not see the relevance as to whether all of the interim antenna will pick up a call as a device travels.
Judge, I wanted to approach on a different issue if we could. I apologize. I would never interrupt counsel's examination like this, but it's important.
It's important. Oh, this is the drama. Oh, she's got it taken down now. Oh, messy mistress has got herself in some trouble.
So the last question really had to do with interim hits off of towers as a device moved. There was no objection as to relevance. So the court is going to allow the question.
I'm just going to conclude. This isn't the only report you prepared with regard to this case. Is that correct?
That's correct.
You prepared a separate report a month ago that included a third person, correct?
That is correct.
And that was the following tracking the travels or the travels of the phone belonging to a Kent Mowini, correct?
That is correct.
Now I would just mark this for identification. I'm just going to ask you if you recognize this, and then I'll show it to counsel.
Yes.
This is a report that you prepared?
That's correct.
And you prepared it in December?
Correct.
This past December?
Correct, yes.
I have no objection if counsel wants to introduce it.
What is the exhibit letter?
Double H, page 8.
Double H admitted as full.
I have no further questions.
The redirect.
I have nothing further, Judge.
Thank you. Mr. Hoyland, you may step down.
Thank you, Your Honor. Thank you.
Keep going. So far, Bubba Goat. Bubba's an AOR goat so far.
Ladies and gentlemen, that concludes the state's witnesses for this afternoon. The court has been informed that there will be testimony tomorrow, and it'll be a lot of video testimony. In other words, video of interviews. And we'll adjust the break schedule accordingly as those interviews take hours. So have a good evening, and please do not discuss the case. Please do not follow any media about the case. Have a good evening.
Bye, jury. Bye, jury. All right, hold on. Let me slow this down. I want to enjoy. Well, here we'll do 1.25. I can't do normal. Normal's too slow for me.
That Mr. Troconis appears to have a text from a sealed report on her monitor in a very high, big font. The beginning of it reads, "Dr. Krasner told me," in quotes, which the only reason why the state is reading that quotation, Your Honor, is that is the note. Now, the state brought this to the court's attention. This is also not the first time that we have heard that Mr. Troconis has been putting things on her laptop for other people to see. For instance, there's actually an article in the Stanford Advocate that during, I think, either Christine Roy's testimony or Kristen Medell's testimony, she had a article with a headline that Dr. Lee is held liable for impeaching or something to do with his testimony. The only implication there was an attempt to. It was related to the blood results in his testimony. The only implication to have that up is an attempt to either put that out in the press or for a witness to see. So this is the second time we've had a concern. We didn't address that first with the court because it was we didn't see it or hear anything. We actually read it in the Stanford Advocate. The concern the state has is this notion that she would have access on her device to a report that it starts off that a member of the audience is able to see, which is clearly under seal. So that is concerning. The second major point is that was displayed for the public with a news camera behind us, and that she shouldn't even have read it to begin with. So it is a huge concern at this point that I'm bringing to the court's attention. We can't gloss over the serious nature, the idea of a violation of her having access to the report, her displaying it for everybody to see, essentially. And three, also there was another instance where we're not sure if she or a member of her family was mouthing to the jury earlier in this trial. So now we're at a point where this has to be raised on the record. And I bring that to the court's attention to address in some way.
Oh, messy
Well,
mistress
does
acting
the
up.
state know who handed the state the note?
If I may just inquire, Your Honor, my inspector is back.
The court is not asking for an identification.
Yes, Your Honor.
So the first consideration by this court is to find out from the person who handed the state the note how that person was able to determine what was seen on the screen. So, of course, that's not going to be done on the record in this proceeding. But, in other words, how did this come to the state's attention? Who brought it to the state's attention? Did you want to be heard, Attorney Felsen?
Very briefly, I'm not sure which order to address things in. I will say it was my understanding that any video that was taken would not display our screen, so it would not be available to the public. We've taken great pains to work with people who are handling the cameras and the videos to ensure that all of our communications, whatever's on our monitors or on our desk, remains private and inaccessible to other people. As far as the report is concerned, I'm not sure how anybody in the audience would know the contents of what would be in a sealed report. I know that I have not reviewed the report in its entirety. I have never seen it on a computer. I have reviewed the last 4 or 5 pages that I was provided, and they were in paper form. I can say that I have never shared the contents of the report with Mr. Troconis. I do not know, in fact, whether she was reading from a memo or what it was. I don't intend to ask her and discuss it at this point in time. What I can say is I know there have been a lot of notes that have been passed back and forth with information that is now just being shared. If I had known that there was an issue with the public possibly viewing what was on our screens, I would have taken steps to ensure that that wouldn't happen, and I can do that from here on in.
Well, the court's first concern is, and the court understands that we are talking about the custody evaluation.
Yes, Your Honor. And the only reason, again, while I indicate that is I do believe the individual who saw it is a close friend of Jennifer's and would recognize a name that was on the report or on Mr. Troconis's computer.
Well, what the court has to task the State Attorney's Office with is to find out as much information as it can as to how, first of all, the individual recognized
I'll show it in a minute.
whatever was on the screen.
Yes, Your Honor.
How they were able to see it from their vantage point. Was it broadcast? Well, was it live streamed? And the court is just going to have to begin tomorrow's proceeding without the jury, because what is happening at this point is there appears to be, the court has issued a protective order and sealed that custody report. If that custody report is being disseminated, and if it's being disseminated essentially with the involvement of the defendant, then the court has to take certain action. Because then it's a violation of a court order, and there would have to be a contempt hearing. Stand in a recess until tomorrow at 10 o'clock.
Oh, she messy. Okay, let's get to the note passing.
No further instruction, right?
Yes.
Incidentally, if a person is speaking on or using their cell device and it's attached to a particular tower as they move, the AT&T records, if you start a, let's say, a telephone call.
Okay.
Drive down the highway, your
right.
call will get handed off.
We'll do normal speed for this. Okay, watch the bottom of the screen. Make sure I'm moved all the way up. Let me hide Lucy Cam. All right, watch the note get passed.
As you travel along the highway. If those handoffs didn't occur, you'd have a drop call. So the network's designed to have slight overlap between towers so that your phone can seamlessly hand off from one tower to another as you travel.
Although there is probably data somewhere that would track each tower that would a person connects to, correct?
Yes, and that information is provided in the AT&T records.
But in AT&T records, if you start let's say a telephone call at point A, you travel through B, C, D, and E during that same call, it will only show the end location and not the interim location, cell tower, from the provider, correct?
That would be incorrect. So AT&T is the only carrier which does in fact show you all of the handoffs that a phone has during voice calls or data sessions, up to a maximum of 20.
But Verizon would, of course, not show that, correct?
Verizon and T-Mobile do not.
So they got that note passed to him. They're sitting there trying to figure out what to do. She turned her microphone off and then told him
Judge, may we
whatever.
approach?
They talked about whatever, and then he wanted to approach.
Well, is there an objection?
There is an objection. If I could just be heard at sidebar, Judge, I assure you it is.
Well, the court is aware of what the testimony is at this point,
Okay, now she turns around.
but the court does not see the relevance
Somebody telling her.
as to
Oh, and then she shuts her.
whether all of the interim antenna will pick up a call as a device travels.
Judge, I wanted to approach on a different issue if we could. I apologize. I would never interrupt counsel's examination like this, but it's important.
Fine.
Said fine. Okay, and you saw as soon as all this happened, then she turned around, like she was turning around or whatever, and then you could see as soon as she did that, then they grabbed the laptop and now it's gone. Oh, she messy. Ooh. Messy, messy. Messy mistress. Ooh. She dirty. Marie Moss with our stats. 6 witnesses, 2 sidebars, 47 objections. He said right 34 times, 1 Vardar, and Walmart. Walmart enters the game. 21 days. And a contempt hearing will happen. Bam. Ooh. Ooh. Someone sent her a text. She turned around too. Did you see? You could tell she was getting. Look, she's on her phone. Get off your phone, you messy mistress. Nope. She's bad. She's so bad. Now I'm like ready to see it. We'll watch it tomorrow. She violated that court order. Ah! Okay. I'm not gonna cheat. I'm not gonna watch it without y'all. But I want to. We made it through. We're gonna watch today's testimony tomorrow. So I have not felt good this week. How long does it take them to address that part? Okay, hold on. Let's do a poll real quick. We'll end. Bubba Goat is apparently what's today? Day 23. All right, fine. Everybody says now. We'll watch it, and then we're going to finish for the day.
District of Stanford at Stanford for the transaction of criminal business is now open and in session. The Honorable Judge Randolph presiding. Good morning, Your Honor.
Good morning. Please be seated.
Oh, dang.
When we concluded the session yesterday, the court had been informed that there had been a possible disclosure of an evaluation report that the court ordered sealed yesterday. The court indicated that the state, who had indicated to the court that a note was passed to the state, would investigate to find out from whom the note came, how that person would know whether there was a violation of the court order to seal, and any other information that the court would, or rather the state could develop concerning the allegation yesterday. So the court will hear from the state.
Good morning, Your Honor. May it please the court. Judge, we were able to conduct an investigation in the evening hours last night, and we were able to speak with the witness who passed the note, Ms. Carrie Luff. She provided a written statement to our office late last night. Additionally, we were able to pull footage from YouTube, which corroborated Ms. Luff's statement. There were additional witnesses to what occurred as well from the state's attorney's office. I'll just indicate, Your Honor, that our investigation has revealed the following: that the defendant absolutely had the sealed report on her computer screen,
Messy.
that it was being displayed in violation of a court order, and that the defendant's mother attempted to prevent her from being discovered as having violated that order by tapping her on the shoulder and bringing it to her attention that we were about to address it with the court. And so that's what our investigation has revealed. Now, we were prepared to go forward this morning with the contempt hearing, if that was the court's pleasure. The court has indicated to us that it doesn't wish to take it up at this time due to the fact that we do have a jury that is waiting, and we are trying to get to a resolution of this case.
Not the mama,
But
too.
it is amazing that nearly 5 years after Jennifer Dulos' death, that this defendant still will not let her rest in peace.
Bam.
Judge, we're asking that the defendant's mother be ejected from the remainder of the proceedings. This is not the first time that we have brought an issue concerning the defendant's mother to the court's attention. Now, the first time we brought it up, we did it at sidebar. We indicated that we received information that the defendant's mother was mouthing to the jury. We indicated that we didn't wish to make a spectacle of it.
Get mama out.
Counsel assured us that they would speak with the mother.
Mama go.
And I know the court recalls that conversation. And now this is the second incident in which the defendant's mother has injected herself into the proceedings in a very inappropriate way. And I'll just indicate, I'm expecting some argument. Well, the Farber family blows kisses at people and makes hearts at people, things of this nature. First I'm hearing of it this morning. And we've spoken with them in the interim. But this is now a second strike for the defendant's mother. And I'm asking that the court eject her from the remainder of the proceedings. Her conduct is inappropriate.
Bam.
And the fact that she tried to prevent the defendant from getting caught by tapping her on the shoulder, and then the YouTube clip you'll see, the defendant immediately takes action with respect to her computer. So I don't make this request lightly, Judge. I have to say I've been practicing law for nearly 15 years, and this is the first time that I think I've ever made such a request. But this is beyond the pale, and I'm asking that the court do something about it, pending the contempt proceeding.
Bam.
Your Honor, Attorney McGinnis's comments reveal just how highly charged this trial has been and how much emotion there's been in the courtroom. We have taken steps to avoid and ignore any negative interaction and to try to focus on the evidence in this case and on ensuring that the evidence goes before the jury without any interruption. As Your Honor knows, we've talked repeatedly to the media to ensure that they were not able to pick up anything on our computer screens, anything that was on our table of evidentiary value. I have confirmed with them that, in fact, they have taken those steps. They've complied repeatedly and ensured that they've been in compliance with the court's orders. As far as if we are addressing today, Ms. Troconis' mother being in court, we did talk to her about the allegations last time. We did not note that she was making any inappropriate movements, gestures, signals in any way, and we have no evidence other than a statement from Jennifer Farber Dulos' friends and family that in fact occurred. I do not understand why the state is suggesting that any interaction that Ms. Troconis' mother had with her about putting something on her screen, taking something off of her screen, has to do with avoiding getting caught for something. That's just an inference that doesn't seem to be based on anything that I've heard so far. I know Your Honor is taking up those allegations at another time. However, what I will address right now is the fact that there have been other interruptions and disruptions and comments that have been made in the courtroom galley that we ignored and will continue to ignore. We don't feel the need to put anything on the record. We've addressed it with Your Honor in chambers. I don't know why that needed to be put on the record now, but rest assured, Your Honor, we've taken steps to speak to Michelle Troconis' family, to speak to Michelle, and ensure that there are no further disruptions. Her computer is not here today because I'm not going to be focusing on what somebody has or doesn't have on their computer. We need to listen to the evidence and ensure that what's supposed to come in before the jury comes in and what's supposed to stay out stays out.
Thank you. This court makes every effort to conduct proceedings in a fair and efficient and dignified manner. This court makes every effort to show counsel and the defendant respect. What the court is not going to countenance are competing pep rallies like you have in high school.
Oh.
The defendant supporters and the state supporters. This is not high school.
Ooh, tell him, Judge.
The court is not going to become a hallway monitor. So if there are efforts to communicate with a jury or a witness, you will be removed. No hearing, just removed. There will be no computer use other than by counsel in the courtroom. There will be no communication with the gallery at any time. There will be no attempts to show your approval or disapproval of a witness's testimony, or you will be removed.
Tell him, Judge. He's had
Court is not going to take up a formal contempt hearing today. The court will schedule a contempt hearing at the earliest after the defense rests. That's at the earliest. Are we ready to proceed?
Dang!
Yes, Judge, we have one witness, and then we have Detective Kimball, and we're going to be playing the third interview in its entirety. I believe it's 3 hours and 50 minutes. I gave another copy to the defense last.
Woo! So he's gonna do a contempt hearing, but he's not gonna do it until after the defense rests at the earliest. So he doesn't want to do the contempt hearing while the trial is still going on. Oh, he's like, this is not high school. Court is not gonna be a hall monitor. Woo! I love it when it gets spicy. Look, he used his dad voice and everything. I mean, no computer for her now. Maybe during verdict watch. I love this judge. I love him. I love him. You know, that mama sure does like to talk anyway. She did, you know, she's talking to reporters and stuff in the hallways, and she's telling them, you know, how, I can't remember what the statement was, but it was something about how the whole trial has pretty much been about Fotis, and that you know, Michelle didn't do it, and she's guilty, or she's not guilty, and she's, you know, they're just ready to put this all behind them and all this stuff. You know, her sister is also very vocal, you know, even talking to people on Twitter who are posting about her, you know, and they'll go on every show or news thing that'll listen and talk about how she's innocent. Which, I mean, I get it, that's your family, you know, but they've been very vocal, you know, trying to spread word that they don't, you know, that she's innocent and didn't do, you know, never done a thing wrong in her life. So, whatever. Who knows? Spicy. I'm glad we got caught up for most of it. So tomorrow, especially because tomorrow, since okay, we're gonna watch the rest of tomorrow's testimony. No, scratch that. We're gonna watch the rest of today's testimony tomorrow, and they're playing her third interview video, which is like, what did he just say, 3.5 hours or something? And those videos are hard to hear, so we have to listen to them in regular speed. We can't speed trial through that specific part. So I'm glad we got caught up today so that we can have a little bit more time to actually listen to that. So, interesting. It got crazy, y'all. It got crazy. This chapstick is so good, Kathy Davidson. So good. Okay, so tomorrow, let's figure out what time we want to do tomorrow. You want to say, what do we do? 10 Central last week, and that seemed to work pretty good, right? We'll plan that. We'll do 10 Central tomorrow. That seemed to work out pretty good, and actually it worked out better. I didn't think I was going to stream it all this week, But then I felt good today, and I was like, yeah, let's get some streaming done. Let's get some days in. Let's get caught up. So it actually worked out really good. But also, I was like, it's so late. It's only 5:40. Feels late. I'm reading a little bit of y'all's chat. We'll plan that. We'll plan 10 Central tomorrow, and we'll catch up on the rest of today's stuff. So, but I'm glad we did watch that little bit. I didn't want to have to wait. Yeah, it's a date tomorrow. All right, so 10 Central, 11 Eastern tomorrow. We will finish day 23. No court Monday, which is good because I wouldn't be able to do it Monday anyway. No court Monday. I think I know I haven't been on here much lately. I am trying to keep up. We're getting there though. We're getting through it. 3 weeks left. Look, I said 3 weeks left. That's 2. This is 2. I didn't come here to math. I meant 3. 3 weeks left of treatment, and then we'll go back to a regular schedule, hopefully. It'll all be good. Yes. See everyone in the morning. I'm reading a little bit of y'all's chat. I'm trying to see if there's anything else I missed. Yeah, no court Monday. Tomorrow, 10 Central, 11 Eastern. And we'll just finish out the day tomorrow, and then I guess no stream on Sunday. I appreciate y'all hanging out. Our mods, thank you. I appreciate everything. Y'all are the best. Yes. Y'all are awesome. Thank you so much. I appreciate it. I appreciate the support. And I was going to do a little video of the stuff, but we'll just do it tomorrow since we finished early anyway, because I'm really tired. I'm ready to lay down. So we'll do, I want to show the quilt. I got a handmade quilt, one for me and one for Lucy. And it's really cool. So I'll show y'all that tomorrow too. And then you've already seen the panda costume, but there's some stuff. So we'll show you that tomorrow too. It's kind of, I got some really cool stuff this week, and I really appreciate it. Y'all are the best. So, I guess that's all I got, y'all. I will see you tomorrow at 10 Central. I love you. Have a good Friday night.
I gotta go. I can't stick around here forever.
It was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel.
Goodbye, good people. Now, how the heck do I get out of here?